My lord, under compelling circumstances, my lord, may I be permitted to mention, my lord, without even uploading of the order, my lord, yesterday, when my wife had no right of visitation, by this honorable court, after going through mediation and everything, yesterday evening, my lord, she came with two male persons and just took away the son without his will, my lord. And now, my lord, as desired word has become, my lord, a curse to my son, and he is now under coercion. Yeah, because the son has called to his grandmother.
Ms. Bhattacharya, file a proper application. We will take it up.
My lord, your lordship has, my lord, not uploaded the order, my lord, till now. For that reason, I have come.
We have signed yesterday. Every order we sign every day.
My lord, can it be, my lord, put up to be mentioned tomorrow?
No. File an application. Call on this.
My lord, under a complete, my lord, extremely urgent matter, my lord.
Leave is granted.
My lord, yesterday I mentioned the matter. My lordship
Yes, we told you something. Yesterday
directed to serve notice to the other side.
Is it appearing in the list?
Is this appearing in the item 36 in the list?
Reach it.
My lord,
Wait,
kindly
we'll reach it.
fix the matter. If not taken up,
reach it, you are wasting time. Call on the list.
My lord.
My lord, mentioning. My lord,
11.
Accordingly, MAT number 107. Sorry, this is. Yes. In view of the above finding, FA 42 of 2024 is allowed on contest. They were setting aside the impugned judgment and decree dated such and such, passed in money suit number 70 of 2013 and dismissing the said suit. FAT 310 of 2023 is dismissed on contest, thereby affirming the judgment and decree whereby the counterclaim was dismissed, was turned down. Interim orders even stand vacated, no orders to cost, formal degrees drawn up, trial could record be sent down. So you have dismissed both. Their suit, your suit as well as their counter, and we have taken consideration into everything, whatever you tried to submit on that date. Don't worry on that. I am sorry, Mr. Nag. Accordingly, MAT 1072 of 2026 is allowed on contest, thereby restraining the respondent authorities from undertaking any demolition process and or eviction drive in respect of the residential quarters, dwelling units, and structures named as Calcutta Dock Labour Board, CDLB quarters, and Calcutta Port Trust quarters, located at Brook Lane, Garden Reach, Kolkata. Accordingly, WPA stands allowed to the above extent. However, nothing in this judgment shall preclude the respondent authorities from initiating due proceedings under sections 4 and 5 of the 1971 Act, insofar as the subject properties are concerned. Can is consequentially disposed of, interim orders stand vacated, no orders to pass. Cool. They were part. Yes. For it to ready up.
My lord. Item number 4, my lord. May Lakshmi kindly keep it at Mr. Bhattacharya, senior standing counsel, my lord, could not reach the court, my lord.
Written notes of arguments.
On the last topic,
Yes, my lord.
your lordship studied length.
Yes.
They have
Well,
said only that
notes of
that was submitted written notes, short.
Are you ready with it?
Yes.
Fine.
Well, Mr. Bhattacharya is carrying the written notes of argument, my lord. Kindly
Written
keep
notes
it
of arguments filed by the petitioners today be kept on record. Full on the prayer of learned counsel for the state, leave is granted to the state respondents to file the written notes of arguments during the course of the day. Hearing is concluded, the matter is reserved for judgment. Another written notes dile paঠিye debi. Thank you.
Item number 5.
None appears for the parties at the time of call. Let the matter go out of the list.
Item number 3.
My application, lord, very innocuous prayer.
I am for the appeal. Here the paper book has been filed.
Pardon?
The books are ready, served, and filed.
What is the prayer? Please have,
So the prayer here is, Lord, there was a correction with respect in the decree with respect to, Lord, the names of plaintiff number 3 and 4. I'm sorry, Lord, 4 and 5. Lord, my lord directed because the trial court records are already here, so my lord, someone can be called
Yes,
to the
yes.
trial court and it can be done here. Now, my lord, the difficulty is I am unable to proceed with the execution. There is no stay. And unable to proceed with the execution because the my lord, rectified certified copy of the decree and judgment is not available with the executing court. Lord, that's the predicament.
What can
But
we
I
do?
have made an application, Lord, if a copy of this certified copy of the corrected judgment and decree can be made over from this department, or Lord, it can be sent back only for that purpose so that I can proceed with the
But
execution.
then will that my appeal, which is ready for hearing, will be-
If you send it back, then the appeal goes.
Not only with respect to the certified copy of the judgment and decree, nothing more
will
than that.
go
The
through the-
rectified judgment and decree. Else, my Lord, I cannot proceed with the execution.
No, no.
Lord,
it
they
is
are not complying with your Lordship's order, so the stay is vacated.
But
To
say has
this
been
to-
vacated 1 year back, not
Effectively,
today.
I am not remedial.
But Lordship had directed us to file the paperwork. We have done it
That
expeditiously.
does not mean you will not
No,
pay
my appeal is
compensatory
ready for
charge.
hearing. Lord. My appeal
If
is
the
ready
appeal
for
is ready
hearing.
for hearing, why should you send it back? We'll direct it to be listed next month. Direct the appeal to be listed. This is can 3.
Can three, Lord, only one thing, Lord, if the
The
certificate
records have been, the records are here.
is there, everything is there. I only want, Lord, certified copy of the rectified judgment and decree, nothing more than that. If that can be done from here, Lord, it can.
I will request my Lordship for early hearing of the appeal. That's
The
my.
learned counsel for the respond, you for the respond.
And for the response.
Learned counsel for the respondent submits that in view of the trial court records being before this court, comma, no certified copy of the rectified decree is available to the respondents. Full stop, next para. The concerned department of this court is directed to issue a certified copy if applied for by the parties of the rectified judgment and decree passed by the trial court. Full stop, next para. In view of the urgency involved, comma, the appeal be listed in the monthly list of August 2026.
Grateful, Lord.
Grateful.
Like, Lord, may I
Can
file that
3 of
in, sir?
can 3 of 2026 is disposed of accordingly, no orders to cost. The affidavit sir is filed to be kept on record at opore দিয়ে.
Oblige, Lord.
Thank you.
Grateful.
ম্যাডাম আমার 5 নম্বরটা না আইটেম নাম্বার 5 এর মধ্যে জাস্ট আমি
Sorry. Yes.
7, Milord, I am for the opposite party, Milord, appellant, opposite party in can 2. Milord, the ad interim order granted, thereafter, Milord, the temporary injunction application on merit dismissed. Challenging that my appeal, I have been protected by your lordship's, Milord, interim order till disposal of the appeal. Now, Milord, they have filed this can 2 for modification of your lordship's order. That, Milord, affidavit have been exchanged. Reply, they have served an advance copy, but I don't believe, Milord, that has been filed before your lordships.
None appears to move the vacating application bearing can 2 of 2025. Let the matter go out of the list. Next.
Grateful.
Item number 8.
Yes.
Yes, my lord, may I file my reply, my lord?
What is the matter, Ms. Manath?
My lord, the probate proceeding, my lord, which was contentious, my lord, was dismissed, my lord. My lord, thereafter, my lord, we have filed this appeal during the after it was dismissed, my lord, and during the pendency of the appeal, my lord, even the properties have been transferred, my lord. So, my lord, I am praying for an injunction. This is
Yes,
the short,
You
my
are
lord.
preventing them from creating third party
Third party interest.
Mr. Basu,
The person on who is favor the third party interest has been created was also a party in the proceedings, my lord. Earlier, some of the properties were transferred
no,
to
is the
him.
transferee a party to the present
Yes.
appeal? Present appeal?
Yes.
I am the third.
Dividend number 12 and 13.
In a book, bol-
You have transferred.
We have already before filing probate application, transfer effective.
That is what you asked you. You have transferred.
A very interesting question, your lordship.
Interesting, maybe, but Mr. Basu, we are continuing.
no, so far as
Regarding,
No
regarding,
third party interest.
regarding,
They are the main parties there. You have transferred, so you have lost interest.
regarding, they have, we have,
Wait,
used our evidence of petition. We have submitted that they have, suppressed in regarding in the probate application, they filed application for injunction. That injunction application was rejected on contested hearing. Then, they preferred appeal before the Honorable Court. Honorable Court also rejected that declare for injunction.
Why rejected? On what ground?
Same, but from the will itself, you will also find that a literate person, MA, and while was serving, in an Asiatic society as a librarian,
নামটা বলো না
procured and
দুর্গাদাস বসু মল্লিক
procured
I don't heard the name দুর্গাদাস বসু মল্লিক was
procured the alleged will, putting the thumb impression, and there is no mention about the name. That is the LTI of such and such person. It is the PW2, one of the attesting witness admitted, and the other, the executor is the son, total beneficiary, the mother, and two attesting witnesses, the one brother and brother's wife. This is the total suspicious circumstances the will has been prepared. And they have failed to measure the trial court held that will has not been at all proved. Will at all not proved, and from the evidence you will also
Not proved means no attesting witness came.
no attesting, there are three will came out, and one will the person
Did any of the attesting witnesses prove the will?
did not fail to prove the will.
So who proved the will?
Nothing. No, that's what trial court held that the will has not been proved.
Yes, Mr. Basu, you have to add anything to that?
yes I have to
Milord, may I?
some property
Yes.
which is subject matter of this was transferred to me on the basis of a partition effected among the Durgadas Basumalis themselves. So those properties.
Mr. Basu, the appeal is pending. We are asking you only to not to create third party interest.
If you Lordship allow me to place, my lord, the ground on which the trial court on two occasions, my lord, rejected the prayer.
Yes.
If, my lord, kindly come to. I have prepared a list of texts. Your Lordship can get it, my lord, in opposition, affidavit opposition of 12 and 13.
Opposition. Position group. Opposition.
Not after completion of Mr. Basumano, I said make my short submission.
You have made your submission.
No, with regard to the
Let him complete, my lord.
Then you complete.
with regard to the point of law, my lord, the Lordship has decided.
Yes.
Then decided to judgment. So when the LTI is in the will, a literate person can. I am relying your Lordship judgment. That is Supreme Court judgment also.
Regarding what point?
Regarding the LTI, if the LTI, there must be explanation in the will, and why a literate person has put his LTI.
Retired person.
Literate, highly literate person.
Literate.
And from the four corner of the will, your Lordship will not find any explanation given that a literate persons. That's why the trial court held that the will is a totally suspicious circumstance. First point, and manufactured. Then, my lord, your Lordship will find the in course of hearing, other two will has come out, and other two will come out. One will the execution. Why not 21? December 21. Why not notarized on? Why not 2022? That has been that I have enclosed in my lord objection. And my lord, another will also same thing.
Those wills are subsequent to this will.
Similar will.
Those wills are subsequent to this will.
Not.
Yes or no, Mr. Dotto?
No, subsequent to this will.
Both wills are subsequent to this will. This will is registered.
Not unregistered.
All are unregistered.
Unregistered. One will has been exhibited. There is no signature. Only signature of attesting witnesses. Signature of the testator is not appearing.
In those other wills.
Other wills.
How are the other wills germane for this probate?
No, the other will has been marked exhibit. They have admitted that this will is the will of the testator. They have admitted in evidence.
But you are demolishing that will by saying that there was no signature of the testator.
There is no signature. You also find they have admitted that there is no signature.
If there is no signature in the other wills,
in the will in the subject matter of the probate application,
there also there is no signature. Obviously, LTI is there.
LTI
That you have already argued twice. Yes.
LTI, the name has not been written, and who put the LTI has not been written, and the literate person, and there is the mention in the.
You are repeating things.
No, there is mention in the bottom that Regovan and explain.
Written.
Yeah, written. In Bengali written will a leader person MA pass.
Yeah, this is your fourth argument on this point.
And my lord, your lordship will find from the said will that in the evidence of the period only or attesting witness who is the common related. He, my lord, stated that I am not. There is no there is no name written. There is no signature of the testator.
Very
My lord, regarding suppression, my lord, I shall place that.
What has been suppressed?
Well, before my lord filing the probate application, they filed out of 2 suits. An injunction paid for.
Suits for?
Suit for declaration permanent injunction relying on this will.
Relying on the will.
On the will.
But no probate was granted till then.
Till then, no probate was granted, no injunction.
So those what happened to those suits?
Suits pending. Injunction rejected. Miscellaneous appeal filed. Miscellaneous appeal also rejected. Those things have been suppressed, but in the reply, they have admitted. That's why, my lord, when that is suppression, that they are not entitled to, my lord. Regarding, my lord, merits of the matter, I cannot say in my present.
What else have you submitted? All on the merits of the matter.
Merits of the matter only to show the prima facie case. What is the prima facie case made out in this application?
Right, right. You are for respondent number 8.
Respondent number 8.
Anything else, Mr. Datta?
Regarding my lord, suppression, your lordship knows very well that I am not burdening your lordship with this citing the judgments matter. There are several judgments. Honorable Holy Standard also passed this in respect to injunction application. When an injunction application is in equitable relief, if a person suppressed, he is not entitled to injunction.
All right.
And there are other valuable properties involved. Supreme Court held when they are valuable, you have to, if your lordship is inclined to pass any order of injunction, they have to furnish sufficient security.
Very
well.
Yes.
This is my total submission, my lord.
Milord, may I, Milord, just add, Milord, 2 lines to this.
You are appearing for?
Milord, I am appearing for, Milord, respondent numbers 5 and 6.
Yes, what do you add?
Milord, the time gap between the will and the death, purported will and the death was, Milord, 17 days. Milord, under the will, Milord, the beneficiary, purported beneficiaries were neighbors. Milord, the neighbor who claimed herself to be, Milord, adopted daughter of, Milord, the executor of, Milord, the testator. Milord, the age difference between the testator and, Milord, the beneficiary was such that, Milord, she could never have been, Milord, the adopted daughter. And, Milord, there was no subsequent or multiple wills. Milord, the will which was initially produced before this honorable court is the same will which was produced, Milord, for granting probate, for grant of probate. Initially, Milord, the will did not have the executor's, Milord, the testator's thumb impression, which was added later on, Milord, to file the probate application. With what is, Milord, my learned senior friend was trying to, Milord, argue before your lordship is that. So, Milord, there were, Milord, attesting witnesses who had, Milord, allegedly signed, Milord, a will in their capacity as attesting witnesses when testator's signature or thumb impression, Milord, were missing. And then, Milord, thumb impression was added to that. There was nobody to prove, Milord, whose thumb impression was it. And this is on this ground, Milord, principally, Milord, the learned court below, Milord, refused to grant probate, Milord, to the will.
All right. Very well.
So, Milord, Milord, the will is by an educated person. My learned senior friend has, Milord, argued that.
Yes.
Yes.
What was the age difference between the so-called adopted daughter and the testator?
Milord, it's only few years, Milord, the exact number of years, Milord, is.
Good.
But, Milord, that was not legally permissible.
Good.
These are the, Milord, prima facie, these are the.
And, Milord, I'm sorry, Milord, one more thing. Milord, the affidavit of assets, which was, Milord, filed, Milord, in the probate proceeding, Milord, included properties which were not with the testator, Milord, under the partition decree. So, if today, Milord, injunction is granted, Milord, on those properties as well, possibly, Milord, will be, Milord, traveling beyond, Milord, the probate application or beyond the four corners of the will even, so-called will. These are, Milord, my short submissions.
Why beyond the will?
Milord,
why beyond the will? Those are subject matter of the will.
Will says all assets are being given, Milord, to the universal legatee.
All right.
Now, Milord, will also says under the partition suit, my lord, he got something. Now, my lord, in the partition decree, my lord, some properties were allotted to the testator. The affidavit of assets includes properties, my lord, which are not allotted to the testator.
Which are the exact properties you have disclosed in your affidavit in opposition?
My lord, opposition, my lord, not properly disclosed, my lord, should have been precisely disclosed. My lord, if my lords kindly allow us, my lord, we can use a short supplementary affidavit
no further-
indicating the bullet
Further
points.
affidavit, we are hearing the application. Yes.
Right.
Yes, Mr. Mr. Basu.
This covered, my lord. My submission is when your lordship's court also, my lord, approach
You have for respond number
13, the transferee.
13.
12 and 13.
12. Yes.
The partition suit, my lord, was decreed on 9th July 2018.
Yes.
And the property, the
Partition final degree.
final decree in respect of the Durgadas's uncles. So the property which are made the hotspot of this probate proceeding, not even the property of Durgadas, which I have purchased from other heirs. If those are included, my lord, and it is injuncted, my purchase from the other heirs of Durgadas is also, my lord, affected. That's why, my lord. Now, my lord, kindly once for a glance, I will not say, my lord, that
We have not yet granted an injunction here.
no. Refused, absolutely refused by the trial judge, and your lordship's court was also approached. Justice Harish Tandon, as your lordship will kindly see this order at page 182 of my affidavit in opposition.
What is the date of the order, Mr. Basu?
Date of the order is 19 December 2024.
আগের অর্ডার গুলো কোথায়?
Is 180.
সব অর্ডার নেই কেন? কয়েকটা অর্ডার রয়েছে কেন?
No, the court in all.
My lord, that order was
Not in this matter.
not in this matter.
Earlier round,
All around?
my affidavit opposition will show. my
No,
lord.
all around in what? Partition suit?
No, in probate proceeding, injunction was sought for.
আচ্ছা।
But
In the
kindly,
trial court, it was sought, came up before this.
kindly come to 182 of your lordship brief in my
My lord,
affidavit.
may I take my lord's kind leave, my lord, for a
Yes,
while and
yes.
come back?
Yes.
Grateful. Great.
182.
Yes. One.
Where, my lord? Your lordship's court was not pleased to grant and delegated to the probate court.
No, their lordship said that as we have indicated that there is a protective order operating in the field,
That is in the suit, let it be there.
and therefore the instant application is only to delay the disposal. That was the premise.
So, my lord, no grant injunction, extra protection has been granted.
That injunction was granted where? In the partition suit.
In the partition suit.
No.
That is
Oh,
no,
no, no. Then another suit they filed by them in that suit.
that injunction is still subsisting.
That is where.
That has been vacated
Then
subsequently.
this logic does not apply now.
No, that is subsequent.
So this does not apply now, this logic of Justice Tandon.
What I am submitting, my lord. These are two parts. One is
The other arguments remain.
what I am submitting, my lord, here in this this order,
Yes.
two parts is according to me. One is court prima facie of the view that in this case no injunction should be granted, coupled with the fact that you are already protected. Not in isolation, my lord, not only you are protected, that's why I am not granting. Your lordship's court has probably not said that.
No, Mr. Basu, there is no finding on the merits at all in Justice Tandon's order.
My lord, kindly
Please come to that, page 182. It appears that before an application for probate, two other regular suits,
yes.
trial court recorded findings in
Yes.
both suits
The probate
entirely on the previous.
third paragraph. Probable application has been converted into a contentious cause of, and we are of the understand that the evidence of support of such and such is done. Though it is alleged by the respondent that whatever is the date is fixed of hearing of the said contentious cause, adjournment is sought, and in fact the application are taken out for injunction just to forestall the final disposal of the said
That was the
proceeding.
interpremise.
So
as
that's why I can show
No adjudication on.
no adjudication, but the trial court adjudicated.
Yes.
And approach your lordship's court, not interfere with this order. This much I can say.
Yes.
Well, kindly once look to this page 152 of the affidavit. I was just only to show to your lordship what is the will filed by the respondent number 8.
Yes.
Affidavit in opposition, page 152.
Respondent 8.
Yes. 152.
152, yes.
But kindly see this.
This is the will.
This is the will.
Yes.
One of the will.
How many wills?
There is only one will, my lord.
One we Bible we got it is.
This is the present will. This is the present will.
One Bible
My lord, one will which contains the thumb impression and the signature.
and this is
There is no other will.
there is no thumb impression, no signature.
This is another will. How is it material here?
Same identical. Same date, identical.
11th May
That's why
My lord, what a- my lord, let Mr. Basu
Basu
submit, my lord, then I will explain, my lord.
wills in 3 suits.
Yes.
So these are the suspicious circumstances which is apparent on the face of the record. That's why this probate has not been granted.
150.
And so far I am concerned, I have not only have this property, I have also got the property
154
from
another-
the heirs of not from the Durgadas, heirs of the vendor.
Mr.
that's why-
Basu, some of the properties belong to Durgadas, others do not.
So
were
some
not.
of the properties I have purchased directly from the other heirs of
So,
Their own
is there any delineation in your affidavit in opposition to show which properties
which property has a
belong to
segregated.
Durgadas? That is not
That-
there.
That is not there, madam. I must be candid. That is
So
not
let us
there.
hear. Let us hear, Ms. Agarwal.
Now, my lord,
another will.
Oh,
Okay.
before that,
Yes.
152 I have shown to lordship.
Yes.
Now count come to 154.
Yes, 154.
Next okay. Another
154. Similar.
Another will. Another will.
Similar.
will exhibit.
This has been exhibited documents. So this we want to show, my lord, the prima facie it appears the suspicious circumstances has galore.
These came from whose custody? These other two wills?
From there.
From their custody,
They produced.
they
To show what?
They include the injunction application.
probably it was been inserted in the injunction application. My lord, what happened? Can you don't make me miss? This for manipulating things, my lord, it sometimes comes out. If it is an actual, the actual will come first and not nothing else. That's all, my lord. And if at all, my lord, things for injunction, my lord, can be put on terms.
What sort of term would you expect?
I will be preventing from utilizing a property. That's why they should be, my lord, in the manner, my lord, things based.
Yes, Ms. Agarwal.
yes. My lord, so far as the injunction is concerned, my lord.
Yes.
My lord, after the will was, my lord, before filing of the application for probate, my lord, the respondent's will was there. Factum of will was disclosed in the suit. Then, my lord, we came to know that the respondent number 8 and 9 were transferring the property of the deceased, my lord. We filed a suit clearly mentioning that the will is there. And, my lord, the trial court, my lord, did not grant the order of injunction on the plea that since appropriate court would be the court where the probate proceedings would be filed, and as yet no probate proceedings have been filed. This was the first suit. In the meantime, my lord, when the probate proceeding was filed, my lord, thereafter, these persons, my lord, transferred the properties, some of the properties which were in the partition deed, my lord, and which were allotted to my client, my lord, to the deceased, my lord, to respondent number 12 and 13. 12 and 13, thereafter, since the third party interest was created, we implemented respondent number 12 and 13, my lord. Then other properties were also sold to respondent number 12 and 13. The other suit was filed, second suit was filed seeking cancellation of the deed of conveyance which was executed in favor of the defendant number 12 and 13, my lord, where also the factum of the probate proceeding was disclosed. In that, my lord, the order of injunction was granted. Thereafter, my lord, we filed application in the probate proceedings. In the probate proceeding, injunction order was not granted. We preferred an appeal before this honorable court. In the meantime, my lord, what has happened, my lord, that it was dismissed for default.
What?
The application for injunction there in the earlier suit, which was later on restored. Then we filed an appeal from in the probate proceeding injunction order, my lord. We preferred an appeal before this honorable court, which is page 182 that was shown to your lordship. So, my lord, when the order was passed by the division bench presided over by my lord Justice Tandon, my lord, order of injunction was there. Since then, subsisting order of injunction was there in the other suit, my lord, the honorable court, my lord, was pleased not to grant any further order of injunction. So, my lord, thereafter, my lord, in the other suit, where the order of injunction was there, my lord, the order of injunction has been vacated, my lord, I shall admit, my lord, on 17th of June 2025 only, on the ground that probate proceedings, all these issues will be tried in the probate proceeding. There is no adjudication on the merit. in that also that I'm not entitled to get the order of injunction. Now, after the probate has been granted, my lord, on refused by the probate court, my lord, after the filing of appeal, my lord, on 15th October 2025, some other properties have been transferred, my lord, in favor of the respondent 12 and 13. This is with regard to this. And so far as the 3 wills is concerned, my lord, my lord, there is only 1 will. My lord, she will find that the handwriting is same, verbatim same. 2 wills are there without signature, which we had annexed along with the injunction application, my lord. I had inquired from the client what is the reason. He said that original will, which was there, which contained the signature, covering the signature part only. The document was xeroxed, it was notarized, and it was annexed to the injunction application. There are no 3 wills, there is only 1 will. And the will not only contains a thumb impression, but it also contains the signature of the testator.
Also signature.
Yes, signature of the
Where is that
testator.
will?
Yes, I shall show. Kindly come to page 54 of the application for injunction.
Where is the thumb impression? You find only the signature.
Thumb impression was there, it has not come. No, my lord, it is another will. It is
Another
the will
copy
which
of the same will.
No. It is a will granted by the brother in favor of the testator.
Thank
Sorry,
God.
my lord.
Yes.
I'm sorry. I've come to the wrong page. Just kindly give me.
Up to 2 we can withstand, but third would be the last straw.
No. Sorry, my lord. I'm very sorry. Wrong document I've shown. Just a minute, my lord. It is disclosed, my lord. Just a second. Just
Really question.
একটু পাতাটা বলুন ওই বিলটা একটু পাতাটা
Mr. Basu or Mr. Dattu, you can also help us.
Yes, sir.
Where is the will?
Yes, 170.
Annex anywhere?
It is annexed.
Mr. Gupta can help you.
Volume 2 application.
174. 174.
Thank you very much.
This is part of the judgment. This is, my lord, this court has recorded that and make it a part of the judgment.
Scan copy.
This is scanned copy.
You know.
And when I got a chance, I should utilize that chance. Can you come to the top?
Let me show.
What is the name I have told?
Yes.
Is the name written?
Yes. I'll answer everything.
Yes.
Yes.
Do we find signature and
Signature as well as the thumb impression.
No. What is the
It
name?
is both. Durgadas Basu Mallik only.
Durgadas
It is
Basu
written by hand.
Not possible.
No, there, sir, my lord. If I can read Bengali, my lord, if the sir ref is a little short, it will read like pa. So, my lord, they are trying to say that the sir the sir has become
My lord,
pa.
sir, ask the judge to read it.
Sir has become pa. I can read Bengali, my lord. If I
No, you can read Bengali.
Yes.
Better than most of us.
No, my lord. But so this sir, my lord, if the it is
Understood.
slightly short, my lord, then it becomes
Got
pa.
yes.
So that is why, my lord, they say that it is somebody else's signature. But some impression and signature both are there, my lord. And so far as the merit is
If
concerned,
you manufactured, you would have written Das in any event.
yes.
More clearly.
Yes.
So this shows it's not manufactured.
I will not
The
say
real
any.
signature may have some discrepancies, but if it's a manufactured signature, you will be very precise and very particular.
Yes. So, my lord,
So what else, Ms.
the
Vidya?
judgment is basically on this only, this signature, that it is per a ref has gone somewhere else. Ref
Have
is
you
not there.
annexed anywhere a copy of the injunction order which was found by Justice Tandon, the trial court's injunction order which came up before?
My learned friends have annexed. I have not
Where is
annexed.
that? Where is that? We
It
want
is
to
at
see
page
that.
182.
Whoever has annexed.
Page
180.
182.
182 of no,
It was placed before your
there is
lordship.
Justice Tandon's order.
Attendance order.
No, the order which was challenged before Justice Tandon, the trial court's order. which you say was refused because of the
Yes.
probate procedure.
Reply का copy कहाँ है?
Another order what I was asking for, when the order was vacated in the suit, that is at page 121.
121 of
Of affidavit in opposition of respondent number 8.
Computer আমার কাছে copy টা নিতে পারো ওটা। इसलिए
39
ले
for
आएगा वो। ये कहाँ है? ले आएगा copy। तो कागज हमारे माँ। Kindly see page 122 मिलो।
yes, we are there.
It also appears that one title suit number 292 of 2022 has already been filed by the plaintiff in respect of the same suit property, which suit is still pending between the same parties and against which a miscellaneous appeal has also been filed, which is still pending. Whereas case number 87 of 2022 is also pending in Learned Additional District Judge 12th Court at Alipur. Considering the same, the petition under Order 39 Rule 4 of CPC is hereby allowed on contest without any order as to cost. But there is no finding on the matter, my lord.
In this case, injunction was granted initially, which
Yeah,
was vacated.
initially, which was vacated. This is the reason there is no reason whatsoever.
What are you asking for Justice Tandon's not interfered.
Page.
Page 99.
Got it.
I got it.
Page 182 that I've shown. So, my lord, while allowing the Order 39 Rule 4, my lord, no finding was given on merit. It simply says that the two other suits.
Let us come to page 99 why it was refused.
Page 99 was shown to your lordship. Page 100 kindly come, my lord. At the time of hearing, it has been rightly contended by the learned advocate for the plaintiff that this court, being a probate court, has no right to consider the title of the testator, but on consideration the matter as a whole, I find that on the strength of the injunction petition, the plaintiff executor of the alleged will is trying to challenge the valid final degree of partition without challenging the degree itself before any higher forum. Having considered the above all and having considered the materials on record, I find that any prima facie case is made out by the plaintiff in support of injunction prayer, and it also appears that balance of convenience and inconvenience is not appearing in favor of the plaintiff, but the same is appearing in favor of the defendants in view of the final degree of partition passed by the competent court of law, and as such there cannot be any question of irreparable loss and injury to the plaintiffs in case of refusal of order of injunction, but there may be chance of irreparable loss and injury to the defendants in the case of grant of injunction order. Moreover, injunction being an equitable relief, I do not find any reason to grant the injunction order in favor of the plaintiff, and as such, injunction prayer is liable to be rejected, my lord. This was before challenge, under challenge, my lord, before my lord, the division bench of this honorable court presided over by Justice Tandon. My lord, there were, I have given in my application, my lord, there were 3 sets of properties, my lord. One, my lord, which was given to the testator by way of in the partition. Second was, my lord, the brother of the testator, my lord, the will which I had wrongly shown to you at page 52. He had bequeathed his property, my lord, in favor of his brother, debarring his children. Probate was granted. By virtue of that will, he became the owner testator. Third was his self-acquired property. So, schedule A, B, and C of my injunction application, my lord, I have clearly mentioned.
There is an allegation by the other side that some of the properties regarding which you seek injunction.
No, my lord,
allotted to them.
these belong in the partition deed, my lord. Those properties have been allotted to the testator only. Some of the properties were allotted to his brother, Subal Das Basu Malik, and some of the properties to Durga Das Basu Malik.
In the will we find, Ms. Agarwal, that in the will it says that Amar Ukto Shokol Sampotti. So, Sampotti is not specified in the will.
Yes.
In your affidavit of assets for the first time, it comes before the court,
Yes.
obviously. But if some of the properties have been given to others, then that by the will itself, as Mr. Basu argued and Mr. Dotto,
Yes.
that by the will itself, then that is excluded because it's not Amar Shokol Sampotti. So which are
Milord,
those
I have
properties
kindly come to page 53.
of the injunction application?
Yeah, this written statement filed on behalf of the defendant numbers 2, 3, 5, 6, 8, 9, 10.
Written statement in the probate.
Yes.
53 of the injunction application.
Yes, I have annexed it. They have annexed. Respondent number 8 has annexed.
Then not your injunction application, then their opposition.
In their opposition,
Say
in my
that we're asking you repeat
partition deed, I have annexed, Milord, but they have mentioned.
whatever you have. Page 53.
Yes.
So these are the properties given to him.
According to them, in the partition deed. Now take my application for injunction, Milord. Schedule A, Milord, I have mentioned categorically. B, C. Which are the properties? Kindly come to page 30 of my application for
We
injunction.
are there. We are there. You have sought injunction regarding which schedule?
Yes.
Both. A, B, and C all.
Yes. And some of the properties in this Milord have been recently transferred in favor of the defendant number, respondent number 12 and 13. In paragraph 4, Milord, I have mentioned that which are the properties which were being purchased by him separately, which are the properties which were inherited by the testator from his brother, and the properties which were he received, Milord, by virtue of the deed of partition, Milord. Paragraph 4. I have clearly mentioned the details of all the properties.
The 56, 57, and 59 are not in your schedule. You say in paragraph 4 that those have been purchased by testator. Those are not a part of your schedule. You don't find these three, 356, 357, and 359.
Record.
Those are not there.
Milord, these are in paragraph 4. I have mentioned the CS dag number, and here the kindly see the area. It is same only. These are RS dag number. Area 1.69 acre, 0.11 satak. Area 0.44 satak. Only which has been added is 0.03 satak. But Milord, I can produce the deed of conveyance, Milord, that he has purchased these properties 29 September 1961. The total area admitting is 2.24 acre. I have mentioned in paragraph 4. Schedule 8 says 2.27 acre. So that is there, Milord.
Yes, that is all.
These are all, Milord. What I submit, Milord, that I have annexed, Milord, in my application also. they have transferred, my lord. They are transferring, my lord, the properties. One is the deed of conveyances, my lord, which have been executed
Yes.
very recently. They are disposing of all the assets of the testator. Kindly come to page 189.
Some transfers has been effected, that is an admitted.
Earlier, and after this also. So that, my lord, when we prefer the appeal, my lord, it becomes infructuous. There is nothing left, my lord. Kindly come to page 189, my lord, the date.
Of what?
15th October, the
189
deed of execution
Of what? 189 of?
of my application, volume 2. And surprisingly, my lord, the defendant number 12 and 13 and the learned advocate who was representing the different parties, my lord, are the close relative. So, my lord, through him, everything was being arranged.
The present appeal has been filed against a judgment whereby the application for probate of the will of late Durgadas Bosumullik, filed by the present appellant, was dismissed. For sub next para, learned counsel appearing for the appellant argues that taking advantage of the absence of an injunction order, the respondents are trying to transfer and or create third-party interests in the property, which is the subject matter of the will of which probate was sought. For sub next para, learned counsel for the appellant submits that the refusal of injunction by the civil courts in two earlier suits was primarily on the premise that the subject matter of the dispute was also the subject of the probate proceeding. For sub next para, an earlier refusal of ad interim injunction by the trial court came up in appeal before a coordinate bench of this court, which, it is submitted, proceeded on the premise that since there is already an injunction order subsisting in a suit, no injunction ought to be granted. Because of thus, it is contended that there was no adjudication, no refusal of injunction on merits as such. For sub next para, learned counsel next argues that the disputed will contains the left thumb impression (LTI) as well as the signature of the testator, who is admittedly a highly literate person. Full stop. Next para. It is contended further that although two other wills without such signature or left thumb impression were annexed initially to the injunction application by the appellant, those were mere photocopies of the disputed will only and not separate wills, wherein, during taking out photocopies, the signature stroke LTI portion of the same was covered. For sub next para, learned counsel next argues that that since transfers are being effected regularly by the respondents, unless an injunction is granted, the appeal may be rendered infructuous when it is finally heard. So next para, learned senior counsel appearing for the respondent numbers 12 and 13, who are the transferees from some of the respondents in respect of a part of the subject properties, argues that the hotspot of the properties included in the affidavit of assets filed in connection with the probate application by the appellant includes several properties which were not allotted to the testator in an earlier partition suit. Full stop. Next para. As such, since the disputed will merely mentions that all properties of the testator are being bequeathed, the properties which did not belong to him ought not to be the subject matter of injunction. Full stop. Next para. Learned senior counsel also points out that there are several discrepancies in the will, which was not properly proved in the trial court, in the testamentary court, comma, due to which probate was dismissed and injunction was also refused. Full stop. Next para. It is argued that the testator, comma, despite being an educated person, comma, allegedly put his LTI on the disputed will. Full stop. Such the circumstances behind such act on the part of the testator is completely unexplained by the propounder stroke appellant. Full stop. Next para. Learned senior counsel takes the court through the copy of the will which has been annexed herein and points out and submits that the so-called signature of the testator beneath the LTI is does not disclose the actual name of the testator, whereas the name of the testator is admittedly double inverted Durga Das, double inverted close, comma, it appears in the said purported signature to be Durga Dutt, D-U-T-T.
Durga Dap.
Da,
Dap. They have taken Dap, not Das, Dap.
D-A-P,
DAP.
Durga Dog.
Dap.
Durga Dop.
Durga Dog.
লিখবে কি করে দুর্গা দপটা?
Left name.
Spell it in English.
Durga Dog.
D-U-G-G-A, D-A-P, double inverted close, full stop. Next para. Learned counsel appearing for the respondent number 8, comma, by placing reliance on the affidavit in opposition filed by the said respondent, comma, argues that since the injunction was refused at all stages, both by the civil courts and the testamentary court, as well as affirmed by this court, comma, this court ought not to grant an injunction as well. For sub next para, learned counsel points out that the will was never proved in accordance with law in the testamentary court. Full stop. Moreover, comma, the circumstances surrounding the alleged execution of the will are highly suspicious, and the will is a manufactured one, which is also borne out by the fact that inadvertently, comma, the appellant annexed two other copies of wills by the testator himself of self-same date as the disputed will, which also puts the execution of the will in question, in doubt. Full stop. Apparently, comma, all the said wills are manufactured documents. Full stop. Next para. It is reiterated by learned counsel that in the absence of any explanation whatsoever as to what prevented the testator, comma, who is highly educated, comma, from putting his signature on the will, comma, but instead, comma, his LTI, comma, the learned testamentary court was justified in dismissing the probate application. Full stop. Hence, comma, no prima facie case has been made out in the present appeal as well. Full stop. Next para. Learned counsel submits further that an injunction, an ad interim injunction obtained in one of the previous civil suits filed by the appellant was subsequently vacated due to suppression of the material fact of subsistence of other litigations. Full stop. Next para. It is contended that since the appellant did not disclose before the court, before the trial court, that injunction was refused in the other proceedings, comma, the interim injunction was vacated. Full stop. Next para. Suppression, comma, it is argued, comma, vitiates the right of a party to obtain an equitable relief, comma, which injunction is. Full stop. Next para. Learned counsel further points out that the contents and date of the two purported unsigned wills are identical with the disputed will, comma, which itself casts a doubt on the veracity of the same. Full stop. Next para. Learned counsel appearing for the respondent numbers 5 and 6, comma, while adopting the arguments made by the other respondents, comma, also submits that there was only a gap of 17 days between the date of the will and the death of the testator. Full stop. Next para, that apart, comma, the beneficiary of the will is a neighbor of the testator who claims herself to be the adopted daughter of the testator. Full stop. However, comma, the difference in age between the testator and the beneficiary is about
7 years, my lord, 7 years.
7 years, comma, which rules out the possibility of her being the adopted daughter of the testator. Full stop. Hence, comma, the will is shrouded in suspicion. Full stop. Next para. Learned counsel next reiterates that there was initially no left thumb impression (LTI) when the attesting witnesses signed the will, comma, which will be borne out by the evidence led led in the testamentary proceeding. Full stop. Hence, comma, the LTI could not have been proved properly in accordance with law. Full stop. Next para.
And my lord, executor is the son of the beneficiary.
Very well. Next para. Learned counsel also points out that the executor of the disputed will is the son of the beneficiary. Full stop. Next para. Thus, comma, it is contended that the above circumstances rule out the validity of execution of the will and are sufficient to cast serious doubt on the actual execution of the will. So next para, learned counsel also reinforces the argument of the other respondents to the effect that the affidavit of assets filed along with the probate application includes properties which did not belong to the testator, comma, in terms of the partition decree passed between the testator and his co-owners. Full stop. Next para. Upon a careful consideration of the arguments of the parties, comma, we find that in the disputed will itself, comma, there is an LTI as well as the signature of the testator. Full stop. Next para. Although it has been argued that the spelling of the name of the testator is incorrect, comma, we find that at least at 2 places in the will, the testator signed. Full stop. Immediately beneath the LTI, on the second within bracket last page of the will, comma, the name of the testator has been clearly mentioned as Durga Das. Full stop. Although there is some confusion, some prima facie confusion as to whether the name of the testator was put in the signature correctly on the top of the first page of the will, comma, on a plain reading and a comparison by the court between the 2 signatures on the 2 pages of the will, comma, it transpires that the same was that the 2 signatures were put by the same person. Full stop. However, comma, we hasten to add that these findings are only prima facie at this stage. Full stop. Next para. Be that as it may, comma, from a plain reading of the will, comma, there does not appear to be any suspicion attached to the execution of the will insofar as the testator put both his LTI as well as signature. Full stop. Even if the LTI were to be disbelieved, comma, the signature cannot be. Full stop. Next para. We say so because there is nothing on record to indicate that the objector stroke respondents sought expert examination of the signature on the will to disprove the veracity of the same by comparison with other signatures of the testator. Full stop. It is well settled that the onus is on the person asserting a positive fact to prove such fact, comma, in the present case, such fact being the allegation of the will not being genuine. Full stop. Next para. Even otherwise, comma, the refusal of ad interim and interim injunctions by the civil court, comma, which we find primarily to be on the ground of pendency of the probate proceeding and on the premise that the testamentary court could not enter into the question of title, comma, cannot be said to be conclusive insofar as the prima facie case made out by the propounder in the probate proceeding. Full stop. Next para. The order of this court of the coordinate bench of this court by which the the refusal of injunction was affirmed also does not proceed to deal with the merits of the probate proceeding, comma, even prima facie, but proceeds entirely on the premise of a prior subsisting injunction, which, according to the coordinate bench, comma, would sufficiently protect the interest of the appellant. Full stop. Next para. Even otherwise, comma, the present injunction prayer cannot be determined entirely by refusal of injunction or vacating of the same at earlier stages of the proceeding. Full stop. Next para. A change of circumstance between the earlier occasions and now is that the injunction application was vacated at the trial stage due to suppression of the material facts of other suits being pending and injunction being refused therein. Full stop. Next para. However, comma, since those facts are disclosed before us and we have prima facie dealt with the injunction orders stroke vacating orders passed in the other proceedings, comma, such malady does not afflict the present adjudication. Full stop. Next para. The respond numbers 5 and 6 rely heavily on the minuscule age difference between the beneficiary and the testator to argue that she could not have been his adopted daughter. Full stop. However, comma, such fact is entirely irrelevant, comma, since even if there is no legal adoption, comma, it depends on the perception of the person as to how he or she views another person. Full stop. It may very well be that in the perception of the testator, comma, the beneficiary was his adopted daughter, comma, although such adoption could not have been permissible in law. Full stop. Be that as it may, comma, there is no bar in law to bequeath a property by a will even to a complete stranger. Full stop. The very fact that it has come on evidence that the testator had the perception that the beneficiary was his adopted daughter rather justifies the bequest in favor of the beneficiary than vitiate it. Full stop. Next para. The respondent numbers 5 and 6 also argue that the executor is the son of the beneficiary, which is but only natural, comma, since it would be more convenient for the testator to appoint the son of the beneficiary as executor in order to ensure that probate is properly granted. Full stop. Such fact, comma, per se, comma, does not tantamount to a double inverted mode suspicious circumstance so high as to vitiate the execution of the will itself. Full stop. Next para. As to the production of two other copies of the self-same will, comma, we find that the contents of the same are identical. Full stop. Thus, comma, it is not a case, comma, prima facie, comma, where three separate wills are produced, but two other copies of the self-same disputed will has been furnished by the appellant, comma, without the LTI or the signature. Full stop. It is a subject matter of trial as to whether such copies do not bear such signature or LTI merely because those were covered while taking out photocopies of the same. Full stop. Next para. In even otherwise, comma, it would be absurd that the appellant would deliberately be producing other wills to disprove the appellant's own case. Full stop. Next para. Thus, comma, on a comprehensive consideration of the arguments of the parties, comma, we are of the another point aspect which has to be considered is whether the subject properties, comma, regarding which injunction has been sought belonged to the testator. Full stop. Apart from the fact that the probate court cannot enter into the question of title, comma, we are of the opinion that in view of the uh, respondents having not categorically pointed out, comma, despite getting opportunities to file affidavits in opposition as to exactly which properties belonged to the testator and which did not, comma, much credence cannot be lent to such argument. Full stop. Next para, from the written statement filed in the trial court, comma, on behalf of the defendant numbers 2, 3, 5, 6, 8, 9, and 10 in the probate proceeding, comma, we find the mention of certain properties to have been allotted to the testator and certain other properties having been purchased by him. Full stop. Next para, the injunction has been sought in respect of the properties mentioned in the affidavit of assets. Full stop. Next para, we do not find any clear adjudication on the issue as to those properties not belonging to the testator. Full stop. Thus, comma, a finding in that regard at this stage would be premature. Full stop. Next para, in view of the above observations, comma, we are of the opinion that unless injunction is granted, comma, the urgency of which has been proved by the very fact of several transfers having been effected in the meantime, comma, the appeal may be rendered infructuous. Full stop. Even otherwise, comma, a prima facie case for grant of injunction, comma, balance of convenience and urgency have been made out in favor of such grant. Full stop. The irreparable injury which would be suffered by the appellant would be in the form of the appeal being rendered infructuous if no injunction is granted to protect the subject of the testamentary proceeding. Full stop. Is in view of the above, comma, can 1 of 2026 is allowed on contest, comma, thereby restraining the respondents and or their men and agents from selling, transferring, alienating, and or creating any third party interest in respect of the properties mentioned in schedules A, B, and C of Can 1 of 2026 till disposal of the appeal. Full stop. Next para, we do not impose any terms or conditions on the appellants while granting such injunction, comma, since it has since the appellants have made out a strong prima facie case and it has not been proved beyond reasonable doubt as to what would be the quantification of security which the respondents would be entitled to. Full stop. No address to cost. Paper book directions have been given.
No.
In view of the all the respondents are represented.
Yes.
In view of the appearance of the respondents through their learned advocates, respective learned advocates, comma, service of notice of the appeal on the respondents is dispensed with.
Some of the respondents may not be
Who are not appearing? You are for 5 and you are for 8.
I am on behalf of 8.
She was supposed to file affidavit also.
Siddharth Banerjee had appeared other day for others, he said.
Mr. Banerjee was appearing for the others.
8.
Milord 5 and 6, Milord, I have been instructed to appear.
Other day, Milord, 1 to 4 and
Milord,
What-
there was a confusion. There was a confusion. In case, Milord, my learned advocate on record has got the Vakalatnama, I will let Milord my learned
Who is
friend
your
know
advocate
about
on
that.
record? Who is she? You are not his advocate on record.
No, Mr. Abhishek Baron Das, Milord, is my learned advocate on record.
Your advocate on record,
Okay.
we don't find. There is no advocate on record before us.
Defendant number
No,
1.
Mr.
Not contest. If that appear and contest. Defendant number 1.
So you ascertain.
Milord,
Mr.
other day, Milord, they said that they are appearing for all.
have
Now, Milord,
Wakalatnama, then it's difficult to ask your clerk to ascertain.
yes.
Says, Milord, if it are all served, Milord
She
is
was-
ready.
She was directed to
Appeal.
file.
Not appeal.
Appeal.
Yes.
In view of the appearance of the appearing respondents through their respective learned advocates, comma, service of notice on the appearing respondents are dispensed with. Push of the appearing respondents in a slips you will write, so you'll get
Yes,
Yes.
from our copy of our order you'll get. The appellant shall put in postal cost requisites and written up notice forms for service of notice of the appeal on the other respondents within a week from date. Push of the trial court record shall be brought by special messenger. at the cost of the appellant, comma, also to be deposited within a week. Full stop. The will in original shall be kept in safe custody of the under the aegis of the Registrar General of this court, subject to further orders of this court till disposal of the appeal. Full stop. Next para, the appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant, liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
Diploma.
And my one more time we added. The observation that the injunction application is tentative.
No. Those are final. All these are final.
Regarding minor merits of the appeal.
No, those are final, conclusive. Those are conclusive. Why do you think they're not final?
Oh,
बोलते हैं
sorry, my lord.
We have several places in the we have used the word prima facie, wherever.
Extremely sorry, my lord.
Why should you be extremely sorry? Be sorry.
Yeah,
Diploma.
I have heard it. My lord.
No.
इंजंक्शन সময় ফাইনাল হয়
We have said prima facie many times.
even if it is not said.
Yes.
Suppose even it is not said.
That is the premise, one of our premises of our order also, that those were not binding.
Milord, earlier matter act number 7.
Over is over.
Please, Milord,
Call on the next matter.
make it not today, Milord. Make it not today, Milord. Coming
9 who is appearing?
from the leaves, Milord, meter is following.
9 who is appearing?
My lord, I'm
Yes. What is that?
appellate. My lord, the city civil court,
Yes.
as the trial court, so I'd like to be the respondent. City civil court as the trial court has evicted me. My lord, I have preferred an appeal, my lord, from that order.
Evicted you on the ground of you being a trespasser or like
No,
what is the premise?
2G. They made out the case of 2G.
What is the prima facie case?
My lord, may I tell your lordship? My lord, this is not a simpliciter 2G. The plaint proceeds on a short point that mother was the tenant. I am the son. So mother died in October 2015. Therefore, 5 years from there, in October 2020, I became a trespasser by virtue of 2G and therefore 2G. This is the case that they run. My lord, in my written statement, my lord, I come out, my lord, with the actual case. Father was a tenant. Father died in the year 1984. At that point in time, I was already a major. 1982. I'm sorry, 1992. Father died in the year 1992. Now, upon my lord, the father dying, me as well as my mother became joint tenants under the old act. And now the Supreme Court has clarified, my lord, that once a vested right is created under the old act, the new act cannot abrogate that. So
So
therefore,
you were all along a tenant after the
so
demise
I am all along a tenant. So this is, my lord, one side of my written statement, that I became a tenant and nothing has happened that has taken away my tenancy. Now, my lord, the learned judge has proceeded on the basis that in 1992, after the father died, there was an agreement executed between my mother and my lord, the landlord.
What sort of agreement?
It's a tenancy, a fresh tenancy, where I am not a signatory, even my name is not referred. It's a simpliciter agreement. So the question arose whether the one of the joint tenants can unilaterally enter into a tenancy which will result in the other joint tenant losing all rights.
You see, your joint tenancy was not affected by your mother's unilaterally.
Yes, exactly. That's what, but the learned judge says that no, it was because I have failed to produce any evidence to show that at that point in time in 1992, when I was reasonably old, in my late 20s or so, I have failed to give any evidence that I ever objected to this document on the basis of that. Now, my lord, may I point out, this document was not part of the evidence of my learned friend, the landlord. After I filed my written statement, he led his evidence. This document was not disclosed.
How was it?
He was confronted with this document when he was being
By
cross-examined.
you?
My lord,
By your
my client was confronted.
Your client confronted this.
My
Your
client
client was
was
confronted
by them. That this is a document of 1992. See, your mother became the tenant. What do you have to say? And my lord, although my lord, personally, I haven't had the, my lord, occasion of, my lord, reading, my lord, the deposition, but I'm given to understand that there is some sort of a recognition of the mother's signature. But the document is not. Yes, but the document is not proved, and the mother has died in 2015, and they didn't prove the document in their evidence. And my lord, on the basis of
not in the exhibit list.
On the basis of my lord,
it was not in their exhibit.
No. So on the basis, solely on the basis of that. So firstly, my lord, the learned judge.
So they got it proved through you.
Through me. But my lord, I am saying that is not proof. So my first contention is that the document was not proved. Mere, my lord, familiarity with some signature doesn't amount to proving a document. They should have proven that document. That's point number one. My lord, secondly, even assuming that the document was proven,
your joint tenancy could not be.
Could not have been affected. And my lord, thirdly, in 1992, my lord, the receipt, rent receipt, my lord, there is one receipt which says so and so proprietorship. What's the name of the proprietorship? No, name of the proprietorship firm.
Dhakeshwari Bhandar.
Dhakeshwari Bhandar is the name of the firm which the father used to run. So in the father's lifetime, my lord, the rent used to be Dhakeshwari Bhandar, and their proprietor, Mr. So and so, with the father's name. Then, my lord, in 1993, for the first time, the landlord, my lord, issued a rent receipt, Dhakeshwari Bhandar, and then the proprietor's name was the mother's name. My lord, that stopped. I said, no, I will not accept this. From 1993, my lord, I have produced rent receipts right up to 2019, where mother's name was dropped. It was being issued only in the name of the firm. I have shown documents, my lord, to show that I was the proprietor. I have produced those rent receipts. He has admitted all those rent receipts.
Proof of your proprietorship did you produce? Trade license?
My lord, I have given, my lord, trade licenses. But, my lord, those trade licenses are, my lord, recent. I haven't been able to produce, my lord, old trade licenses. But 2007-8 onwards, from the lifetime of the mother, my lord, I have shown that I am the proprietor. There's enough.
Died when?
2015.
Mother 2015.
So, my lord, it's not as simple, my lord, a case as a 2G case is, my lord. There is enough, my lord, material. And, my lord, it's a first appeal, my lord. It's not, my lord, unlike a second appeal where lordship, my lord, has, my lord, expressed, unless as a law point, your lordship has been averse to, my lord, admitting. This is, my lord, the first appeal.
We are notorious for dismissing first appeals at the first instance. No, we understand.
This is, my lord, a genuine.
Let us say.
Please, your lordship.
Yes, please.
The points which are involved here is the tenancy agreement which is in question, my lord, which has been executed by the mother. Well, first of all, the agreement was executed and has been admitted by them in the deposition. And they say that the point which they are agitating right now, that they were also party to that. He was a major son. He had attained the age of 30 at that point of time. That has been dealt with the impugned judgment. I will not go beyond the judgment, because in the impugned judgment, it says that he has attained the age of majority, and he did not, at any point of time, he did not raise any objection to the proprietorship. So the tenancy agreement which has been recorded, it records that this is a fresh tenancy. The father died, the dates are very important. The father died on February 17, 1992, and then a new tenancy agreement was executed in 1993, which has been marked as an exhibit. As my learned friend was saying, that has been marked as an exhibit. It is there.
How was it proved? Proved through them?
No,
what is the exhibit number? Do you have the exhibit?
Yes, number? I have the exhibit 7.
7 means your document, your exhibit.
Yes, ma'am. Exhibit 7. It's there in the judgment. I'll go through the judgments itself to indicate those points.
Yes.
Now, as far as they say that the trade license is concerned, the date is very important. The mother dies on 2nd October 2015, and they have procured a trade license which they have produced in the trial, that is of 23rd of September 2015, just before the death of the mother. And this has been dealt with in the.
Like when it said that 2007-8.
No. There's an observation in that regard in the impugned judgment. I'll show you that part of the judgment.
No trade license prior to mother's.
No. 23rd, it's prior, 7 days prior. 2nd of October, the mother dies. 23rd of September 2015, that has been disclosed. And that has been marked as an exhibit.
But it's still prior to the death of the mother.
It's
not a will that suspicious circumstances.
Definitely.
Something is there.
Something is there, but
if something is there that's fatal to you regarding this injunction.
But now I understand. But now, as far as the rent receipts are required to
their best point is the first point. Supreme Court now has held, upsetting the judgment delivered by Justice Banerjee and me, quite rightly, that if the right accrued prior to the coming into force of the 97 Act, then those rights prevail. Those cannot be overridden by this 2G new addition.
Yes.
So if that be so, even if there was an agreement between the mother and the landlord, can one of the joint tenants, because he became the tenancy devolved on both of them,
Well, he doesn't.
can his tenancy right be taken away without evicting him properly?
Well, I let me
That's the most crucial question here.
let me address this on this point. The impugned judgment records that for till 2015, he had never raised this objection till the death of his mother.
Non-raising an objection, does it tantamount to waiver? Waiver is a conscious relinquishment of a right, judgments. So there was no conscious relinquishment of their right. They might not have objected, they might have admitted that there was a signature of the mother. But that does not, if there was a relinquishment by them categorically, or it was a tripartite agreement, we could have understood. At least prima facie case has been made out for injunction. We can permit you to, we will permit you to file your opposition for the purpose of occupation charges. We'll grant the injunction. Otherwise, the appeal will become infructuous. We'll record your
let a
submissions.
limited stay be granted so that
Limited means we will be disturbed again by.
I understand.
No, we'll direct paper books and all, and
Because we have already filed
the injunction application we are keeping pending. We'll direct you to file opposition so that you can. The occupation charges may be a deterrent for them to continue law. And that is the purpose of occupation charges. So you disclose whatever materials you have regarding occupation charges. What is the area?
I think it's from 2019. I think 2019. The 2019 till
Purushottam, Bada Bazar.
Yeah, it's in Bada Bazar. Well, it's 125 square feet of area. Well, they pay 330.
You don't require an eviction degree. The occupation charges might be sufficient. So we don't want to predetermine this, but you disclose whatever documents you have.
We'll do so.
You find out the old tenancies and you find out the current tenancies, the receipts.
We'll
For your reply. Well, the present appeal has been preferred against a decree of eviction passed against the appellant, primarily on the ground that the appellant has been rendered a trespasser beyond the statutory moratorium period contemplated in section 2 within bracket small g of the West Bengal Premises Tenancy Act 1997 after the demise of his mother, the original tenant. For next para, learned counsel appearing for the appellant argues that the tenancy originally belonged to the father of the appellant, held in the name of the proprietorship firm of the father. First of the father died in the year 1992, whereafter the tenancy devolved jointly on the two heirs of the appellant's father, that is his mother and the appellant himself. Subsequently, a purported tenancy agreement entered into between the mother of the appellant and the respondent landlord was tendered to the appellant in his evidence, where there is a semblance of an agreement, a semblance of an admission on the part of the appellant as to the signature being of his mother. However, the document was marked as an exhibit without being properly proved. Thus, it is argued that the said so-called tenancy agreement could not have been relied on by the learned trial judge. Secondly, even if such a tenancy agreement was entered into, the joint tenancy rights accrued in favor of the appellant at a point of time before the commencement of the 1997 Act could not have been taken away by the subsequent introduction of section 2 within bracket small g in the 1997 statute. Next para, learned counsel argues that the premise on which the learned trial judge proceeded was that the appellant did not object to the tenancy agreement between the landlord and the appellant's mother, despite the appellant, at the relevant juncture, being a major and sufficiently capable of understanding the consequences of the same. It is argued that even if there was no specific objection raised by the appellant, the same does not tantamount to waiver of the joint tenancy rights of the appellant. Next para, learned counsel appearing for the respondent landlord contends that the father of the appellant died on February 17, 1992. Next para, thereafter, a tenancy agreement was entered into between the mother of the appellant and the landlord, giving rise to a fresh tenancy. Full stop. The said document, comma, it is submitted, comma, was duly marked as Exhibit 7 in the suit. Full stop. Moreover, comma, the appellant, comma, despite having full knowledge of the said tenancy agreement and being sufficiently aware of the consequences thereof, comma, never raised any demur or objection thereto, thus acquiescing to the position that a fresh tenancy was granted solely in the name of his mother. Full stop. In such view of the matter, comma, it is argued that on the demise of the mother, comma, the appellant's tenancy, comma, even if he was entitled as an heir at the relevant point of time, comma, has extinguished by operation of Section 2 within bracket G of the 1997 Act. So next para, lastly, comma, learned counsel for the respondent contends that the trade license produced by the appellant in the trial court was procured immediately prior to the demise of his mother, and as such, comma, is suspect. For the next para, upon hearing learned counsel, comma, we find several arguable questions involved in the appeal. So first, comma, since apparently valuable joint tenancy rights accrued in favor of the appellant upon the demise of the original tenant, comma, the father of the appellant in 1992, comma, it is arguable as to whether such right could be taken away by a bilateral agreement of tenancy executed between the mother of the appellant, comma, one of the joint tenants, comma, and the landlord, comma, in exclusion of the appellant. Full stop. Next para. Secondly, comma, in view of the tenancy receipts being granted for a substantial period in the name of the proprietorship firm of the father, comma, in effect, comma, since law does not recognize a proprietorship firm as a separate juristic entity, comma, it is the father of the appellant who is to be construed as the original tenant, and upon his demise, comma, the mother of the appellant and the appellant as joint tenants. So next para. Thirdly, comma, it is also to be appreciated on the basis of evidence on record as to how the tenancy agreement between the mother of the appellant and the landlord was exhibited and whether the same is sanctioned by law. So also, comma, in view of a trade license having been produced in the name of the appellant, comma, whatever may be its death, comma, the impact of the same on the lease at hand is required to be considered. Full stop. Next para. Accordingly, comma, a prima facie case for hearing the appeal on merits has been made out by the appellant. Full stop. Comma, entitling the appellant to injunction to stay, to an order of stay, in order to save the appeal from being rendered infructuous prior to hearing of the same. Full stop. Accordingly, accordingly, there shall be stay of all further proceedings of title execution case number 37 of 2026, comma, arising out of title suit number 58 of 2021, comma, pending in the City Civil Court at Calcutta till disposal of Can 1 of 2026. So next para. Another aspect of the matter is required to be taken note of. Full stop. It is well settled that while granting stay of the impugned eviction decree or execution proceedings in connection therewith, comma, the court, comma, as a norm, comma, imposes occupation charges commensurate with the current market rent which the subject property can fetch at the present point of time. Full stop. Accordingly, to grant an opportunity to the respondents to bring on record sufficient materials to impress upon the court as to what should be the current market rent at the locality of the suit premises, comma, the respondent is directed to file affidavit in opposition to Can 1 of 2026. What would be a reasonable time?
Well, it's 2 weeks, 2 weeks.
You'll be able to gather materials within that.
I think well, that's my
Yes.
Very
Within a fortnight from date, full stop, reply if any.
Within another fortnight, my lord?
No. Shall be filed within a week from week thereafter, full stop. Next pay, you get more than them. You start from now.
Yes, I will start from
Start collecting from
I
now.
know what I have to do.
Yes, you know. Both of you know. Within a week thereafter, full stop, the application shall next be listed for hearing on in the monthly list of September 2026, because this period will monthly list of September 20. Acha, the other things we are just putting in. In view of the appearance of the respondent through their learned advocate, service of notice of the appeal on the respondent is dispensed with, and the appeal be treated to be ready as regards service. Stop. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a fortnight from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. This much.
Great.
but I appear for the appellant. Now, my lord, suit for divorce was filed by the husband. Suit was decreed by the learned trial court. The wife has come up in appeal. Now, my lord, so far as the my lord, application for alimony pendenti liability, my lord, the husband, my lord, we both have filed our affidavit of assets and liabilities. Now, my lord, yesterday, my lord, lordship has heard this matter. Now, my lord, lordship, my lord, wanted me, my lord, to, my lord, about the affidavit of assets and liabilities of the husband. My lord, kindly takes up page 7 of the affidavit of assets and liabilities
Of the husband.
of the husband. Now, my lord, here, my lord, he admits, my lord, of receiving pension. My lord, he is a retired employee of the State Bank of India.
Hmm.
Admits, my lord, receiving pension of rupees 63,167. Now, my lord, if your lordship, my lord, kindly takes, my lord, thereafter, my lord, page 11 of his affidavit of assets and liabilities.
If you remember correctly, Mr. Bhagat took a point that you are earning.
No, my lord.
This is not that.
It is not her. It is not their case. My lord, I am admittedly a housewife. What my lord, learned friend, my lord, said was that, my lord, prior
continues
to
some
my
other-
marriage, my
Yes.
lord, prior to my marriage,
Yes.
my lord, I used to work as a teacher in a kindergarten school, my lord, for 10 months only. So, my lord, after marriage, my lord, I am a housewife. Now, my lord, if your lordship takes up page 11 of their affidavit of assets and liabilities, now, my lord, he has stated that he is getting pension of 63,167, but my lord, he has, my lord, not stated one thing, my lord, about his retirement benefits. My lord, he is totally silent over it. Then, my lord, being a retired employee of State Bank of India, my lord, he has received his retirement benefits. What he has only said is that he is receiving, my lord, some amount of interest from his PPF. Lordship would get that at page 12. My lord, point number 8, income from other sources, PPF account number such and such for last 3 year statements, income from interest from PPF as on 31st March 24 is 18,594, 31st March 25 is 20,908, and 31st March 26 is 23,292. But so far as his other retirement benefits, my lord, which he has received from his employer, my lord, there is no mention here. And my lord, my assets and liabilities, if your lordship takes up, my lord, I have asked for alimony pendenti liability to the tune of rupees 10,000, my lord, which I was receiving, my lord, before the learned trial court. The suit was decreed on 12th of December 2025. My lord, thereafter till March 2026, he has made payment, and thereafter, my lord, it has stopped. And my lord, my income I have stated, my lord, in my affidavit of assets and liabilities, that it is 10,000 rupees per month. My lord, that is what I want. Kindly takes up page 2, clause 7.
Yes.
Now, but I have given the breakup. It would include rent, household expenses,
And there is no
medical
child of the
bills.
marriage.
There is no child.
Right. So let us hear them then.
Lordship.
Yes, Mr. Bhagat.
My lord, kindly sees their affidavit of asset, whether it is, my lord, at all, the responses are at all, my lord, as per direction of the apex court or not, my lord. Kindly sees, my lord, page, my lord, page 4 of the affidavit of asset of the wife.
Yes. Yes.
Item 2.
Hmm.
Third line, my lord. That disclose if any independent source or income of the dependents, including interest income, assets, pension, tax liability on any such income, and any other relevant details, apart from the nominal interest, not spelled out. What is the amount? And, my lord, Loxi Bhandar grant of 1,000 per month. So it is to be, my lord, taken into consideration what is his income. Well, he has not vague nominal. That about, my lord, can be says. Income tax, my lord. He has not furnished 3 years income tax return. Bank statement has not been furnished.
Bank statement has not been.
Not furnished. That about incomplete and illegible, my lord.
Bank statement has been furnished, but it is in.
3 years. One single page, and this is also, my lord, illegible copy. And different name, because In one
Where
account,
is that?
My lord, prior to marriage, I was Shingo. After
let
marriage,
them
I
copy,
became
please.
Mujo.
Let us let
Lordship,
them.
I'm sorry. I'm so
that
sorry.
about my lord. What happened, my lord? In different
Where is that? Let us see that.
last annexure at page, my lord, 55 and 54, 55. 54 illegible copy starts from 52.
Your copy was deliberately kept illegible.
No,
Our copy is,
maybe uniform. Our copy is not illegible.
your copy is not illegible. Not legible or not
Our copy, what he annexed, not illegible. He yesterday live.
your copy of there, Mr. Bhattacharya, don't get so excited. Page 54, we are saying just in as a joke that your copy of this document has been kept illegible. Our copy is legible. Don't so overreact. Yes. Yes, Mr. Bhagat.
And 54 is, my lord, somewhat illegible, my lord. Our copy at least, so far out. And it is not a free.
So regarding the name, it's illegible in our copies.
Yes. I took stress to.
Yes, yes,
find
you're
out
right. What is the name, by the way? Dipti Mojumdar.
Deepti Singh and somewhere in Deepti Mojumdar.
Dipti Singh, prior to marriage, she might have been Dipti Singh.
Thereafter also Deepti Singh is using.
The bank account may continue.
And
It's more cumbersome to change your name in the bank account than to.
And age is different, my lord. Somewhere she has, my lord, from the Madhyamik Pariksha certificate, it appears she born on in 1955, and somewhere it appears 65.
It's your perception that mattered all this time.
My lord, so, my lord, it is.
Now there's a tussle between you and then therefore.
What happened, my
But
lord?
age is not a factor in bank.
But she, my lord.
But you are right, nominal interest that has been kept vague. And she has also mentioned stroke old age pension. We don't understand that also.
But that was the
No, we have not come to you. Please take your seat. There's a seat behind you. Take it. Don't jump up at the first. And ask your learned junior to take a seat also. Why should she be standing? Yes.
This is very much required, my lord, to assess whether.
So apart from this, anything else, Mr. Bhagat?
And my lord, we have suffered, my lord, criminal proceeding as well, my lord. What I am saying.
That is a different aspect.
For that purpose, my lord, they, my lord, implicated not only me but also my minor daughter, my lord, stepdaughter, in the criminal case.
How does that matter in alimony?
How she has.
He's not a 125.
Yes, sir. Then, my lord, unless and until this.
Your task is threefold: to contain Mr. Bhattacharya's anger, to contain our anger, and to continue learned friend. So
and also my adversary.
All three of us may become angry with what you submit. So be cautious on all fronts.
I say, my lord, this can too is not.
So therefore, they have not disclosed their income first.
Yes.
Secondly, their bank statement which has been given is not for 3 years, illegible, not in their name.
And also income tax return.
Not produced. All right.
And, my lord, no reply has been given to our affidavit in opposition, my lord. They have not denied it. Whatever contention we have raised, my lord, in our AO, they have not, my lord, denied it. By way of filing affidavit in reply. And, my lord, this disclosure of passage has not complied with the direction.
Yes, yes. Supreme Court.
So, my lord, this can too is not, my lord, maintained.
How is it not compliant? 3 years, these IT returns have not been given. 3 years bank statement.
Income has not been, my lord, disclosed.
All right. We don't have the copy of registration. And we don't know it by heart.
I have the.
No, on what counts? We are just asking that. One is that specific income not disclosed.
In IT returns has not been, my lord.
No IT returns.
And, my lord, the bank statement.
3 years bank statement is not there.
Not appended to the application. And age is also different, my lord. Summary it appearing.
Age is in Rajesh versus Neha. There is something about age.
My lord, whenever he.
Age where? In the bank account.
In bank account. I don't know, my lord, there are two age.
If you could not know for so long after staying with her, forget it. We are not concerned with her age.
Only, my lord,
age.
So far this application is concerned, income is the, my lord, vital. And we have already we have paid 16 lakhs by way of, my lord, maintenance.
Get ready to pay more.
No.
How much more that will
cost? Kindly consider whether they have at all disclosed their income or not.
Understood. Let us. Yes.
Only please kindly comes to my affidavit of assets and liabilities, page 6, my lord, 9. Lord, I have clearly stated that I have attached the bank statement for 1 year as the preceding 2 years could not be provided by the bank to me.
That is not an excuse.
But I could not get it.
That is not an excuse at all. Your bank did not provide
My
you
lord,
this.
whatever statements I
Where
had,
have you
my lord,
stated that?
my lord, kindly comes to 6, 9 furnish copies of bank statements of all accounts for the last 3 years.
6, 9.
My lord, the lordship is looking at page 6.
The page 6.
My lord, kindly
Balance
comes to
sheet.
9. Details attached for only 1 year. A statement of preceding 2 years could not be provided by the bank, and the same are enclosed here and collectively marked as Annexure C. And so far as, my lord, my age is concerned, I am 61 years old. I have stated that in my affidavit of assets.
We are not bothered with your age much. But what about this nominal income, nominal interest?
Well,
and all
nominal
this?
interest is
Kept
my
it vague.
savings bank account interest, whatever I am.
So what
getting.
is that from disclosing
Well, it
that
kindly
account?
comes to my savings bank, whatever my bank statement, my bank passbook I have annexed. My lord, balance as on 29th March 2026 is rupees 952.95 rupees only.
53.
So whatever my lord, savings bank interest I am getting from it, that is my
Oh, interest means bank interest.
bank interest.
And what you have by pen you have inserted stroke old age pension. What is that?
But that was the my lord, the grant given by the earlier my lord, government, my lord, which my lord, now it has stopped.
Lokhir Bhandar, apart from that, old age pension was also given.
Yes, my lord,
What
that
was
was
the
1,000.
quantum? You have not.
My lord, 1,000 rupees. I have stated the quantum there.
Lokhir Bhandar grant of rupees 1,000 by the government, stroke old age pension. So that Lokhir Bhandar itself is
The old age pension of 1,000 rupees.
Lokhir Bhandar was not given to young women.
Well, it was also given to my lord, the aged ladies also. My lord, to all my lord, classes of women. So I was getting it.
So why old age pension? You see your. ওটা ডিফারেন্ট সেটা তো আলাদা তো লক্ষ্মী ভান্ডার তো জেনারেল সব বাচ্চা মেয়েকে মানে ছোট মেয়েদের
My lord, that
Lokhir
one I have
Bhandar
to
is
take.
something different from old
But
age pension.
my lord, the entire amount is 1,000 rupees, which I am getting. My lord, that comes to my savings bank account. Lordship would get it.
You wanted to add something, Mr. Bhagat?
Now it is money enhanced to rupees 3,000. Yes, Annapurna Bhandar.
We don't know whether they are in the SIR. We don't know whether their name has qualified. We don't know whether they are close to the ministers.
As they have been, I'm gonna see.
How do you know that they are getting whatever?
But Lokhir Bhandar, they were.
Lokhir Bhandar 1,000 they were getting.
1,000. So and also.
We'll give that 1,000 to you. The rest of the amount you pay to her. You conduct yourself with that 1,000.
And this is our expenses, my lord.
Whatever.
My lord, kindly.
You cannot deny your wife.
Kindly consider the expenses. How I'm incurring, my lord.
So you have understood what we are going to do.
Yes, my lord.
You understood what we are going to do. That's why.
My lord, kindly don't.
Because there is no reply to reply. 10,000 is a meager amount.
No, my lord.
Definitely grant
He is not entitled to because, my lord, she has harassed us, my lord. Not only.
That is not a ground in section 20.
But, my lord, we have suffered. My lord, that is to be taken into consider. How?
No,
we
no,
have
this
been
is not at all to be taken into consideration. Mr. Bhattacharya knows, you know, Mr. Das knows, everybody here knows. In section 24, harassment will not be seen.
Then, my lord, only consider whether, my lord.
It's a fundamental right to harass the
Have not, my lord,
spouse.
disclosed the entire income. There you go. So, my lord, they are at
We'll
this stage.
take into account.
At this stage, she's not entitled to it. Unless she discloses all his incomes.
We deduct 1 point from your case if Mr. Bhattacharya stands up. We do it to my son. So Mr. Bhattacharya is like of same maturity. Whatever wants to add something.
I have taken loan.
No, you take instruction from you. You have taken loan, you will repay it. You have taken loan, it's your choice. So Mr. Bhattacharya wants to add something. Let him finish.
Daughter, my lord. I am paying, my lord, 19,000.
She's not asking anything for daughter. It's your noble duty as a father to pay for it.
How I'm incurring these expenses.
Incur that. He was saying something, ask him. So that no stones are left unturned. Otherwise, those will be thrown at the judge at the end. দেখো প্যাশনেট হয়ে যায় আমার আদার সাইড অনেক
What my
yes tell it no
instruction is this, my lord. Either, my lord, the Rajneesh Neha's decision is to be followed.
either
The direction given in the Rajneesh versus Neha case, my lord. They have not complied with. So, my lord, unless and until it is complied with, they are not entitled to.
Rajneesh versus Neha, what is the citation? Just give us.
It's to 2021. Volume 2 SCC 324.
324.
Lordship, I have a copy of it.
Yes. Keep it with you. No.
And there is, my lord, enclosure one, that is for non-aggregation asset of affidavit to asset. What are the contents of that my lord, affidavit? It has been specifically mentioned, my lord. And these are mandatory. So they have not, my lord, complied the mandatory direction of the Honorable Apex Court.
The present appeal has been preferred against a decree of divorce obtained by the respondent husband, comma, at the behest of the appellant wife. Sub next para. In support of the alimony application, comma, learned counsel for the appellant argues that the admitted pensionary income of the respondent husband is rupees 63, 167 oblique dash per month. Sub next para. Learned counsel submits that throughout the pendency of the suit in the trial court, comma, an amount of alimony to the tune of rupees 10,000 was being paid per month by the respondent husband to the appellant wife. Full stop. In all fairness, comma, it is submitted that such amount has been continued to be paid till the month of March, 2026, although the divorce decree was passed in December 2025. So next para, learned counsel submits that the appellant wife claims alimony at the same rate during pendency of the present appeal as well. Full stop. In support of his submissions, comma, learned counsel points out that although the husband has disclosed his pensionary income, comma, the retirement benefits obtained by the husband at the time of his demitting office from the State Bank of India, has not been disclosed. Full stop. Next para, thus, comma, it is argued that it should be presumed by the court that the husband has in his hand a much larger amount than disclosed in his affidavit of assets. For some next para, learned counsel appearing for the respondent argues that the appellant wife, comma, in her affidavit of assets, comma, has stated that she has income from nominal interest, nominal to double inverted, comma, without disclosing the exact amount of such interest. Full stop. Moreover, comma, the statement of her bank account has been furnished only for one financial year, comma, contrary to the judgment of the Honorable Supreme Court in Rajneesh versus Neha, reported at 2021 to SCC 324. Full stop. It is further pointed out that the affidavit of assets filed by the appellant wife is not in consonance with the format as prescribed mandatorily in the said judgment. For example, comma, the non-agrarian income has not been disclosed in proper format, and there are other discrepancies as well. Next para, the bank statement furnished by the appellant wife, comma, it is submitted, comma, is illegible in certain portions thereof and is insufficient compliance of the proposition laid down in Rajneesh versus Neha. Moreover, comma, no income tax returns of the appellant wife has been furnished before this court, comma, nor is there any affidavit in reply filed to the affidavit in opposition filed by the respondent husband. Full stop. Next para. Upon hearing learned counsel for the parties, comma, we find that there are certain deviations from the principle laid down in Rajneesh versus Neha on the part of both parties. Full stop. The wife's affidavit of asset is not in exact tune with the format given in the said judgment. Full stop. On the other hand, comma, we find it.
I retired in 2015, my lord, so I need not to furnish that information about my retirement benefit. Can you consider this aspect?
Ki bollam? Just last. We find that the retirement benefits of the respondent husband has not been disclosed by him. So, although the respondent argues before us that he retired in the year 2015 and as such, such benefits need not be disclosed, fact remains that retirement benefits are a concomitant of the accrual of pensionary rights of the respondent husband. Retirement benefits, if any, received by the respondent husband, even if in the year 2015, must have been either invested or spent by the husband. In the event there was an investment, the interest from the same ought to have been disclosed. Thus, there is no reason as to why we should not draw adverse inference on such count against the husband. Next para, insofar as the appellant wife's disclosures are concerned, although 1 year's bank statement has been filed before us, an explanation has been given in the affidavit of asset to the effect that the prior 2 years accounts statement could not be obtained from the bank. Next para, even without going into the veracity of such allegation, sufficient indication of the income of the wife is reflected in the statement of accounts produced by the wife before us. Next para, we find therefrom that the bank balance of the wife and her regular income is meager, not sufficient to maintain herself. Although the law laid down in Rajneesh versus Neha mandates parties to disclose their incomes and liabilities, the exact format of the affidavits contemplated therein, if not followed, does not necessarily constitute an illegality so high as to vitiate the entire disclosures. Next para, as discussed above, there are certain discrepancies on the part of both parties, and as such, we do not lend much weight on such discrepancies, since the materials before us are sufficient to come to a conclusion as to the incomes and liabilities of the parties. The pro forma given in Rajneesh versus Neha, although otherwise mandatory, may not be adhered to strictly to the letter for the court to arrive at a ballpark figure of maintenance on the basis of the disclosures made by the parties. Next para, it is well settled that even if both parties suppress some of their incomes, the court would be entitled to resort to a reasonable guesswork to arrive at its own findings in that regard. Next para, even otherwise, the amount of rupees 10,000 per month which has been claimed by the appellant wife as alimony pendentility per month is an insubstantial amount, which is absolutely the bare minimum required by a person in modern days to maintain herself. The appellant wife all along used to get such amount during pendency of the suit in the trial court, which was never successfully challenged by the respondent before any forum. Thus, there is no.
We have challenged, my lord. We have challenged that amount.
What happened to that challenge?
My lord, initially it was 12,000. It was decreased to 10,000. And your lordship also adjudicated once upon a time one civil reason.
Not successfully challenged before this court. Next para. Since as such there is no reason to deprive the appellant wife from the said amount at the appellate stage. Next para. Accordingly, can 2 of 2026 is allowed, thereby directing the respondent husband to pay alimony to the tune of rupees 10,000 per month to the appellant wife. Such the first of such current amounts shall be paid for the month of August 2026 by the 15th day of the said month, and thereafter by the 15th day of each succeeding month, comma, for such current month. So next para, the arrear amount of maintenance, comma, calculated at the rate of rupees 10,000 per month between April 2026 and July 2026 shall be paid by 2 equal monthly installments, comma, the first of which shall be paid by August 31, 2026 and the second by September 30, 2026. Full stop. Next para. Paper book directions have been given.
That has been given.
No address to cost. Those will be adjusted, you know the law, Mr. Bhattacharya. The higher amount will be paid by you.
That is also I have stated in my.
What can be done? Great. Yes. The direction is already there. You said. Next. Yes.
My lord, I'm on behalf of it's number 125, my lord, I'm replying Mr. Jyoti. So he is busy.
He was just here.
He's waiting all morning. He was waiting, my lord.
Then we'll adjourn for the day then.
Lord, may I? कल की कौन?
कल के तो है.
Whenever you say.
The only problem that I have is below they've started demolishing the property.
Oh.
Tomorrow, my lord.
Not it may be day after if it's possible, but in the meantime, let them not demolish the property.
If they demolish the property, then day after should be tomorrow then.
But
he wasn't visible.
Today he is. Today. No. If the demolition is going on, it should be tomorrow. Why day after?
But I can't oppose Mr. Kaur. Tomorrow there is one of my problems. I will not be visible. That's my main problem.
Oh, achha.
But day after I'll be visible before your lordship.
We're adjourning for the day. Tomorrow and day after tomorrow we take up hearing matters.
That's my problem, my lord. This will go off to Monday.
Yes.
That's where my problem lies. I knew that. That's why I said, below that if in the meantime they start demolition.
They already started.
But below, can Mr. Kaur come back?
We are keeping it tomorrow as specially fixed. Day after tomorrow as specially fixed.
Very well.
An adjournment is sought on the ground of the respondent number 1 to 5. Push up next para. However, learned senior counsel appearing for the appellant pleads extreme urgency in the matter as allegedly demolition of the subject property is going on. Push up next para. In such view of the matter, let the matter be listed on July 23, 2026 as a specially fixed matter.
Okay.
No difficulty.
Great for that.
No, I am supporting Mr. Chatterjee.
That is my main problem. That is my main problem.
No.
Yes, Milord.
What is your main? You have several main problems. Yes.
Mr. Chaudhary, Milord, is
Chaudhary is one of them only.
Mr. Chaudhary is one of the major ones.
He is one of the major ones, right?
Major ones.
He doesn't know my comment yesterday.
So it's a quid pro quo between the two of you regarding being a problem.
Milord, for me, Milord, I'm very innocent.
Mr. Banerjee is making fun of you by smiling sheepishly. Yes.
Which Mr. Banerjee, Milord?
Siddhartha Banerjee.
Right, I was
I'll tell your lordship separately, Milord, when I meet your lordship.
Yes,
yes,
on a different occasion.
On a different occasion.
Next, yes.
Lordship, I am for the appeal.
Yes, please. What is it? What is the defect? There is a defect.
Lordship, in this matter, I am challenging the.
What is the defect in the appeal?
Defect is decree in the preliminary form has been passed
removed. Sorry.
In violation of law. Because Lordship.
No, not that defect. There was a defect in the appeal that has.
Lordship, this has been cured.
Yes. What is the appeal against?
Lordship.
There is no caveat.
No caveat has been.
Right. Yes.
This Lordship, this order has been passed in violation of law. Because this is a partition suit has been filed by the plaintiff I am defendant.
Preliminary degree has been passed.
Preliminary degree has been passed.
We are passing the usual order. The final degree won't be drawn up. Final degree proceedings will continue, but final degree won't be drawn up.
Lordship, if your lordship kindly sees, this order is not sustainable in law because the order has been passed in violation of law,
What law?
misapplied the law. Because lordship, if your lordship kindly sees,
Tell us why in violation of law, then we'll look into it.
lordship, the plaintiff claim right title interest by relying upon the CS record of rights.
Only, no title deed.
Title deed, plaintiff has the title deed, but CS record of rights owner has given this according to the plaintiff. CS right, the name which is in the CS record of rights, who has given that, who has transferred the land to the predecessor of the plaintiff, and by which they claim right title interest. Lordship, CS record of RS record of rights thereafter West Bengal, according to West Bengal State Acquisition, RS record of rights has been created, and RS record of rights is in the name of the mother of the appellant number 1. Is in the name of the mother of the appellant number 1, and which is according to law the mother, and thereafter the appellant has been
decided in the appeal. This is not a pure question of law. Has to be decided in your appeal. The appeal is there.
No, this question has been decided in favor of the plaintiff.
How?
Because the
This judgment.
In this judgment.
That is subject matter of the appeal. We'll have to decide when we hear the appeal. We have to decide it at this stage. The present appeal has been preferred against a preliminary degree of partition. Full-stop learned counsel for the appellant submits that the impugned judgment is vitiated by error of law inasmuch as the plaintiffs, in your memorandum you have stated appellant's plaintiffs.
No, appellant, what a mistake, mistakenly this has been mistake.
So many
Defendant, this will be defendant.
And respondent's defendants you have written. So reverse that, we'll give you the leave. Inasmuch as the plaintiffs relied on a title deed executed purportedly in favor of the predecessor in interest by a vendor whose name was recorded in the CS records of rights, comma, whereas the RS records of rights, comma, subsequently in vogue, comma, stood in the name of the mother of appellant number 1. Full stop, next para. Apart from the above questions, comma, a question, comma, other arguable questions have been raised, comma, both on fact and in law in the appeal, and as such the appeal is required to be heard on merits. Full stop, a prima facie case having been made out, comma, we direct the learned trial judge to continue with the final degree proceedings, but not to draw up any final decree without the prior leave of this court during pendency of the application. Full stop, the appellants shall serve copies of Can 1 of 2026 on the respondents, indicating that the application shall be listed in the monthly list of September 2026 when an affidavit of service shall be filed by the appellants.
Lordship, may I pray, Lordship, kindly this
Paper
matter,
books and all.
kindly fix this matter on the daily supplementary list, Lordship.
No, all the same before us. Supplementary list and combined list both are. আচ্ছা বাকি কয়েকটা জিনিস দিয়ে দাও ঠিক আছে the trial court records shall be brought by special messenger at the cost of the appellants, comma, to be deposited within a fortnight from date. Full stop, next para. The trial court shall be entitled to retain a skeletal record for the purpose of proceeding with the final degree proceedings. Full stop, next para. The appellant shall also deposit postal costs, written up notice forms, and due requisites for service of notice of the appeal on the respondents, comma, within a fortnight. Which of the appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appeal. Those directions we have passed to expedite the appeal.
Lordship.
And in the meantime, you serve and come back.
Lordship.
Yes. Next.
Lord, I appear for the appellant, but this appeal, my lord,
I appear for the respondent.
Yes.
my lord, arises out of an order by which
my application, my lord, my learned senior friend's application for revocation of the probate obtained by me has been, my lord, allowed. And as a consequence, my lord, probate has been granted. My lord, for that, the appeal, my lord, praying for stay, my lord, this is a my lord, application for stay.
What is your ground? I mean, the
Yes.
probate was obtained in by you.
My lord,
Revocation. Why revoked?
So, my lord, the primary ground is that they, my learned friend's client resides in, my lord, London. My lord, they were not cited. They had a subsequent will, which from the same testator, and my lord, that has been, my lord, already probated, my lord, before a competent court in London. My lord, I will show, my lord, kindly reads, my lord, the impugned judgment. My lord, there is not a single line of finding regarding non-citation. Kindly see.
What have you asked for here? Injunction?
A stay of, my lord, stay because revocation has been allowed, and my lord, কি 27 তারিখ কবে date আছে বলুন?
Stay of the
grant of probate.
Stay of the
operation of this order.
Stay of the operation of this order will mean the grant will revive, which would be allowing your appeal before hearing it. You can't stay. File a proper injunction application, we can consider. Or we can, in this application, the court will ask both parties to maintain status quo regarding the position. But in a stay, we won't be granting.
Very well. Your lordship will allow me 5 minutes time.
Definitely, why not?
Then, my lord,
let him complete. Then
my lord, let me place the judgment. Kindly see the memorandum of appeal. এটাই তো আমারটা। Kindly, my lord, takes up, my lord, page 10 of the impugned judgment, decision with reasons. Kindly see, let me place. This is a case where two wills have come before the court, and this court is to see whether the probate granted by this court in respect of the first will be
subsequent will was probated.
Yes.
So then, in any event, your probate goes. If the subsequent will is
my will, my lord, is also probated.
Subsequent will prevails.
Yes, that is there. That is
what
there.
Case do you have in any event?
No, but exactly so. My lord, subsequent will has which has been probated in a competent court of London. In London,
it is not binding.
No, not at all.
Is there any distinction between London law of probate?
Yes, my lord, that is, there is a bar in the statute itself.
Section একটা দিন উপরেরটাই
CPC ono CPC টা আমার ক্লার্ক কে বলো দিয়ে দেবে
which section?
my lord, 228.
This does not say that the probate will not be conclusive. Suppose a probate application, a will is there, probate application is filed. 211 read with 13 empowers the executor to proceed. So will is not there is not this is not a bar. When a will has been proved and deposited in a court of competent jurisdiction which has been probated elsewhere, and a properly authenticated copy of the will is produced, they produce an authenticated copy. Letters of administration may be granted with a copy of such copy. Exactly. This does not say that per se the will go.
No, my lord. Why, my lord? Because why, my lord, this additional layer of protection was given, my lord, to find out whether the probate was at all an authenticated one. Because it was, my lord, probated, my lord, at in a foreign country. My lord, this same provision is also there in section 13. One. Number two, they have given, my lord,
in section
13 of the civil procedure. Yes. Now, my lord, we are not aware because they have given, my lord, the name of a court. My lord, we do not aware, my lord, whether that court is at all the appropriate court. We were also never cited. We were sisters. We were also never cited there.
You should have come prepared with the law in that country or that county. It's England or
England.
Different countries, counties may have different laws.
Definitely. Whether, my lord, that
I don't personally, we don't know whether
I have to do some research on that. One. Number two, my lord, whether that is, my lord, even, my lord, inferior to the district delegate, we also do not know. That says a court of registry.
Inferiority may not be an issue.
Ground.
If it's a competent court under that jurisdiction, that is sufficient.
But kindly appreciate their ground was non-citation of summons. Kindly let us confine also on that ground how they have how the learned trial judge has decided that. Kindly see from paragraph 10.
No, they were otherwise also heirs of the testator.
Yes, from the first wife. We are from the first wife. They are from the second wife. Not a single line. Now, we have taken a specific ground,
Suspicious circumstances is one of the premises.
That is the only premise. Kindly, if your lordship would kindly takes up my ground in the memorandum of appeal. Cut the copy.
Come to 4.9.
Yes.
4.9.
Yes, my lord.
Page
Yes.
12. Please read it.
Thus it appears Chobi Vishnu Majumdar obtained a probate in Miss case and could not satisfy this court that she was served with the notice of the probate proceeding and the appropriate citation to the legal heirs of the deceased Amarnath Bose. But this is the only line. But why the learned trial judge came to the finding? There is no nothing. Kindly comes to my memorandum of appeal. Once kindly see the grounds. Kindly
there is doubt that Pushpa Bose, Sukumar Bose, and others are legal heirs of deceased Amarnath Bose, and the same is not denied. The existence of the subsequent will do revoke earlier wills. Both grounds.
Yes. Kindly see my ground in the memorandum of appeal. Kindly similar ground number 4 and 5.
What are those? Tell us.
Yes. Kindly, we have taken a specific point. Kindly see paragraph 4. Further, the learned judge of the court below are in law by revoking the probate granted on 23rd June 2024 in Miss case number 219 of 2011 P, thereby revoking the probate of the will and testament of the will dated 18 February 1976 executed by late Amarnath Bose without appreciating that.
You had cited.
Exactly so.
They were parties to the probate.
They refused. I have the order sheets of
this was not considered. That is
not at all.
Let us hear Mr. Court.
Even kindly see next ground. Kindly see 5. This was special citation. This man general citation.
Let us hear Mr.
Ajkal also.
Yes, Mr. Court. What do you say? Why shouldn't you say that a prima facie case has been made?
A short list of dates. It will help you a lot.
Mr. Court, we are not hearing the appeal. Just precisely why on the grounds taken by the citation was not discussed by the
Lord, one point your lordship will kindly.
Yes.
They are claiming under the first will, and I am claiming under the second.
PW3.
The first will is dated 18th February 1970.
Your will is subsequent.
No, I am not on that. When was the application filed? 23rd March 2011. Date is 83.
We don't find the ground, that ground in the judgment, impute judgment.
Lord, limitation.
This is a new ground you are
taken
taking.
before the court.
This was available before the probate court, which should have taken it. A revocation is not exactly an appeal against the probate taking.
No.
So if the probate, yes.
The application itself is the application for grant maintainable.
No, that whether you can, because that application has been granted by a court, competent
Yes,
court.
Lord. Rightly or wrongly.
Revocation grounds are limited as per the statute.
263.
263.
I'm aware.
You cannot reopen the entire judgment by invoking this limitation and all. Then you could have prepared an appeal against the probate with leave.
Under the Limitation Act, because the ground of limitation is
Need not be taken. Section 3
Yes,
says court has
Your
to.
Lordship.
But whether you can reopen that aspect now without preferring an appeal against the probate decree, this revocation is limited to 263.
Lord, there are two grounds I am taking.
Then it's arguable, Mr. Court. Let this be decided.
Two grounds I am taking.
We are granting status quo regarding the point. Very arguable grounds. One is limitation. The second is?
Second is by the second will, first will has been revoked.
Second will, he raises some doubts as to what is the binding effect of that, of the second will. What is the law there?
Not with the same as in the first will. If the first
No,
will,
it was probated in London. So we don't know the law regarding
My lord,
that has not been discussed also by the tribe.
my lord, if your lordship
How far
sees,
that is binding?
if your lordship sees the judgment, my lord,
Mr. Kaur, you know as per section 13 CPC, if there is no conflict between the two laws, then very well. If it's not an enemy country, if there is no conflict in the law, then that is binding on us. We start with the presumption of binding. But nothing has been discussed to that effect.
my lord, in the limitation has not been at all.
These are arguable questions. We'll hear the appeal. We'll take these points. Now, for the time being, maintain status.
Very well, my lord.
We'll take note of your arguments, definitely. Right now, we're taking note.
Very short reply. If your lordship kindly comes to page 8 of my application.
What?
Limitation.
It won't come to anything. You tell.
Very well.
You tell us.
One, my lord, paragraph, my lord, I have stated paragraph 7, though the original will was in custody of the applicant all along, she could not file probate application for getting probate of the will in your honors court because she could not produce the death certificate of the testator so long since the death certificate has been obtained recently because the testator had, my lord, expired in London, we were in India. One, number 2, my lord, kindly see, my lord, this is the affidavit in chief of my learned senior friend's client in the revocation application. My lord, their case, my lord, in the application proceeds for non-citation of summons. In the affidavit in chief, not a single line stated regarding non-citation.
The present appeal has been preferred against the revocation of a probate granted in favor of the appellant. First of learned counsel for the appellant argues that although the primary ground of revocation was non-citation of the respondents, in the affidavit of examination in chief of the respondents witness PW3, not a single line has been devoted regarding non-citation. So also, in the impugned judgment, it is argued, non-citation has not been dealt with by the learned trial judge. Full stop, next para. Secondly, it is contended that the learned trial judge also proceeded on the premise of a subsequent will purportedly executed in favor of the respondents by the self-same testator, which was allegedly probated in London. Push up, while considering the same to override the earlier will in favor of the appellant, the trial court, it is contended, failed to take into account the legal effect of such probate granted by a London court and did not go into the corresponding laws of both the countries in that regard to ascertain the binding effect of the same within the contemplation of section 13 of the Code of Civil Procedure. Full learned counsel also argues that section 228 of the Indian Succession Act 1925 envisages letters of administration to be granted if a properly authenticated copy of a will is produced, if probated beyond the limits of India. For next para, learned counsel for the appellant thus submits that arguable questions have been raised in the appeal and the impugned judgment ought to be stayed. For next para, learned senior counsel appearing for the respondents controverts such submissions and places reliance on a short list of dates indicating that the purported first will, of which probate was granted in favor of the appellants, was executed on February 18, 1976, whereas the probate application was filed only on March 23, 2011. Full stop, next para. Thus, the probate application was palpably time barred, even taking into account the provisions of Article 137 of the Constitution of the Limitation Act. Full stop, next para. Learned senior counsel contends that the question of limitation need not be argued for the court to mandatorily consider the same within the contemplation of Section 3 of the Limitation Act. Full stop, next para. Secondly, it is contended by learned senior counsel. What was the second point you have missed? Just indicate sitting. You can sit and
Revocation. of the first will by the second will.
Yes, thank you. Please. Secondly, it is contended that by dint of a probate having been obtained of the subsequent will executed by the testator, the first will, of which probate has been revoked by the impugned judgment, is overridden. Full stop. Upon in reply, learned counsel for the appellant contends that sufficient explanation for the delay in preferring the probate application has been furnished in the probate application itself. To the effect that due to the demise of the testator in London, the death certificate of the testator, which was a mandatory prerequisite for filing the probate application, could not be obtained by the appellants in due time. For next para, upon hearing learned counsel for the parties, it transpires that several arguable questions, as indicated above, have been raised in the appeal, which are triable questions to be considered at the final hearing of the appeal. Full stop. Thus, a prima facie case has been made out to pass interim protection. Full stop. Next para. Be that as it may, grant of stay of the impugned judgment within bracket deemed decree bracket close of revocation would tantamount to reviving the probate, effectively allowing the appeal prior to hearing the same on merits. Full stop. However, in order to protect and preserve the subject matter of the will, we hereby direct both parties to maintain status quo with regard to the property which is the subject of the disputed will till disposal of the appeal. Full stop. Next para. Can 1 of 2026 is accordingly disposed of without any orders to cost in view of the appearance of the respondent through the learned counsel, service of notice of the appeal on the respondent is dispensed with, and the appeal be treated to be ready as regards service. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing.
Mr. Trivedi, indulgence, the last order which was passed by the trial court was to submit the probate and revocation after revocation. If this order is not stayed, ওদের ওপর ডাইরেকশন of the
import. Yes. Well, however, যেখানে can is such allowed that Mr. Cod, we are staying the last portion of the order where they have been directed to be personally present and file the certificate of probate for the purpose of revocation.
No, they are in London.
There?
আমাদের দিয়েছে আমরা প্রোবেট নিয়েছি we have probate we are
they were
directed to be deposited in.
However, since the appeal is pending before this court, we stay the operation of the direction incorporated in the order dated July 9, 2026, passed in Miss case within bracket revocation bracket close number 186 of 2015 to the limited extent that the present appellant has been directed to be personally appear and file the certificate of probate before the said court. Shall remain state till the disposal of the appeal.
Objection, my apologies, my lord.
Please hand over a photocopy of this and give a photocopy to Mr. Cod also. Because he
PW3 এর এটা
he requests to see what on the basis of what we have.
PW3 এর ওইটা
that give it. Next.
May I take back my copy of PW3, my lord?
PW3 কি আছে দেখি. Whatever you handed, no, PW3 you have not referred, you can take. But this order, please give a copy.
Yes, please. Yeah. My apologies, my lord.
Accepted.
Item number 14.
Yes. Thank you. Yes, Mr. Bose, what is the matter?
Your Lordship, I
As a
beg to
caveat,
appear
my
for
lord,
the
I am
respondent
my
number one.
affidavit of service. This is a caveator is the appellant.
Right.
From an order.
Caveator is the?
Caveator in the court below. Caveator opposite party in an application for grant of probate is the appellant.
Yes.
Probate granted. Two applications to be. It's a first appeal. My lord. There are two applications in the list. Can one is an application for stay of operation. Can two. But there was a deficit court fee. The matter appeared before the Lozima bench. The court fee was put in, but it comes to 33 days instead of 30 days since it's.
We're condoning the delay and accepting the deficit code. First, we're allowing Can 2. Can 2 of 2026 is an application for acceptance of the belated deposit of deficit court fees on condonation of delay in filing the same. First of being satisfied on the reasons shown in the application, Can 2 of 2026 is allowed, thereby accepting the deficit court fees deposited late on condonation of delay in depositing the same. No address to cost. Can 1, yes. What is your ground, main ground? Prima facie satisfying asset.
Will is said to be drafted by.
1 second. Affidavit of service filed to be kept on record. Yes, will settle.
Will is said to be drafted by Advocate X. The will is executed on a day and narrates incidents, including registered documentation, which happens after the death of the advocate. I have proved the death certificate of the advocate saying he dies on a day, events post that day mentioned in the will. Clear case that the father was confined and not available for even meeting the other children.
Will might have been drafted by the advocate prior
How
to his
could it
death.
be? How could the deed number, volume number, book number, everything be there?
Achha, in the will it's mentioned.
Yes, will record certain registered documents which are brought into existence and registered subsequent to the death of the advocate alleged to have drafted the will.
Subsequent to the death of the advocate.
Yes.
Yes. And what else? That is the main.
That no, there is the case of confinement, interested witnesses, the attesting witness who has been examined is the employee.
Yes, what do you say?
Your Lordship, we have complied with everything that is required.
Section 63, Section 68.
We have examined the
suspicious circumstance. This was not dealt with.
The suspicious circumstances. What he's saying, he is also one. He's also appointed as one of the executors in the said will. He's also been bequeathed properties, as we can see in the judgment. If you Lordship,
just because he has been appointed, suppose if I manufacture a will which goes against you, I can put you as one of the executors there. If he was the sole executor, then evident that trust was reposed on him, it was genuine.
But your Lordship, what happens is that whatever the story of confinement that his appellant, the appellant has taken in the lower court, is a matter of contention because case and counter case has been lodged by both the parties.
It says that has to be decided in the appeal.
Now, the fact remains that why we are discussing with the appeal is that because the application does not disclose any grounds.
Application did not disclose any ground.
It didn't. So we
That
have
will be
to
the
go
memorandum.
on the merits. Your Lordship. That is why I'm going on the merits.
Heard learned counsel for the parties. The
But your Lordship,
present appeal challenges, we are granting status quo regarding the property, both parties to maintain that. Stay, Mr. Bose will not grant because it's a judgment in rem. It has other ramifications.
But then he can't use the probate.
No, you can't.
If there is no stay of the operation and if he gets the probate, he will
Mr. Bose, he cannot deal with the property in any manner. That is the best we can do.
might as well cannot be dealt with because the
Achha,
property.
the present appeal has been preferred against the grant of probate in respect of a will. The present challenge has been preferred on several grounds. Learned counsel for the appellant argues that it is a clear case of confinement of the testator, which is borne out by the fact that the will contains full particulars of certain documents which came into existence only after the demise of the advocate who allegedly drafted the will. Next para, that apart, it is argued that there are other suspicious circumstances in the execution of the will, Full stop. Next para, learned counsel appearing for the respondents argues that the will was duly proved in accordance with law, and as such, the appellant has failed to make out any prima facie case. Full stop. However, comma, upon hearing learned counsel and
If I may ask for a indulgence, your lordship,
Yes, yes.
kindly record my submission
yes,
that he himself has admitted during his cross-examination that he has
be-
never lived with the testator since 2013. He was not materially
2013.
2013. He was not materially aware that he was not aware that the testator, he himself admitted that the testator suffered from no illnesses, died of natural causes. Kindly records this.
Learned counsel for the respondent further argues that the appellant admittedly did not reside with the testator since 2013 and was not aware of
He himself admitted that the testator suffered from no illnesses, terminal or
and also admitted that the testator did not suffer from any ailment or inability. So next
even during the execution of the
whatever
will.
it is. তারপর কি বলুন? The last. We find that sufficiently strong prima facie case has been made out since the above questions are arguable ones which are required to be decided at the final hearing of the appeal. Full stop. We are loath to grant stay of operation of the impugned judgment at this stage, comma, since the same is in the nature of a judgment in rem. Full stop. However, comma, in order to preserve the subject matter of the disputed will, comma, we direct both parties to maintain status quo as regards the properties which are the subject matter of the disputed will till disposal of the appeal. Can 1 of 2026 is disposed of accordingly without any orders to cause in view of the you're appealing for all the respondents?
No, Your Lordship, I am
One.
appearing for
In view of the
one
appearance of the plaintiff, the others participated in the
sisters. Yes, they filed written statement, but no
they
evidence.
have someone file wakalatnama for them. But we'll have to you have to put in issue notice. You have to. Don't make the collusion too obvious. No, in view of the appearance of the plaintiff stroke respondent number 1 through their learned advocate, service of notice of the appeal on the said respondent is dispensed with. The appellant shall put in postal cost requisites and written up notice forms for service of notice of the appeal on respondent numbers 2 to 4 within a fortnight from date. The trial court record shall be brought by special messenger at the cost of the appellant, also to be deposited within a fortnight. The appellant shall prepare and file the requisite number of usual time, 8 weeks, date of service of notice. Liberty to mention for enlistment when ready. প্রথমে একটা affidavit of service filed to the court. Great. Thanks. Yes, respondent.
Respondent. The last occasion, Lordship, my lord.
We are directed to go out of the list.
Yes, my lord.
Our list is
Perhaps on their mention.
এই যে আউট অফ দ্য লিস্ট হচ্ছে আবার মেনশন করেছে মেনশন স্লিপ কই ওটা দিন পুরো ফাইলটাই দিন আমায় Yes, what is the matter about?
My lord, we are the judgment debtor, my lord.
In a suit for?
But suit for title suit, my lord declare evict suit. They filed the eviction for suit, my lord.
Eviction on the ground that you are a trespasser or license?
Yes, my lord, we are the test.
What is your ground in the appeal?
My lord, ground is only one point.
Please use the microphone, ma'am.
Yes, my lord.
Yes.
My lord, only one ground. The learned trial could not consider my original rent bill, my lord.
Rent bill you produced?
Yes, my lord.
Which exhibit?
A, my lord.
Yes, did not consider at all or?
No, my lord, no, at all.
Oh, acha.
They,
Such a short judgment.
Well, they filed the already execution petition by execution, mis-execution. The next date is 17th August, my lord.
No, it was considered. Please come to page, please, Mr. Bose, what is it? Please come to page 6, ma'am, of your impugned judgment.
Yes.
Exhibit A is fully, that is the consideration under issue number 4 and 5.
Yes, my lord.
So you say it was not considered? Considered and dealt with. In cross-examination, you stated that Exhibit A is issued by Promila Dotto on behalf of Narottam. Narottam was the landlord.
Yes, my lord. Narottam is my landlord, but I am the Potima Singh, the daughter of the Nepal Singh. They could not consider the
No, you
Nepal
don't
Singh.
understand. You are Pratima Singh.
Yes, my lord.
In
I-
cross-examination, DW1, you are DW1.
Yes, my lord.
You
Yeah,
stated that Exhibit A is issued by Promila Dotto. Promila Dotto. On behalf of Narottam Dotto. Acha. Who is Promila Wala Dotto? There is
Narottam Dotto and Pomila Dotto is the only.
your landlord was Narottam.
Yes, my lord.
Narottam did not sign the rent receipt, so it was disbelieved by the trial court. What is the difficulty there?
No, my lord. I am the Pratima Singh, the tenant of the Narottam Dotto.
Yes, but Narottam did not execute that rent receipt.
Yes, he executed the rent receipt and
Your finding of the court, you are saying yes, you have stated in your evidence that it was issued by Promila Dotto. It was signed by P. Dotto. You say that it is Promila Dotto in your evidence.
Madam, kindly take a short adjournment. I am
No.
direction
No.
of the.
No. You satisfy us on this point? You have to make out a prima facie case at least. Not at the drop of a hat. Eviction of a licensee, I mean, trespasser, not at the drop of a hat.
Madam, kindly short date, my lord. My lord.
What short
I
date?
have-
Why? Whenever the court goes against you to seek a short date, you have argued. We'll come back after recess. We'll continue with this. We get prepared in the meantime.
3.
No, 2. Why 3? 2.
Fixed matter.
Where?
Because the Justice Ajay Kumar assigned matter from 2 p.m.
You get your adjournment due to him.
My lord, kindly fixed.
The hearing of the application cannot be concluded before recess. Full stop. Learned counsel for the respondent submits that he has some difficulty immediately after recess.
He will be there.
No, my lord, kindly.
No, then come back after 2. Come back after.
My lord, please come, my lord.
Come back after 2. Why?
My lord, I'm preparation for. Please, kindly.
Someone else will argue on the next date.
Yes, my lord.
Then definitely we won't grant time.
My lord, please.
No. You will have, then if you argue on the next occasion, somebody, your senior, maybe there. Learned counsel for the appellant seeks an adjournment, whose of such adjournment is granted subject to the rider that learned counsel representing the appellant today before us shall resume arguments on the returnable date. Full stop. Let the matter stand adjourned till July 27, 2026. Give your name only now. You are also appearing in this matter.
Yes, my lord. He is
Helping him. No, give your name only. So that you have to argue on the next topic. Next.
deeply obliged,
Next.
my lord.
The appellant one.
Yes.
My affidavit of service.
Good service affected?
Yes, madam.
Yes. What is the matter?
My lord, this is an application for condonation of delay.
What is the delay?
My lord, another 353 days.
What is the reason?
And the reason because the matter, the originally the suit for declaration and injunction, which was partly decreed.
Right.
But at the after that, my lord, after going through the judgment, it was found that the share of the plaintiff was in the residential house is 1/4 share, but that was declared as 1/5. Thereafter, my lord, the petitioner, the appellant asked her learned advocate to prefer an appeal, but that was not done, my lord, as the, my lord, certified copy of the judgment and decree was applied on 8th May 2025, whereas the judgment was passed on 28th of March 2025. Thereafter, my lord, the judgment was available 19th of May 2025, but somehow the delay was made, my lord. Thereafter, yes, the appellant came to the present learned advocate, and thereafter.
No, you filed the appeal almost a year thereafter, after obtaining certificate copy.
Yes, my lord. The 28th March 2025 is the date of the judgment, and the appeal was filed in 16th March 2025, my lord. This is 353 days.
Despite service, none appears for the respondent at the time of call. Which of the affidavit of service filed to be kept on record. So next para, the delay of more than 300 days in preferring the appeal has been sought to be explained. The delay of about 353 days in preferring the appeal has been sought to be explained to the effect that the appellant was initially assured by her learned advocate in the trial court that certified copy would be applied for, but was applied later. Which of even after obtaining the certified copy on May 19, 2025, the appellant could not take steps due to several old age ailments such as Parkinson's disease, spondylosis, etc. Which of prescriptions in that regard have also been annexed to the application, which go on to substantiate the averments made in the condonation application. Accordingly, says sufficient cause has been shown for the delay. Can 1 of 2026 is allowed, thereby condoning the delay in preferring FAT 113 of 2026. Which of the said appeal be deemed to stand registered and admitted. The appeal is against what?
Against the judgment and decree, my lord. The suit was partly decreed, my lord.
Recovery portion not granted.
No, my lord. The suit was for declaration and injunction.
Recovery portion has not been granted.
No, my lord, suit was for declaration injunction. The decree is wrongly written as recovery of possession.
Oh, it was not for recovered portion at all.
No, my lord. Only
Why
for
partly decreed? Why partly decreed?
My lord,
Absolute right was claimed, but only a part was given.
it was, there is a.
You are the plaintiff.
Sorry.
You have challenged the part which was not decreed. Schedule. The appellant shall put in postal costs and requisite for service of notice of the appeal on the respondent within a week from date. The trial court record shall be brought at the cost of the brought by special messenger at the cost of the appellant, also to be deposited within a week. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant, which shall liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing.
Yeah.
Thank you. Next.
Lord, what I request, my lord, another item 116.
Yes.
If the matter is tagged along with this, so that
116 is appearing under what heading?
WPLFT.
This is a civil matter.
But the issue is same. Issue is same because here is the point involved, the status of the appellant. Your lordship held the licensee. And another set of...
Mr. Mitra, do you agree to that?
I have no difficulty, but then they are showing this review pending and the execution is getting delayed. And in fact, the last order is very interesting where they place before the executing court that they are going to file the order which the court will pass. So I have no difficulty. And these are just check with them.
What review has
Well, review of eviction decree. Supreme Court has SLP dismissed. From that, anyway, but he has the right to review, so I don't want to comment.
No,
on
not that, but what is the connection with the WPLT?
WPLT, there is also status is involved. What happened actually? The rent controller, additional rent controller held prima facie you are a tenant. That they have challenged before the WPLT.
In fact,
that dismissed. Then thereafter they have challenged before this court. The coordinate bench they didn't move. That is also dismissed. That reaches finality. 1 point. Again in subsequent there are 2 occasions before the land tribunal, and first occasion land tribunal upheld. Yes, there is no infirmity in the order because they have contested the issue. Second point, they have another coordinate bench. Overruling the coordinate bench decision came to the conclusion that no, rent
That
controller.
challenge was preferred against what order passed by the rent controller?
There are 2 orders. One is 27, another is 36. In 27, ultimately.
So what connection does that have with the eviction degree? Eviction degree itself.
One point is the status must be unique.
No,
If the
the rent controller's adjudication does not determine the
yes,
status.
it is one set of series, another set of NCLT and NCLT. That is the liquidator.
No.
Kindly listen. Before that point was also raised. I want to place that order also.
Place that order, no difficulty, but that has no connection with the eviction degree. The adjudication by the rent controller is not binding on the eviction civil court.
But the NCLT
We will
and
hear this independently, Mr.
Alright.
No. So let us first come to the section 5.
Yes.
43 days.
Delay of 43 days.
Reason.
I moved the application before the Supreme Court and thereafter I filed this. Supreme Court has given liberty to proceed all pending applications.
We are allowing this section. Supreme Court order is annexed here.
Yes.
Granted liberty to seek review.
No, not review.
Not come in the way. Very well. The reason for the delay of about 43 days in preferring the appeal, as pleaded in the condonation application, is that the appellant initially preferred, the review applicant initially preferred an appeal against the judgment under review before the Honorable Supreme Court, which was turned down, observing that the said dismissal shall not come in the way of the parties, including the petitioner therein, if any other proceedings are pending between the parties. First of, although, strictly speaking, the review application does not come within the purview of any matter pending at that point of time, learned counsel for the review applicant submits that due to the pendency of the SLP, the review applicant did not take steps to prefer a review application. Full stop, upon hearing learned counsel for the parties, we find sufficient explanation for the delay having been proffered. Full stop, accordingly, can 1 of 2026 is allowed, thereby condoning the delay in preferring RVW 141 of 2026, no rest to cost. Yes, what is the review? What is the ground?
Second can is this for amendment of review.
What sort of amendment, Mr.
I have cited the certain paragraph I want to insert because when it was filed there was mistake. So kindly, if they allowed the amendment.
Where is the proposed amendment?
Proposed amendment I have enclosed with the can.
You want to add grounds?
Yes. I want to add grounds, certain grounds.
Very well. We are allowing this. And Can 2 of 2026 is an application for amendment of the review application by incorporation of certain additional grounds. So upon hearing counsel for the parties, we allow the same. The grounds taken in the grounds mentioned in the schedule to the amendment application be treated to be incorporated in the review application itself. No rest to cost. Can 3, what is can 3 for?
Can
the never ending cans.
Yes,
can 4 is also there.
Yes, can 4 is for stay.
Can 3 is for?
Can 3 for consideration some judicial orders passed by the different forums for complete adjudication in the matter.
Judicial orders, yes.
NCLT and NCLT. Everything.
What do you say to this, Mr.
These were all available before the matter was heard by your lordship. And these are not new subsequent orders. This doesn't come within the scope of review relying upon these judgments. I leave it to my lord, because that's of course on merits. So
we'll keep the question of admissibility of these documents open, but we'll permit you to rely on
you
this.
could anyway handed up the order of court. So
Lord, kindly come to page number on the can
This is
3.
a professional approach for professional reasons. So very well.
Can 3 page number 18, 18. The order passed by the NCLT, because what happened after
You have
original.
not yet allowed this application.
Yes, subject to. The original, when the original landlord.
And 3 of 2026 is an application for permission to the review applicant to rely on certain documents, judicial orders, pleadings, and other evidence. Full stop. Next para. Such the can 3 of 2026 is conditionally allowed, comma, permitting the review applicant to refer to the annexures to the said application. Full stop. However, comma, the question of admissibility of such appellants at the review stage is kept open for being decided at the hearing of the review application. Let us take up the review application.
Yes.
What ground, Mr.
Yes.
Doctor? What is the error apparent on the face of record?
There are two types of grounds. One slightly apparent and another for sufficient ground.
What sufficient?
Any sufficient.
That
there
has
is
to be read mutatis
Yes,
mutandis.
sufficient ground for review. There is a
held by different courts that is akin to the
yes,
previous.
that I will satisfy. That I will satisfy. Sufficient ground means what to the extent. Sufficient ground for review is also covered under the Order 47 Rule 1. But first of all, when the trial court was directed the plaintiff to serve notice upon me.
What is the backdrop? Decree was passed. Eviction decree was passed against you.
Yes, before by this first appeal. But in the trial court, the suit was dismissed.
We reversed it.
Yes. The suit was dismissed on the ground there was no cause of action.
Suit was filed for eviction on what ground? Licensee, trespasser, or
they have taken the plea. There is a licensee, and there was a default. So I won the position. That was the point.
Licensee with fees.
Yes, but what happened? I have raised the issue. So whether the leave and license agreement come within the purview of city civil court or the small cause court, as per section 41, there is a judgment of the Supreme Court that it is exclusive jurisdiction of the small cause court. The learned single judge granted stay, but that was dismissed for default. When it was dismissed, by taking the opportunity, the plaintiff moved ex parte without serving any notice. There is a specific direction of the trial court. You serve notice. I will annex those order also. But no service was done. They moved ex parte, though the suit was dismissed. What happened by this way? I have lost to give evidence to participate in the trial court. But your lordship, what happened? In summarily decided the issue.
What is the pressing urgency in this? Is there any pressing urgency in this? Or we'll take up the review application for hearing along with the we'll fix a date next.
If you are granted limited stay, yes, granted limited stay of the execution because they have
the next date for execution.
3rd August for police help. If your lordship any convenient day and during that time limited protection we give it.
On 21st.
Yes, 21st may be fixed for.
No, we are keeping it on day after tomorrow, 23rd, for hearing as a special fixed matter.
Let me see.
If it commensurates with your timings, or we can keep it next week early,
or except 23rd any.
So then 29th then Wednesday. Mr. Datta, it will be on 29th as a special fixed matter. In the event we can't reach it for some reason, you can ask for stay then. We are keeping the can 4 alive. In view of the arguments advanced in connection with the review application being identical with the application for stay, that is can 4 of 2026, we fix the review application itself for hearing along with the application. Push of the matter shall be listed on July 29, 2026 under the heading specially fixed matters.
It's inclined to also keep 116 along with it, as my friend is saying, because
very well. Comma there when it will be listed along with item 116.
WPLT 205 of 2013.
Along with WPLT 205 of 2013, which is appearing as item number 116.
Today's list.
In today's list.
Yes.
Okay. দুটো একসঙ্গে করে স্পেশালি নেক্সট খুচরো অ্যাপ্লিকেশন গুলো টেকে নিদিন
Lordship, in this matter, your Lordship, after filing of this appeal, means before the passing, after passing of the judgment and before filing of this appeal, one of the appellant expired, your Lordship. Accordingly, necessary application has to be filed, your Lordship.
Learned counsel, one of the appellants.
Yes, your
Learned counsel for the appellant submits that after passing of the impugned degree and before filing of the appeal, one of the appellants has expired. Full stop. Accordingly, leave is granted to the appellants to prefer an appropriate application in that regard. Full stop. Let the matter go out of the list with liberty to the appellants to mention the mention for inclusion in the list as and when such application is filed. Next.
Item number 19, I beg to appear for the appellants, your Lordship.
Yes, what is the matter?
Appear for the respondents.
Yes.
Affidavit of service on
You have
previous.
served on all the respondents.
I've served.
Mr. Mukherjee, you are appearing for.
Lord, I am appearing for Lord the affected respondent Lambawala tea plantation. Lord.
The others have been served.
Respondents.
We have served, your Lordship.
All.
Complied. Not all
We have complied.
All respondents.
You are appearing for.
All
Well, yes. What is the matter?
Your Lordship, we have filed a suit for declaration and injunction, and on the upon moving order ad interim injunction, the learned court below refused it, and the order is with our memo of appeal. And the order previously, as your Lordship mentioned, in your Lordship's order dated 10/6, the order seems to be cryptic and unreasoned. Completely, there was no reason given for denying the injunction. We have made our case. The learned trial
Yes, yes, yes.
recorded.
Have you annexed that lease deed?
Yes, your Lordship.
What was that?
It's in page number. It is 60. Your Lordship, I'm being led by me.
Yes, yes, yes. Sure.
No, page number 46. Is below deed.
All these documents are produced. The list is there.
Yes, but these are the documents which are before the land court below. The Firisti I have next.
What sort of injunction do you want? Protecting your possession.
My possession, what they are doing is, they are forcefully entering into my tea garden, chopping off the old 30 years, 40 years old tea bushes.
Mr. Mukherjee, at this stage, why shouldn't injunction be granted? They produce a lease deed at interim stage.
But I'll tell you, Lordship,
Lease
if
is
your Lordship
successive.
kindly see, Lord, they are not having a lease in respect of a part of a DAG number. And the balance of that DAG number is not the leasehold right of my client. The difficulty is they are trying to ingress into my property, claim a right, and take an injunction from your Lordship. Why I say this? Your Lordship will kindly see their the total area that
yes, please show us that.
Kindly come to page 43, the area that they say to be under them. But I am concerned about serial number 1 and 2. Rest I do not mind.
1 and 2 only.
1 and 2. Your Lordship will kindly see.
That comprise of the lion's share.
That is of which the area of the plot leased to the plaintiff company. The balance 3.58 belongs to my company.
In 1.
In 1.
3.58 is
I
the balance.
think 3.58. अरे भाई एरियाটা বল
Item number 1, your area.
And in item number 2 also your Lordship sees the balance portion is 0.80.
Oh, acha, whatever this total area minus that.
Yes,
whatever is it.
yes. So in respect of this,
it is not a demarcated plot.
It is not a demarcated. I also do have a lease by the government. But
Similar.
These are all.
But this could not be looked into at that stage.
These are all tea plantations. These are all government land. Plantation land, as your Lordship knows, but these are all given on a lease,
yes,
based upon 30 years, the long-term lease.
But it's not demarcated. There is a difficulty.
Yes, and now, here the question is, they say that my client is entering into their property, and they are trying to disturb the possession. On the contrary, what I say is that when your Lordship has passed an order of injunction, on the strength of that injunction, they are coming into these two properties to disturb and say that the order has been passed by the honorable court.
But they produce a document at the ad interim stage. They should have been granted injunction. Although it's not demarcated, you can understand that. But regarding
yes, but the nature of the allegation that your Lordship will kindly see what they have stated at paragraph 11.
Yes.
Rather I start from page 40, paragraph 10.
Yes.
That in the month of May and June 2024, some miscreants entered in the tea garden at night and for chopped the mature tea bushes, and chemical was sprayed on the other bushes to spoil the standing crop, and also used to pluck the tea leaf from the other portion of the garden. All this was causing not only disturbances, but was also resulting into huge business loss of the plaintiff. On 18/5/2024, 26/5/2024, and 9/6/24, the director of the plaintiff company lodged written complaint with the local police station stating all facts, but till date no action has been taken by the police authority for reason
Mr.
not within
Mukherjee, you
the
have
law.
read these paragraphs.
So,
So,
Lord, your lordship will kindly see
11
Lord,
also we
the
saw.
next two paragraphs, and Lord, the current Lord, the statement is
So, Mukherjee, you
paragraph
can do
30.
this. We can pass an injunction regarding this for their portion.
I'll use an affidavit, Lord.
No, what you are saying, because at the ad interim stage, entertaining your affidavit will.
Your lordship has already protected them by an
No, we'll maintain that order.
Lordship.
We'll direct the trial. We'll file your written objection to the injunction application in the trial court within a limited period. We'll clarify that this is just for ad interim protection, not influence trial court, and we'll direct the trial court to appoint a survey pass commissioner to ascertain the extent of their
We'll kindly
leased
do
out
so.
portion.
Kindly do so.
We'll pass
We'll
that
kindly do
direction.
so. That will really, Lord.
That is the only way we
that
can.
is-
Otherwise, it's
that-
very difficult.
yes.
They have to
Otherwise-
identify their portion.
In a tea garden, it is very difficult.
Tea garden is not possible. You have to demarcate each of the bushes then and write your names probably.
Grateful.
So we'll make it in order of the code, obviously. Affidavit of service filed to be kept on record. Full stop. Learned counsel for the appellant. No, the present appeal has been preferred against the refusal of ad interim injunction in connection with a suit for declaration and permanent injunction in respect of a tea garden filed by the plaintiff stroke appellant. Because of next parallel, counsel for the appellant argues that the impugned order, refusing ad interim injunction, is cryptic and is devoid of any reason for such refusal. Because of next para, that apart, it is pointed out that the plaintiff duly produced a deed of lease executed in respect of the plaintiff by the government of West Bengal, as well as the recording of the name of the plaintiff in the LR records of rights, which were all considered by the learned trial judge, along with police complaints and photographs substantiating the case of disturbance by the respondents, however, the learned trial judge still refused to grant injunction. Full stop. Next para, learned senior counsel appearing for the respondents argues that the appellants are only the plaintiff appellant was granted lease only in respect of a portion of the subject plots. Full stop. Insofar as the rest of the plots are concerned, the same was let out to the respondents. Full stop. Taking advantage of the ad interim protection granted by this court, it is submitted that the appellant is trying to disturb the position of the respondents in respect of their leasehold portion, which comprises of the balance of the plots in question. Full stop. Next para, learned senior counsel argues that in the absence of any specific particulars of the exact portion of the plots conferred by way of lease in favor of the plaintiff stroke appellant, no injunction could be granted. Full stop. Upon a perusal, in view of the identity of the arguments in the injunction application and the appeal, and the short conspectus of the same, we take up the appeal itself for disposal along with the injunction application. So next para, at the very first blush, it is evident that the impugned order is devoid of reasons. Full stop. The learned trial judge, while recording that the learned judge perused the deed of 2007 and the LR ROR Khatian in the name of the plaintiff stroke tea plantation company, from which the learned trial judge found that the plaintiff took lease which will be in force till 2027, as well as the police complaint and the photographs, despite which the learned trial judge refused injunction on the specious plea that he was not inclined to pass any ex parte order without hearing the other side. Full stop. Next para, such approach is dehors the law. Full stop. It was the bounden duty of the learned trial judge to advert to the materials and averments made in the plaint and the injunction application before the learned judge at the stage of ex parte ad interim injunction and to decide the issue accordingly. Full stop. Next para. However, comma, since a contention has been raised regarding the ownership, regarding the rights, leasehold rights of the respondents with regard to the rest of the plots than which was let out to the plaintiff stroke appellant, comma, for the ends of justice, comma, it would only be appropriate if the learned trial judge appoints a survey past commissioner to hold a local investigation to ascertain, to compare the respective deeds of the parties and to ascertain the exact portion of the subject property which was let out to the plaintiff stroke appellant. Full stop. Next para. However, comma, in the meantime, comma, in view of the documents before us, comma, which is also placed before the learned trial judge, comma, we find that a prima facie arguable case has been made out entitling the plaintiff stroke appellant to interim protection at this stage. Full stop. Next para. However, comma, we make it abundantly clear that this court has not conclusively decided any of the issues involved in the suit and or the injunction application pending in the trial court, and it will be open to the learned trial judge to decide the temporary injunction application independently on its own merits without being influenced in any manner by any of the observations made herein. Full stop. Next para. Accordingly, FMAT 161 of 2026 is allowed on contest, thereby setting aside the impugned order dated April 24, 2026, passed by the learned civil judge senior division at Islampur, comma, district Uttar Dinajpur in title suit number 08 of 2026 and restraining the respondents and or their men and agents by an order of injunction from disturbing the peaceful possession and enjoyment of the appellant in respect of the suit property till disposal of the temporary injunction application pending in the trial court. Full stop. Next para. The respondents shall file their written objection to the temporary injunction application within a fortnight, within a fortnight from date. Full stop. The learned trial judge shall, comma, in the meantime, comma, by acting on a server copy of this order, comma, appoint a survey past commissioner for holding a local investigation to ascertain the exact portion of the suit plots.
I'll just, Lord,
yes.
But in respect of Lord, serial number 1 and 2, in respect of the others, Lord, it is full plot. So, Lord, we can not restrict it to not only
one minor submission. But probably, Lord, as far as I have not seen the copy, Lord, what my senior friends addressing with regard to his lease deed, probably it has expired by iflox, so it's not subsisting as on date.
No, we'll put in something. Ascertain the exact portion let out to the plaintiff in respect of serial numbers 1 and 2 of the schedule to the plaint and the injunction application, comma, pertaining to plot number 26 and plot number 01 in Uttor Besarbari Para, comma, JL number 64 as described in the schedule, as per the schedule of it. Full stop. Next para. Since the respondents do not dispute the rights of the plaintiff stroke appellant with regard to the other serial numbers, that is serial number 03 to 12 of the said schedule, comma, no such local investigation need be passed in respect of the said plots. Full stop. Next para. It is expected that the entire exercise of appointment of survey past commissioner and filing of report by the said commissioner shall be completed within 6 weeks from the date of communication of this order to the learned trial judge. Full stop. The learned trial judge shall endeavor to dispose of the injunction application in accordance with law within 8 weeks from the date of such communication. Full stop. Next para. We have already stated that we are not going to.
But only one thing, Lord, your Lordship, in my Lord's interim order has restrained my client from alienating, Lord, and selling the property. This is a government land, Lord. My learned friend should have pointed out that.
No, we are not passing that now because that merges in.
Very well. Lord,
we are only granting
transferring, alienating, encumbering in favor of.
No, we are that merges in this order. We are only granting. Push up. Next para. Can 1 of 2026 is also disposed of accordingly. interim order, if any granted in connection with the appeal, stands automatically vacated. No address to cause urgency.
One submission. The lease may not is that entire exercise of appointment of the Thabewas Commission shall be done only if it is found that the lease is subsisting as on date.
Lord, that is not the question.
Well,
Lord,
if
the
appointment of-
if it is expired, it doesn't inure to my learned friend's benefit.
Written objection within fortnight
cannot
বলেছি
process.
একটা জায়গায় written objection within a fortnight বলেছি comma disclosing thereby disclosing the lease deeds and other documents on which the respondents rely on in support of their rights to the other portions of the concerned plots. So they'll disclose in the written objection so that the commission can be held in.
That's only one line that if it is found only then, otherwise may not.
But kindly do not, because Lord, why I say that?
One minor submission, this it's a very remote area. It's in a tea garden. If the assistance of the inspector
That the trial court will decide. That the trial-
the problem is
no, without any allegation of that.
There are GDs, one after the other. I have annexed with my appeal itself. But just one direction that whenever the
That the commissioner will. The commissioner is the officer of the court. Court will protect its own officer. Next.
Great.
Great.
Opposition টা যেটা এখানে করছিলি তোরা ট্রায়াল কোর্টে ফাইল করো।
You are for the appellant.
Respondent.
Respondent number 2.
Yes, respondent number 2.
একসময় অনেকগুলো কি মেনশন করছি অনেকগুলো কি ম্যাটার সবকটা একসঙ্গে আছে
Yes.
এত সবকটা দিয়েছেন তো উইথ করে দিলেই তো পারতেন কত থেকে কত সবকটা দেখান তাহলে বোর্ডে উইথ করে দিয়েছি আপনি আলাদা দেখাচ্ছেন কেন
কত থেকে
27 up to
From
27
Yes, 27.
none appears for the petitioner none appears for the appellant petitioner in any of the matters. Full stop, let the matter go out of the list. Let the matters go out of the list. Next.
My appeal from a refusal to pass an ex parte ad interim injunction. My lord has passed an order on the first on the day, and we have served thereafter, my lord.
You are appealing? Yes.
Give me short possible.
You were not panting when you entered. When coming to the microphone, you started panting. You have noticed it.
My, I don't know 28, my lord.
Yes. What do you say?
I am for the respondent number 1.
Let us hear them. Very good. Yes.
Well, the ex parte ad interim injunction was refused on the sole ground that, according to the learned judge,
Oh, that.
Commercial.
Commercial.
My lord.
Commercial Courts Act din.
Acha, Commercial Courts Act din to. I might just point out from the plain.
So you alleged a breach of confidentiality when the respondent left your service.
Yes.
And the court constitute that to be intellectual property. Come within 2(1)(c) that 7.
Court, in fact, court also did not hold it in so many words. Court was of the view that since, if my lord sees the impugned order, the last but
in
one
1(c) 7 was referred. Most probably.
My lord had referred to it. The court did,
the court did. The
court did not. Court did. My lord will see the impugned order, my lord. Stay petition, paragraph, page 29 of the stay petition.
Yes, commercial. Yes.
Very sir. The last.
Begin your breath. We have heard him. We have heard him.
Yeah. Already.
Yes.
Already
You remember what order we passed.
Yes.
How does it become a commercial dispute?
Your Lordship, it does. In the sense, Your Lordship sees the pleadings in the plaint.
Yes, we have seen. Which provision of the Commercial Courts Act?
Yes, Your Lordship. Kindly come to 2C, Roman 17.
Yes. Intellectual property.
Yes, Your Lordship. His allegation is that I have stolen the designs of the plaintiff and I have used that for my revenue purpose, for selling leather goods.
Let us come to the relevant paragraph of the plaint now.
Your only will see he is harping upon the word design, and it is mentioned in 2C Roman 17. Intellectual property rights, including trademark, copyright, patent, design.
Yes.
Now, Your Lordship will see
Page 157, can you take page 157?
Yes.
And it take from paragraph 9 onward.
Yes, please.
158.
Yes.
The defendant number 1 used to enjoy a position of seniority in the employment hierarchy as maintained by the plaintiffs, and similarly the defendant number 2 used to be an important design cutter. The defendant number 1 and 2, in view of their positions in the plaintiff, are entrusted with the valuable properties pertaining to plaintiff's business, confidential trade information, client database, supply information, leather and non-leather goods, design, pattern, stock details. Now, the Lordship will now take para 18. That sometime in September 2025, to the utter shock and surprise of the plaintiff, the said Swiss company, through the defendant number 3, had informed the plaintiff by email communication dated 3rd September 2025, a copy whereof is annexed. False and baseless allegations of the plaintiff supplying leather items, bags manufactured for Swiss company to the plaintiff's customer and other third parties were against the plaintiff in the said email communication. The plaintiff at no point of time has caused any leather goods item manufactured for the said Swiss company.
Yes.
Then para 25A.
Yes.
It is thereafter that the plaintiff became suspicious and started making inquiries in respect of both the defendant number 1 and 2, pursuant to which, to the utter shock and surprise of the plaintiff, has come to learn of the following facts. The defendant number 1, even while being engaged in employment of the plaintiff, has removed sensitive data as also confidential details of the clients and leather designs, which she had full access to, being effectively in control of the plaintiff's database, as also the official email communication of the plaintiff, and had transferred them to third parties and or plaintiff's competitors in the business, and has clandestinely purported to delete the email communications in this regard. The plaintiff is in the process of ascertaining further particulars to the extent of data and or confidential detail designs or other confidential information with the said defendant have unauthorized removed or transfers plaintiff database and have been made available to third parties, shall furnish the same before this learned court at the subsequent stage of proceeding. Then para 26. That in view of the aforesaid, it is evident that the said defendants, that is the defendant number 1 and 2, have acted in material breach of express and implied terms of employment, and have also acted in material breach of the trust and faith which the plaintiff reposed on them, as also in the breach of their fiduciary duty and obligations which they have towards the plaintiff. Then that the defendant number 3, being fully aware of the fact that the defendant number 1 and 2 are associated with the plaintiff or under the employment of the plaintiff, have proceeded to collaborate with them and incorporate the defendant number 4 with the sole objective of starting competing business to take away and solicit regular clients of the plaintiff. The defendant number 3 and 4, more particularly the defendant number 3, therefore are liable for procurement of breach of contract between the plaintiff and the defendant number 1 and 2. The plaintiff reasonably apprehends that the defendant number 1 has passed on sensitive and confidential data and information pertaining to plaintiff's business designs to the defendant number 3 for the purpose of gaining advantage. Then the allegation is against the defendant number 2. Then para 31, the defendant 1 and 2, despite of being in employment with the plaintiff, has entered into competing business in collusion and conspiracy with the defendant number 3 through the company being the defendant number 4. On the basis of that, learned friend, cause of action paragraph is para 40 and 42. That in such circumstances, it is required to declare that the plaintiffs have right to protect the confidential trade information, client database, design pattern, and sample of the plaintiff's business, and the defendants have no right to utilize confidential trade information, client database, design pattern, and sample of the plaintiff's business, and the plaintiff is also entitled to an inquiry into the damages. Now, you will see his allegation is that I, being a senior merchandiser, while in course of my employment, was assured and was given the responsibility of a confidential job. I have taken advantage of his designs, which he used to apply for manufacturing the leather goods, and have supplied trade information and design to third parties, and have set up a company to the defendant number 3, which is defendant number 4, and I'm utilizing his designs, is taking away his clients and selling the goods for which he has suffered loss. He has claimed damages.
Where has he stated anywhere that he had a trademark either registered or unregistered in any of the designs? Let us come to the designs. Business data, everything else, forget. Design is the closest to the trademark.
Correct.
Either copyright or trademark. They never say they have any trademark in anything.
No, they are not saying that.
They say they are in the leather business. They manufacture leather for others, and you are a senior manager, and they were implied in express contracts, employment contract, confidentiality clauses. So it's virtually a breach of that contract, data breach, and that you are entering into competing business, all boiling down to the breach of that employment contract with you, implied or express. So it's not an intellectual property as defined in clause 17 at all.
You see, designs are not mandatorily required to be registered. Like a
No,
patent or a
but
trademark.
unless it's registered, no, we are not on registration.
Correct.
You're right. It may be unregistered trademark also, but they never claim a trademark in any of the
They
designs.
are not claiming, but they are saying that I have utilized their design for my revenue gain.
If
and
they
for
don't have a
revenue-
trademark and they use a design, whatever particular design, then this, as per the frame of the suit, it's a breach of the contract. It's a data breach, you are entering into company, all boil down to breach of contract, not a violation of trademark or infringement of a trademark of any manner, in any manner.
They are saying, Your Lordship, subject to correction, Your Lordship, I come under two clauses of 2C1. That is, first is Roman 17 and Roman 18, agreement with related to provision for services as well. I was appointed.
What is the agreement for sale of goods or provision of services?
Your Lordship, I was never a regular employee of the plaintiff company. I was engaged for providing my services as a service merchandiser.
Who is my learned friend?
I was never in the payroll of the plaintiff company. So, Lordship, if that is so, if they say that there is an agreement for services, employment contract has been breached.
That you can file a written objection, take those points. At the identity stage, court has to proceed on their claim.
The fact is that their averment says so. I will show their averment with regard
Who is
to
my learned friend appearing for? Because I have also been one of the parties. Even number one. Okay, then I'll show for that he there in the payroll. I've got my bank statements or everything.
That is not part of the plaint or the injunction petition.
It is there.
No, it has not been annexed. No,
But
Lordship will
actually,
kind.
for respond number 3, I also have a similar point of maintainability.
Who are you? I mean,
For respond number 3.
who is respondent number 3? That is what we are asking.
Lordship, the respondent number 3 is the person from Switzerland with who used to provide the design to the plaintiff for manufacturing goods, and their allegation is that I have theft, I have stolen their design.
They are now siding with you.
Yes, they formed a company together, 1 and 3.
Fact is that, Your Lordship, is there any bar that he cannot form a company?
While being in service.
Allegation is that
Apart
he
from
was
a
never
breach
in
of the
service.
confidentiality clause.
Yes, yes, yes. Your Lordship will see. Kindly come to para 7 onwards of the plaint.
This onwards, we fear this word.
Sorry. Page 157.
Yes. No, onwards, we fear onwards. What are the specific paragraphs? You have read 9
correct.
onwards.
Your Lordship will see para 7.
7, yes.
Plaint number 1 and 2 are employed with the plaintiff as a senior merchandiser and senior pattern
They
cutter.
say employed with the plaintiff.
That is what they say.
Employed.
Fact is that I
What
was
they
only
say, which
appointed
the
as
court
a
has
senior
to-
merchandiser.
So, manager, at the addendum stage, it is what they say.
Lordship, I am showing the other paragraphs as well. Kindly.
You see it in their claim.
Paragraph 12. That as would be evident from what has been stated hereinafter, the said defendants have acted in material breach of the aforesaid express and or implied terms of the employment
Absolutely.
with the
Implied
plaintiff,
terms
and
of
have also
employment.
acted in material breach.
The more you are placing, the more you are arguing in their favor. It's an employment contract as per the plaintiff.
Your Lordship, with regard to the definition and the provision for services, Your Lordship will see.
They have no agreement with you for sale of provision of services or sale of goods or something.
Lordship,
Like.
that
They have
agreement,
not pleaded at least.
that agreement is with me. That agreement
Produce
is
that
with
by all means in your written objection in the trial court and get it contested. But till then, they will be in.
But Your Lordship, kindly have a look at this. With regard to the privacy case even made out, they say that I have stolen data. Kindly come to the pleadings at para 25A. They are saying that the email which I have written to the other client stealing the data, that has been deleted. Now, that is deleted. How do they come to know that I have stolen data, I have transferred it to the third party clients? Kindly have a look at the pleadings which they have made.
Yes.
Para 25A.
Yes.
It is thereafter that the plaintiff became suspicious and started making inquiries in respect of both the defendant number 1 and 2, pursuant to which, to the utter shock and surprise of the plaintiff, he has come to learn of the following facts. The defendant number 1, even while being engaged in employment with the plaintiff, has removed several sensitive data, as also the confidential details of the client and leather designs, which she had full access to, being effectively in control of the plaintiff's database, and also the official email communication of the plaintiff, and had transferred them to third parties or to plaintiff's competitors in business, and has clandestinely purported to delete the email communication. So how does he come to know that it has been deleted? If that email, which is the basis that I have transferred information and data to third parties, that has been deleted, then what is the prima facie case made out to show that actually I am the person who has done it? apart from mere pleading. There has to be some evidence. Now, now your lordship will see the documents which they have annexed to their appeal. The allegation is other way around. Your lordship, what has happened?
Calcutta did not even look into this. Calcutta said it's a commercial dispute, go to the commercial court.
Your lordship, the division bench in first appeal can look into this. Your lordship can
No, not as a
supply
first court. Then we have to remand it by granting injunction. If you prefer that, we'll do that at the ad interim stage. We'll remand it. We'll go back to that.
with regard to the
It's your
injunction as
preference,
well.
Mr. We leave it on your preference. We can remand it at the ad interim stage, and then again ad interim order will be passed or refused, and then they'll come up in appeal. And in the process, 1 year will elapse before you file a written objection to the injunction.
The matter is returnable on 11th of August. Before the
That your lordship, I appreciate.
Obviously, we will not do that. Not do that to you. Obviously, you will not want that. We also don't want that. That will be
With
penal
regard to the
against you.
order which my learned friend has also obtained.
Yes, appeal allowed.
No.
Yes, yes.
Your opinion?
Not for defend, respondent.
Then appeal is allowed.
এই তো তুই 1 নম্বরে ছিলি সেখানে চলে গেলি।
You are for who is he? Another company?
Beating me. He is leading me.
No, but he is for whom?
Respondent number 3.
Oh, Swiss. That Swiss.
The Swiss company.
Swiss, not Swiss person.
Swiss person.
Swiss person.
Yes.
Your lordship, I was just showing two documents which are part.
Yes.
Your lordship, the facts are other way around. It is the plaintiff who has initially stolen the design and kindly have a look.
They have admitted in their plaint.
Yes. No, they have annexed this document.
Show us that document.
Kindly see. This is the letter which was given by the defendant number 3 before even filing of the suit that you have stolen my
Which page?
design.
Which page?
Page 119.
reply to Dakash.
For hiding this, for evading this, your lordship, this suit has been filed. So that the
D1 taking this
12 November 2025. Kindly see, letter written to Balaji Leather Creation, the plaintiff, on behalf of the under authorization of my client, Jamimak Design, who is the defendant number 4 company. We hereby formally demand that immediately cease and desist from the unlawful activities. Kindly see, immediate cessation of copying, imitation, production and distribution of products, design, patterns or any other protected elements belonging to the brand. Margulation, value to customers, business partners or third parties. Immediate destruction of all patterns, prototypes, samples and design documents related in any way to the above mentioned brands. Immediate termination of illegal, corrupt or otherwise.
So who is this Jemima to espouse your cause?
No, lordship, I am one of the director in this company.
Yes.
So it's you basically. It's your alter ego.
Yes. So fact is that this notice was given much before. Suit was filed in May 2026. Our allegation was that you are copying my designs and you are violating my patents and trademarks. So immediately they desist from doing any business by using my designs. This fact, this letter is part of.
According to their plaint, Jamimarg is what? Jamimarg is one of the other companies whose products they were selling.
D4.
No.
Defendant number 4 is incorporated by 1 and 3 while 1 was in service with me, dealing with in the same line of business.
So that is not.
And in the meantime, what had happened was that defendant number 3, that is a Swiss gentleman, he was in a business with us, whereby because he used to get us business in Switzerland, there is a company we used to supply design. There were some disputes which happened between plaintiff and the defendant number 3. So they stopped and there are legal notices.
Tie up with 1 according to your allegations.
According to my
Tie
allegation.
up with 1 and they form 4.
Form 4. 1 and 3 came together, formed 4.
So they're complicit in this.
They're complicit in this. That is my allegation against.
Yes. I had a contract. Your lordship, their stay petition in para 10 says the respondent number 2 was only in the payroll. I am not the respondent number 2.
Kindly see page 35.
Contract that I will provide my services as a senior merchant.
Page 35.
Para 10, kindly have a look at para 10 of the stay petition. Page 5.
38 and 54 is defendant number 1.
No, in paragraph 7 of the plaint, they say the defendant numbers 1 and 2 are employed with.
Yes.
Your lordship, then your lordship will also take para 2. Para 10, page 5 of the stay petition.
Yes, 10.
There are about 100 employees who are in the payroll. The respondent number 2 is also in the
Para
payroll.
10, you are saying.
Yes.
Para 10 of the plaint.
No, stay petition. Stay petition. Injunction petition.
Whatever you are placing. No, that was the plaint you are placing. Page 157.
Initially, I placed the plaint. Now I am showing the pleading in para 10 of the injunction petition filed before this court.
It is not the same as the plaint.
No, it is apparently not the same.
No, it is not this.
Oh. Which page? Sorry.
My lord, page 5.
No, this stay application we are not interested. I mean, This is
your
not a
lordship has-
pleading, neither a pleading. We want to see only the pleadings which were before the trial court when the injunction order was passed, refused. Only those we can look at. Whatever you say or they say at this stage is not there.
157 para 7. Page 157 para 7. Defendant 1 and 2 are employed with the plaintiff.
That we
as-
have seen. That
yes.
we pointed out to him. No trademark has been claimed by them.
Kindly see.
Design
Your
violation.
Your Lordship knows better.
They don't say that they have a design, but
No,
they have a
that-
trademark.
Please see the relevant paragraphs, in the plaint, Your Lordship. But perhaps Your Lordship has been shown, please see paragraph 13.
Yes.
This is how they have described me in the plaint.
You are three who have produced design.
Yes. Then, Milord,
This is not a Swiss,
18.
Swiss person. Yes.
18.
The last sentence in paragraph.
Yes.
18 is, Milord, September 2025, to the utter shock and surprise, the said Swiss company through the defendant number 3 had informed by email. So, Milord, there was an inter se relationship between the defendant number 3
yes.
and the plaintiff.
Yes.
Then, Milord,
You were not on that payroll as per the allegations also. They were doing work for you.
Yes.
According to their plaint. We are going by only their plaint for the time being.
Milord, please see 25.
25A was placed by Mr. Man.
Yes, the defendant, even while engaged in employment, the plaintiff had removed several sensitive data, as also confidential details of the clients and other laser designs, which she had full access to, being effectively in control of the plaintiff's database, as also the official email communication of the plaintiff, and had transferred them to third parties and or plaintiff's competitors in the business, and had clandestinely purported to delete the email communications in this regard. This is unauthorized removal. This is what they have alleged.
No, Mr. Bhattacharya, they say in A, the defendant number 1, even while being engaged in employment, had removed several sensitive data, as also the confidential details of the clients and leather designs.
Yes.
They don't claim right over the leather designs. They say it was confidential details of the clients and leather designs.
Then,
so they don't categorically say that they have a right over the leather design.
They have
the client's data.
They have actually computed their claim, as damages. As damages, because they say that because of this alleged,
Data
misdemeanor
breach
of
confidentiality clause. Yes.
the part, they have suffered this loss.
It boils down to violation, alleged breach of the employment contract between 1 and 2 and them.
I respectfully say, looking at section 2C, Roman 17 and Roman 17 in particular.
And 18 also.
17 in particular, 18. Maybe also, agreements for sale or provisions of services. This squarely falls, within the domain of the appropriate, legislation, the Commercial Codes Act 2015.
You are granting injunction.
Only one thing.
Granting, injuncting.
It's your choice whether we will keep the appeal pending. You will take a chance before a different bench.
No.
So we will delete the last portion. We delete the last data.
No, Your Lordship will kindly permit us
or decide it and direct you to file a written objection. Take all your points in the
Your
trial
Lord,
court.
permit us to use our written objection.
That will do in the trial court.
Trial court?
Yes, definitely. We'll give you a fortnight's time. Within a fortnight, you file a written objections and the injunction application to be decided.
Well, we can come back to Your Lordship. We can.
No, because we are hearing an appeal from an ad interim order. Mr. Bhattacharya, we have some restraints on that. The scope of our, whatever the trial court could do, we can do as an appellate court. So at interim stage, only their plaint and injunction could be looked at. Therefore, your scope will be much more limited. We can't look into your new documents which were not there before the trial. We'll say that this will not influence the usual things.
Your Lordship will kindly allow me.
Ball. You are appealing for a different party.
No,
finish it.
Since you are making submission. Today, even if I assume that suppose the commercial disputes are not applicable, commercial court has no operation. Even then, if your Lordship looking into the stay petition, the injunction and the plaint, what documents, even prima facie, the plaintiff has shown that I am guilty for transferring of data to third parties. Kindly
Need not.
Apart from mere averment,
Only
I can make any averment.
Only one submission.
Some evidence.
Only one submission.
Some evidence. He says that the email by which I have transferred it is deleted by me. How he came to know? So I don't know how he came to know that the email has been deleted.
There are ways of knowing digitally.
But that, your lordship, there is
That pleading has to be there, that
pleading
case has
is
to be
not
made
there.
out.
That would be evidence.
But if I've deleted something, then how, where is the proof of, even privacy proof of
Last
data information?
Last submission, my lord.
Forget the deleting. They have made serious allegations of your violation of the employment contract.
No, lordship, I am not in the payroll. Your lordship, they have stated so, but I am not in the payroll. I was only appointed.
We cannot look into that unless you file a written objection.
Some
Bring those
documents has
documents.
to be there, my lord, even before this court.
I am reading, my lord, just only one, my lord, only one sentence more.
Yes.
My lord, section 2C17, 1 says intellectual property relating to registered, unregistered trademarks, copyright, patent, design, domain names, etc. My lord, here the plaintiff has prayed in his suit the prayer, a decree for declaration that the plaintiffs have right to protect his confidential trade information, client database, design pattern. Sample of the plaintiff's business, and the defendants have no right to utilize confidential trade information. Will not ignores it, your lordship. Client database and design pattern. Will not, so boiling down to this prayer, Milord, I respectfully say, Milord, it is perhaps, Milord, subject to correction. It is perhaps covered by the definition of 2C17.
Let us come back to Mr. Bhattacharya. Yes. What about design and pattern?
Well, design. I am not owner of the design pattern.
No, your prayer says plaintiffs have right to protect the his confidential trade information, comma, client database, comma, design pattern. So your design pattern and sample. Sample we are forgetting. Design pattern. How do you deal?
Client database and design pattern coupled with my pleading is that I design for I have leather bags I design for my clients. So I'm not the owner of those designs. I'm not seeking protection of my intellectual property apropos designs, but I'm answerable to my clients. Today, if I'm, because I sell leather bags, supply them throughout the world. Now, today, they provide me the designs on the basis of which I do it. That's why the client database is also very important. Now, my lord will also see the prima facie document, kindly sees, comes to page 105.
Have you annexed any employment letter?
Yes, page 35. Page 35. Apart from my pleading.
And may I just
Annexure P4.
may I just
Serial number 50.
Paragraph 29 of the plaint may kindly be looked into, Milord, page 163.
No, where is the employment letter, employment contract?
No, there is no contract. I've said oral contract. There is no written contract of employment. Now, page 35, 54, serial number 54, while name of the person, all my employees list is there. And kindly say entry number 54 is defendant number 1 and defendant number 2 is entry number 48. Page 35. And with their signature
35
of the volume 1. Annexure P4. Rosalind Jamir is
from the middle of that list. We don't know what the heading of the list even.
Page 35, my lord, annexure P4.
35 is the middle, it starts from 41.
Yes, it's a list. I have already said I have hundreds of employees. So out of the list,
Time and out time. Your lordship, this is
yes, so
attendance list. In
attendance. So he's my
It will
employee.
happen to employees only.
No, your lordship,
In time.
even if there's an I am appointed. This is
And also kindly sees the WhatsApp messages. Now, before I show the WhatsApp messages, kindly sees first step page 105 of volume 1. This is an incorporation certificate of the company, defendant number 4, incorporated on 6th August 2025.
Defendant of 4, not
Yes, yes. And who are the directors? Rosalind Jamir, page 106, defendant number 1, and the defendant number 3, which is director number 2. And there are WhatsApp messages from about on 16th August 2025. Kindly see page 116. My mother is ill. I'm not going to come.
So that does not make me an employee of the company.
So why would I exchange messages with her? Kindly see 116.
An employee, you have business relations, you will say, my mother is ill, I'll not come.
No, your lordship, because I was there as a senior merchandiser, it is my duty to let the plaintiff.
You are there as a senior merchant?
Senior merchandiser. That is their pleading in paragraph.
There's a designation that
is. Kindly say this is in and out time. Anybody coming inside the factory will have this attendance list.
And we'll attend of all the employees.
Even a visitor who comes in, your lordship, that will be shown in this register. And your lordship, the one thing has not been told, your lordship, this person, my lady, my client, has faced her. Sorry.
Freudian, yes. Freudian slip. Please complete your arguments.
This person, defendant number 1, has faced earlier a sexual harassment charge from the plaintiff, who is the proprietor, and FIR was lodged in 18 November.
How does that matter?
No, lordship, this is a suit which has been filed to wreak vengeance, nothing else.
We will decide that.
No,
Do
no,
you seriously expect us to decide?
No, no.
But even prima facie on that, this is a suit to wreak vengeance.
No, no.
At the ad interim stage of the injunction
This is only
application.
I am giving the entire facts as to what has happened, which led to the filing of the suit. But this attendance register, which my learned friend has shown, is not a proof of any employment contract. This is
Page 116, kindly sees
Let us not go back and forth. We have heard you substantially, Mr. Bhattacharya. You are going to show para 21.
29.
29. Yes. Yes, what about that?
Please see the word, in paragraph 29.
Yes. Passed on sensitive and confidential data.
Confidential information pertaining to the designs, pertaining to the plaintiff's business and designs. The entire effort is an offshoot of this entire thing. The attempt is to, as if to show that it is a suit which is thus not covered by this act, but essentially it is a suit to protect his own business, and his business inter alia includes his specific designs which he sells. He has just now submitted. There are specific designs which are exclusive to it. And that is one of the cases which has been sought to be, that is the case which has been sought to be built here. Subject to correction, there are other averments in the plaints, which I can show. And apart from that, there are documents which also evince, that there was an attempt to use the design wrongfully, rightly. So there were exchange of correspondences inter se, the parties here. There are certain correspondences, your lordship is absolutely correct. One document versus another document, but the fact remains, the documents essentially is on the issue of design.
Your lordship will see, only to supplement what Mr. Bhattacharya has said, the documents from page 73 onwards, it is the defendant number 3 and 4 who is alleging from the very beginning that you are using my design and selling it to your clients, which is causing revenue loss. So this is only for the purpose of protection of his business, so that in near future.
I am not saying for a moment, the suit is not maintainable. Let him file a suit before the appropriate forum. That is what I say. There has to be a institution mediation as contemplated by this act. There has to be a proper forum. Essentially, there are innumerable places, where he has referred to the word design.
There is not a single document or an email communication to show that I have written an email from my own email account to any client of the plaintiff, transferring any data or any design or any nature of trade that I've shared. There is not a single document which is part of the front of the injunction petition to show that I have communicated with third parties. There has to be some document to show that yes, I was involved in sharing information or communicating with third parties. There is not a single document. Only mere averments, nothing else. So some document has to be shown. Your lordship has to show that at least my FSI, I am guilty.
Mr. Bhattacharya, we are not very clear on the designs part. The other parts not so sure.
Issue is
Maybe in your favor.
Today,
these designs you in paragraph number apart from the prayer portion as pointed out by Mr. Bhattacharya and Mr. Para 9, you also say, you consistently say that the defendant 1 used to enjoy a position of say whatever, were entrusted with valuable properties. So there are disjunctive commas: confidential trade information, client's database, supplier information for leather and non-leather goods, designs, patterns, stock detail. And if you see the designation of these people, 1 and 2, you define one of them as design cutter, senior pattern cutter.
Yes.
So therefore, and your business is job work preparation of leather goods and allied products in West Bengal.
Yes.
Reputation, craftsmanship and other trade practices. Your work is craftsmanship, manufacture of leather goods,
yes,
and selling them.
Yes, job work basis.
Might have been doing that for others.
For others.
But you have you manufacture, you have your designs for manufacture. Obviously, the designs are
those are provided.
It's not clear.
Those are provided. Now the question, my lord, which I put to myself is that today at an ex parte ad interim stage, could the trial court come to a finding that the suit in its entirety is not maintainable? Out of 7 or 8 things which I have alleged is being.
Please come to page 81.
Definitely.
Yes. Under the heading 5.2, unauthorized use of Virgo designs.
This is part of
second last paragraph of that 5.2.
This is,
Letter has been written by the defendant number 3 and 4.
yes, this is by the defendant to the plaintiff. So today, if I am violating there is a breach of design on my part. So if there is a breach on my part, so they are entitled to file a suit against me.
Thank His Lordship for this.
Yes, my lord. In fact, so their allegation is that their designs I'm stealing or I'm infringing upon their right of design. Where is the suit filed by them?
Our design. This is respondent number. Balaji is the
Balaji is the
plaintiff. Plaintiff. It has been issued to me.
By whom? By
defendant number
4 is that company.
Yes, that company which was
in consonance with Mr. Banerjee, who is that allegations have been leveled.
Yes, because their allegation is against me, but there is no suit filed by them. Because I have also replied to their notices. That's why this is not a subject matter of challenge in my suit. This is for these facts need to be there to just show that what is happening here. My employee ties up with my former business partner or whoever business person I have connections with.
But Mr. Bhattacharya, then this is your client writing to them, page 81.
For this director, yes, for this design, yes.
So you say that it's your designs.
That is Millard what? That is what the letter says.
Your letter says.
That is because the plaintiff Millard they have described.
Therefore, it's not their designs.
I'm sorry.
Not their designs.
We have never said that it is.
You are an employee. What can you say?
I am not an employee.
He said her resignation letter is there.
There's no proof.
Her resignation letter is there.
Yes, resignation letter.
Page 115.
The email communication saying
Page 115. Mr. Banerjee, please, page 115.
You don't have to tell me that. I've seen
No. Sent by Rosalind Jamir. I am in service with you for 8 years. Please remove my name from there in the record.
Could we dispose of the appeal or the injunction application?
Your Lordship is not taking
The ominous tone is sufficient.
design and all with regard to the
Design will deal with. Serious
Your
arguments
Lordship
made
will-
by deal with right now.
Your Lordship will.
Your choice is restricted to whether appeal will be decided or no. If you decide the appeal, we are indicating to
Your
you.
Lordship
Because otherwise, this appeal will be illusory insofar as you are concerned. Your materials are not before the
Your
trial.
Lordship will kindly Millard put us with.
Within a fortnight, you will file a written objection in the trial court.
Ah.
And these whatever our findings are not conclusive, the usual findings, tentative. And then the injunction will be decided, say, within 6 weeks or something. Better to do that. Otherwise, if you keep it pending and if you file your opposition and at the end we say that we cannot look into this, because there are conflicting judgments on how far we can look
Kindly
into all
gives
this.
us some more
You
time.
know
Millard.
that.
Your Lordship has delivered so
You
many
know that.
Kindly gives us some more time. Well, my person is not Millard even stationed here.
3 weeks? How long? Whatever you say, for that period injunction you will be suffering injunction. That's difficult.
15th of August, by 17th August.
Give us a date.
17th August, Millard. 17th August.
We'll give you a month then.
Yes, 7
Month from date.
Today.
Approximately 21st and 17th. 17th August sounds odd. I mean,
Very well. Well, I leave it to the court.
let it be something rounded. 1 month.
Your Lordship will also record one submission of mine that on instructions that I am not using any designs or anything client base of the plaintiff. That is on instructions.
You're leaving?
Matter is really going on. No,
Yes, but your name will not be recorded.
My lord is there. থাকো না বললে হয় কে চলছে ভাই ঢাকছে উড়বে না
The present challenge has been filed by the plaintiff in a suit for declaration that the plaintiffs to appellants have right to protect his confidential trade information, client database, design, pattern and sample of the plaintiff's business, alleging and for permanent injunction on the allegation that the defendants and their men and agents are utilizing confidential trade information, client database, design pattern, etc. of the plaintiff's business, comma, preferred against an order whereby ad interim injunction prayed for in connection with the suit was refused by the learned trial judge. Full stop. Next para, the plinth of the impugned order, impugned refusal was that the dispute involved in the suit is of a commercial nature. Full stop. Next para, learned counsel for the appellant argues that the closest provisions of the Commercial Courts Act 2015 vis-a-vis the present suit would be section 2 within bracket 1 within bracket small c, comma, clause XVII and clause XVIII. দুটোই ব্র্যাকেট ক্লজগুলো full stop. Insofar as the first is concerned, comma, the same pertains to disputes arising out of intellectual property rights relating to registered and unregistered trademarks, comma, copyright, comma, patent, comma, design, comma, domain names, etc. Whereas the latter relates to agreements for sale of goods or provision of services. So next para, as per the plaint and the temporary injunction application filed in the trial court, comma, it is argued, comma, the plaintiff numbers 1 and 2 are were employees of the appellant company for several years. Subsequently, comma, in collusion with defendant stroke respondent number 3, comma, which is a company, the products of which the appellant used to manufacture and sell, comma, has floated the respondent number 4, comma, another company. Next para, in the process, comma, it is alleged that the respondent numbers 1 and 2, comma, taking advantage of their confidential knowledge of the trade secrets and designs as well as patterns of the appellant's business, comma, are letting out such information for commercial benefit in favor of third parties. This, comma, it is alleged, comma, constitutes a breach of the employment contract of the appellant company with respondent numbers 1 and 2, as well as breach of data, comma, business information, designs and patterns. The allegations in the plaint also pertain to the respondent numbers 1 and 2 entering into competing business with the appellant, comma, in contravention of the implied and express confidentiality clauses of the employment agreement between the appellant and the respondent numbers 1 and 2. Next para, thus, comma, the as per the present frame of the suit, comma, the reliefs sought therein do not at all relate to any intellectual property rights as contemplated in clause XVII of section 2 within bracket 1 within bracket small c of the 2015 Act. Moreover, comma, the respondent numbers 1 and 2 being employees of the appellant all along, comma, there arises no question of any agreement for sale of goods or provision of services being involved in the dispute, comma, as per the ambit of clause XVIII of section 1 within bracket section 2 within bracket 1 within bracket small c. Next para, thus, comma, the learned trial judge, comma, it is argued, comma, acted with rehearsal law and in a perverse manner in holding that the dispute involved in the suit relates to a commercial dispute contemplated under the 2015 Act. Even on merits, comma, the appellant has annexed a letter dated August 31, 2025 to the injunction application filed in the trial court, whereby the appellant, the respondent number 1 has written to the appellant seeking removal of her name from the records of the appellant company, comma, admitting therein that the respondent number 1 has been in the service of the appellant organization for the last 8 years. Next para, learned counsel further points out that from the communications annexed to the injunction application filed in the trial court, comma, it would be evident that respondent number 4 has been formed by the respondent number 1 and respondent number 3 comma, as its directors. Full stop. Next para, it is contended that in terms of the averment and the annexures to the injunction application, comma, the learned trial judge ought to have granted interim ad interim protection to the appellant. So next para, learned counsel appearing for the respondent number 1 controverts the submissions of the appellant and places reliance on the several annexures to the temporary injunction application of the appellant itself to argue that prior to the filing of the suit, comma, several allegations leveled by the respondents against the appellant company as to the appellant stealing the designs and patterns, prototypes, comma, samples, etc. of the respondents is concerned. Full stop. In the said communications, comma, it was also alleged that the appellant was making defamatory and slanderous statements against the respondent number 1 and respondent number 2, comma, who were co-owners of the respondent number 4. Full stop. Next para. As a backlash to such allegations, comma, it is submitted that the present suit has been filed. For some next para, learned counsel places considerable stress on the word double inverted design and double inverted pattern used throughout the plaint and in the prayer portion thereof to argue that intellectual property rights relating to design also comes within the purview of section 2 within bracket 1 within bracket small c within bracket XVII of the 2015 Act. Full stop. Thus, comma, since the valuation of the suit is above the specified value as contemplated in section 12 of the 2015 Act, comma, it is argued that the learned trial judge was justified in holding that the suit pertains to a commercial dispute and ought to have been filed before the commercial court having jurisdiction and not the ordinary civil court. Full stop. Next para. Apart from the maintainability of the suit before the ordinary civil court, comma, learned counsel also controverts the contentions of the plaintiff insofar as the merits of the plaint case are concerned. Next para. Learned counsel appearing for the respondent number 3 company submit
First individual.
But-
Code is the company.
oh acha, sorry, respondent number 3, sorry, respondent number 3, comma, one of the alleged clients of the appellant in the plaint, comma, also adopts the arguments of the respondent number 1 and, comma, in addition, comma, argues that from the averments made in the prayer portion of the plaint, comma, it would be evident that the plaintiffs have sought to protect their confidential trade information, comma, client database along with design pattern. Full stop. Thus, comma, there is an implicit admission in the prayer relief sought in the plaint as well as the averments made in the plaint that the design pattern which is allegedly being utilized by the defendants belongs to the plaintiffs, comma, thus bringing the dispute within the ambit of clause XVII of section 2 within bracket 1 within bracket small c. Full stop. Next para. Learned counsel for both the respondent numbers 1 and 3 submit that the dispute is also covered by clause XVIII, comma, since the respondent number 1 claims not to be an employee of the appellant company, but to have business dealings with the appellant. Full stop. Next para. Hence, comma, it is submitted that the agreement between the respondent number 1 and the appellant company for provision of services also brings the dispute within the contemplation of section 2 within bracket 1 within bracket small c within bracket XVIII. Next para. Upon hearing learned counsel for the parties, comma, we find that at the ad interim ex parte ad interim stage, it is only the averments made in the plaint and the injunction application and the documents relied on and annexed to therein, which are to be looked into by the trial court. Full stop. For such purpose, isolated statements in the plaint cannot be culled out, but a meaningful reading of the plaint in its entirety has to be undertaken. Full stop. From paragraph number 2 of the plaint, which is virtually reproduced in the injunction application in the trial court, we find that the plaintiff alleges to be engaged in the business of manufacturing and job work preparation of leather goods and allied products in West Bengal. Full stop. Next para. In paragraph number 7 of the plaint, it is alleged that the defendant stroke respondent numbers 1 and 2 were employed with the plaintiff as a senior merchandiser and senior pattern cutter, respectively, the defendant number 1 being associated with the plaintiff for more than 8 years and defendant number 2 approximately about 12 years. Full stop. It is also alleged that till such time as stated thereafter, they had been regularly drawing salaries from the plaintiff. Full stop. The last pay drawn salary of the defendants has also been enumerated in the said paragraph. Full stop. It is alleged in paragraph number 8 of the plaint that there are about 100 employees who are in the payroll of the plaintiff, in support of which an extract of the alleged payroll was also annexed to the plaint, in which the names of the defendant numbers 1 and 2 featured. Full stop. Next para. In paragraph 9 of the plaint, it is alleged that the defendant number 1 used to enjoy a position of seniority in the employment hierarchy as maintained by the plaintiffs, and the defendant number 1 also similarly used to be an important design cutter. Full stop. Next para. In paragraph number 11, it has been alleged that there are express and stroke or implied terms of employment which the defendants were required to adhere to, inter alia, not to engage in any competing business with any third party while still being in employment with the plaintiff, not to solicit clients of the plaintiff or for their own business purposes, not to disclose or share any information or confidential data or document in any form of the plaintiff with any third party without the knowledge or consent of the plaintiff, etc. Full stop. Next para. In paragraph number 12 of the plaint, it is alleged that the said defendants have acted in material breach of the aforesaid express and or implied terms of employment and have also acted in material breach of the trust and faith which the plaintiff had reposed on them. Full stop. Next para. In paragraph number 25 within bracket small a, relied on by the respondents before us, the plaintiff alleges that the defendant number 1, even while being engaged in employment with the plaintiff, had removed several sensitive data as also the confidential details of the clients and leather designs which she had full access to, being effectively in control of the plaintiff's database, as also the official email communication of the plaintiff, etc. Full stop. Next para. In relief A, small a of the plaint, it has been asserted that the plaintiff seek a declaration to the for a right of the right to protect its confidential trade information, client database, design pattern and sample of the plaintiff's business. Full stop. Next para. A composite reading of the aforesaid pleadings indicates that the business of the plaintiff is manufacture and job work preparation of leather goods and allied products in West Bengal for clients who are spread across different countries. Full stop. The defendant numbers 1 and 2 are alleged to be employed with the plaintiff in several paragraphs of the plaint. Full stop. In support of such employment, a letter issued by defendant number 1 has also been annexed to the injunction application, which shows that which prima facie shows that the defendant number 1 claims that she was in employment for 8 years with the plaintiff company and seeks to seize CEAC to be so. Full stop. Next para. The use of the word within double inverted leather designs, double inverted clause, has been in the plaint is in conjunction with confidential details of the clients and other several sensitive data as well as the official database of the plaintiff company. Full stop. Thus, the leather designs referred to in the plaint are linked with the confidential details of the plaintiffs and the database of the plaintiff company. Full stop. We do not find within the four corners of the plaint that the plaintiff has categorically asserted ownership of the design pattern or database, which is the design pattern, which is a part of the database and confidential client information, which is allegedly being sought to be compromised by the defendant numbers 1 and 2. Full stop. Thus, in the absence of any claim of ownership of the designs and or any sort of trademark, copyright, patent or domain name, the dispute cannot be said to come within the ambit of clause XVII of section 2 within bracket 1 within bracket small c of the 2015 Act. Full stop. In the teeth of the averments in the plaint and the annexures to the injunction application filed in the trial court, which assert that the defendant numbers 1 and 2 were in employment of the appellant, it cannot also be said that there was any agreement between the said defendants and the appellant for provision of services. Full stop. Next para. Even otherwise, the ambit of the dispute centers around an allegation that there has been a breach of the confidentiality clauses and restriction to to engage in competing business clauses, which are allegedly enumerated in the employment agreement between the defendant numbers 1 and 2 and the plaintiff stroke appellant. Full stop. Thus, such breach of employment contract and breach of the confidentiality clauses therein cannot be termed as a dispute pertaining to any trademark or intellectual property rights as envisaged in section 2 within bracket 1 within bracket small c or any of its clauses. Full stop. Accordingly, prima facie the learned trial judge erred in law in refusing injunction on the sole ground that the suit is of a commercial nature coming within the ambit of the 2015 Act. Full stop. Even on the merits, on the averments made in the injunction application before the trial court and the annexures to the injunction application, we find sufficient substance to hold that triable issues for trial of the suit have been raised, at least at the stage of ex parte ad interim injunction. Full stop. Accordingly, in view of the above discussions, the impugned order cannot be sustained. Full stop. Hence, FMAT 187 of 2026 is allowed on contest against the respondent numbers 1 and 3 and ex parte against the others, thereby setting aside the impugned order dated May 12, 2026 passed by the learned civil judge senior division at Shelda, district South 24 Parganas in title suit number 90 of 2026 and granting injunction restraining the respondents and or their men and agents from
Page 153, my lord, is the prayer.
Yes. Utilizing confidential trade information, client database, design pattern and design pattern of the appellant apostrophe plaintiff stroke appellant apostrophe's business as given in the schedule of the plaint of the said suit till disposal of the temporary injunction pending in the trial court. Full stop. Next para. The respondents shall file their respective written objections to the injunction application within 1 month from this date. Full stop. The learned trial judge shall dispose of the injunction application at the earliest thereafter, comma, preferably within 8 weeks from the date of filing of the preferably within within 8 weeks, within 10 weeks from date. Full stop. Next para. 10 weeks from date to 6, 4 plus 8. Within 12 weeks from date. That 4 weeks, 1 month and plus 8. 12 weeks from date. Full stop. Next para. It is, comma, however, made clear that this court has not conclusively decided any of the disputes raised between the parties, and all the above observations are tentative in nature, comma, arrived at merely for the purpose of adjudication of the present appeal at the ex parte ad interim stage in the trial court. Full stop. Next para. The learned trial judge shall not, comma, in any manner, comma, be influenced unnecessarily by any of the observations made above, and go on to decide independently the temporary injunction application as well as the suit on their own merits. Full stop. And in accordance with law. Full stop. Next para. Can 1 of 2026 is also disposed of accordingly in order to cause urgency.
Your Lordship, only one submission which I made, Your Lordship, that upon instruction that the defendants are not using any trade information or any designs or any pattern of the plate. Your Lordship, kindly.
এই যেখানে যে নিলে রেসপন্ডেন্টের আর্গুমেন্টে যেখানে রেসপন্ডেন্ট নাম্বার 1 রেসপন্ডেন্ট 1 এর আর্গুমেন্ট হচ্ছিল ওখানে কোথাও একটা বোল্ড লেটার ঢুকিয়ে দিও লার্নেড কাউন্সিল ফর দ্য রেসপন্ডেন্ট নাম্বার 1 ফার্দার আর্গুস ওনার আর্গুমেন্টের সময় that the further controversy allegation that the respondent number 1 is utilizing or using the designs confidential information and or database of the appellant in any manner whatsoever.
Lordship has also recorded that 1 and 2 is the directors of defendant number 4. It will be 1 and 3.
1 and 3, yes. It will be 1 and
That will be 1 and 3.
Probably we said 1 and 3.
No, 1 and
We'll
2
correct
has-
it if we said.
Grateful, my lord.
Thank
Keep
you.
it up.
Thank you. Grateful. Next. 32টা ডাক্তার মাথায় ঢোকা আছে। Yes.
Blood 29, I
Only for the
beg
Lordship,
to.
I appear for the appellant. I'm led by Mr. Aniruddha Chatterjee, Lordship.
Blood, I'm here online, Blood.
He's there.
Yes, if it can be, Blood, there was a direction to serve, Blood. We have served in terms of that.
Mr. Mukherjee is
If
appearing
it can
for
be,
the-
Blood,
Except 5. 5 has passed away February 26. I don't know why they have not.
no, if 5 has passed away, Blood, we have to take steps with respect to that.
Yes, we'll vacate the interim order granted because that was passed in the name of a dead person.
Blood, we had no
Absolutely
idea
correct.
today. Mr. Mukherjee is informing us. We shall take steps immediately.
Relations.
You're-
The same family, they are relations. And they don't know that he has passed away.
No, Milord, if I had known, Milord, I can assure my learned senior friend that
Not
I
you,
would have
your
taken
client. Obviously not
No,
you.
Milord, the clients also, Milord, they wouldn't know. And Mr. Mukherjee knows my clients pretty well. I don't think they would be suppressing that.
He passed away on 7th February.
Learned counsel appearing for the respondent numbers 2 to 4 and 6 to 9 submits that respondent number 5 has passed away, but still features in the list of respondents in the cause title of the present appeal. Push up at this comma, learned senior counsel appearing for the appellant seeks an accommodation to take instructions in that regard and to take appropriate steps in the appeal. Push up accordingly, let the matter be listed in the next monthly list. Push up steps, if any, shall be taken by the appellant in the meantime.
May I take just one?
Yes, Mr. Mukherjee.
Now, the gentleman died on 7th of February.
Hmm.
When we have to stay on 21st of July.
Yes, but something has to be then brought before the court.
We have already taken steps in the trial court.
Those application, a copy of that application or something will help us.
The application has also not been served upon us.
No, in the trial court you said that you have taken steps.
Yes,
So you must file an application.
that is allowed. They know it.
They know we
That's
don't. We have to see something.
Miller, if that's allowed, Miller, that's even
Mr.
better.
Mukherjee, if you please bring that also on record on.
Certainly, but I'll immediately take it by instructions and.
This is very bad for me to ask.
No, what has not
No,
been?
no.
Lordship, we have served, but it has written with that.
So where is the affidavit of service? Where is the affidavit of
Lordship,
service?
the 2 to 4 were the respondent number 5 was the power of attorney for all 2 to 4. It came written. It
So we
came
are
written.
directed to serve copies.
sir.
Where is the affidavit of service?
The affidavit of service cannot be correct.
But probably what's happened is, since 5 was representing 2 to 4, my lord, it was served upon 5. But now my learned
I
senior
received.
friends,
Your Lordship will again.
I cannot, I think.
I was received.
Endorsement left, Your Lordship. Will serve again, Your
It
Lordship.
left, my
Serve
lord,
again.
in a different, we can take it in a different way.
Left in the different sense.
Will serve.
In a different sense.
Anyway,
That's sad. That's very sad.
Is filed to be kept on record. So, however, apparently, service was effected on the deceased respondent, who was
Effective, my lord.
sought to be effected on the
Thought
deceased
to be affected.
who was deceased by the time it was so sought to be served. Hence, the learned advocate on record for the appellant shall furnish fresh copies of the applications and the memorandum of appeal on the learned advocate on record appearing for the contesting respondents.
My lord. So grateful, my lord. 30, my lord, there is a preliminary objection. I don't know whether your lordship would like it or not.
Yeah, what is the preliminary?
Looks to the order.
Yes.
Extension.
The lordships are not sitting in the larger bench at all.
Impugn order?
18th
my
of June, my lord, it had expired. Or
I am
extended,
telling-
further extension.
But then, my lord, I will have to go on signing memo of appeal one
And that
after
is
the
what
other.
the problem is, my lord. If your lordship sits, my lord, in the full bench, it was constituted.
We'll go by the last order.
The last order of, my lord, yes, even that also, my lord.
We have referred it, but we have decided in favor of only one application.
My lord, that too, my lord, I
favor
had
of
the
possession.
occasion. Yes, I had the occasion, my lord, to appear in that matter as well. But then, my lord, it is that it's even more divergent now. So there is another view which says that, my lord, the first initial order will stand.
No, what will be
initial order
extended
was,
then? We don't
my
understand
lord,
this.
what happens is every extension is not, my lord, it is a fresh interim order. That's what's been said by Justice Standen in a division bench.
Cannot
It
accept
is
it.
not
But
mechanical.
well attended.
It is not mechanical extension. So those orders are
We'll
independent
keep this question
orders.
open. We'll keep this. Keep this question open and grant an ad interim order to. You are for the appellant.
I have an
Well,
interim
they
order.
have got an interim order. I am against that, my lord.
So you're granting a stay of operation of that, and we are.
That also, my lord, your lordship wouldn't. Your lordship may always.
Larger
may,
bench,
but-
we are not being able to constitute Mr. Chatterjee because we are not being able to. I mean, all the three judges are not being able to find a common date.
Because somebody or the other, my lord, is in circuit.
Mostly that. You are right.
And if anybody who sits in below the civil jurisdiction, my lord, goes to the circuit very frequently. It is weird.
We don't know. We have no direct knowledge regarding that.
But yeah, we as lawyers, we have, my lord.
No, so then
See,
we
My lord,
don't open that.
pleasure, my lord, to keep it on Monday.
My lord, I'll tell your lordship, my lord, very briefly, my lord, there is already a subsisting order of status quo which they are enjoying in a partition suit. That order is there. Now, my lord, kindly see what is the nature of the order which has been passed. Virtually, it's like a perpetual injunction which has been prayed for in the suit.
Mr. Shane, please come back on Monday and we'll just decide. We'll let him come prepared on this.
Just give me on
And
Monday. I'll do that.
Mr. Chatterjee, please give a copy of that reference judgment to Mr.
I'll
Shen.
do that. I'll do that.
Mr. Kormaka, please do that so that they
Do
also are apprised with whatever equipment they have.
Well, I'll do that.
Very well. Learned
In
counsel.
fact, my lord, I'm just suggesting this to my junior, my lord. If instead of going into this legal issue, I file as another memo of appeal, my lord, you do
Yes,
that.
yes.
But I don't
That
want
will be
to, my
safe.
lord.
That will be
Actually,
safe.
my client will not be interested in the
Yes, we do. They are not interested in academics also.
discussion. My lord. Like this small
No, but this
matters.
will save if it is held in your favor, in your contention's favor, then probably, I mean, costs and time will be saved for future litigants also.
Absolutely, my lord.
But Mr. Chatterjee's contention will increase the costs and time.
Well, I made this submission when your
But I
lordship
don't
sat
think he will
in
take the
the
point if he is
full
this side.
bench.
He's the order which is
And
challenging.
probably, my lord, if I'm not mistaken, Supratik Ghosh was passed by Justice Sen, sitting with Justice Kundu.
Yes, Supratik
If
Ghosh
I'm-
was.
Huh.
I recollect.
Yes.
Yes, I recollect Supratik Ghosh was passed by Justice Shen with Justice Kundu.
I with Justice Kundu.
Yes.
So he will obviously
our ancestors, Mr. Chatterjee, your predecessor in interest in office, not in office, your predecessor, Mr. Shen's predecessor, my predecessor, everybody, they are creating problems in every sphere. Wherever
everywhere.
we are touching, either you or
Milord-
him or Justice or Mr. Bhattacharya, Shaunak Bhattacharya's predecessor. These people are creating the main problems.
Absolutely. Milord, it's basically the Bhattacharjis who create the problems. Chatterjees don't create problems. Chatterjees are, are humble
the reasons
human
for
beings.
Bhattacharya is creating the problem.
Chatterjees, they think
Chatterjees are the reason for Bhattacharya is creating the problem.
That is in a way correct because your lordship
If you want to file, how many subsequent orders are there? In the meantime, some other orders may also.
And
be
I'll
passed.
not take a technical point. Let them file the last one. I will not take the
How many have been
interregnum point.
passed in the meantime?
One.
What is the next date?
28th of July.
So another order will be passed. Yes.
No,
So
your
you are
lordship,
attending
hears it out
Saturday,
on Monday
you want
itself.
filing appeals. If you want.
No, Monday. Milord, I will not take
You want to
this
do
point
that?
again.
Consider it.
I don't want to do that.
No, Milord, I will not take
Let
this
us wait
point
for
again.
after 28. So 28th, after that, how long will it take to draft?
Well,
it?
let us come back on 27th. That is before 28th. If there is no not to attend, my lord, we can have it thrashed out here and now. Then
No,
Is
if there's
there a
not to attend,
possibility?
if there's no not to attend, you will thrash out. If there's a not to attend, I'll thrash you.
Hey, is there a possibility?
No, steps can be taken in the meantime to create the possibilities. I always allege that Mr. Basu does something of that sort from the
That's all.
corridors.
He probably
From the
goes
veran-
somewhere
from the
and
balconies,
does.
yes.
now, my lord,
He may push people also.
Milord,
He was
in
there.
today's world,
Sorry, he's not
black
there.
magic.
I'm withdrawing that count. I thought he was here. Yes.
In today's world, Milord,
follows it
black magic is a big thing.
Strategy just pushes, that is sufficient. So on whose prayer should he put it on Monday, Mr. Strategy?
Mr. My prayer, I have no problem.
On the prayer of learned senior counsel appearing for the respondent, the matter is adjourned till July 27, 2026. The application heading is it? It will be quite fairly at the
Monday
top.
is your lordship's day for application. my lord.
Yes, that's why I
One
said
of the
it's
few
the
days
day.
we take application.
So, my lord,
Milord, this is also something, Milord, if your lordship can, Milord, think about.
My lord is keeping.
27, 20.
My lord is keeping the orders. My lord, I filed
What orders you have?
the.
No, fair enough.
order of
No, take those back.
The applications and order 41s, if my lord
Yes.
can increase by a day or two, my lord, it is probably at times required.
Appeals are getting stalled.
Appeals,
Everyone
Milord.
coming to mention appeals. Your juniors also come. to mention
I
appeals.
have come, my lord.
And you
Forget
have
about
to you have to see the faces when they mention the appeals.
I bow down, my lord.
And the words which they use when they go out of court when we refuse.
No, they don't. I can assure your lordship that because we
No, but
understand, my lord,
we
what the
used to do
problem
the
is.
same thing.
No, we did. Of course we did. But we only say that ki korbe George. I am telling you very frankly. Very frankly, I'm telling your lordship.
Now
if
you have
your
really
lordship-
become a senior advocate.
No, my lord, it's true.
I was about to say that.
Now he has really become a senior advocate.
No, my lord, it's true. I'm telling your lordship, it's true. Your lordship knows me. I have never, my lord, sugar-coated words ever.
No,
I have never been known for that. If I was, my lord, I wouldn't have been, my lord.
No. You
So
let me
I'm
stop
telling
there.
your
Stop
lordship.
there. Yes.
That's why I prayed before your lordship that something, my lord, maybe.
You understand?
I thought something positive will be done today, my lord. Instead of Mr. Chatterjee coming and saying adjournment on the first day, my lord, this
No,
was
I didn't ask for an adjournment at all. The matter was heard. Mr. Sen, kindly do not say that. The matter was heard and adjourned. Grateful.
31 who is appealing? Mr. Shamanto is appealing.
I am appealing for the respondent.
Yes.
My lord, an order has been passed by your lordship.
My lord, I am for the appellant. Kindly adjourn for the day.
No adjournment. Sorry. People are crying for including their matters in the list, and your matter is pending in the list. No adjournment. Sorry. Extremely sorry. Move the matter. Are they enjoying an interim order, Mr. We'll limit the interim order. It is unfortunate that despite the heavy pendency of matters in the list and the court being unable to include matters in the list despite being mentioned due to congestion in the list, comma, adjournments are being sought. Full stop. At the time of call, comma, an accommodation is sought on behalf of the appellant. Full stop. We find from the by the appellant, comma, although the respondents are represented, respondent numbers 1 to 3 and 5 are represented through counsel. Full stop. Next para, from the order dated May 5, 2026, we find that we had granted an interim protection to the appellant till disposal of Can 1 of 2026. Full stop. However, comma, since the appellant is not however, since the appellant seeks an adjournment today, comma, we cannot take up the matter. Full stop. However, comma, we modify our order dated May 5, 2026 and limit the interim order granted thereby till July 31, 2026. Full stop. Let the matter be listed next on July 27, 2026. Next.
My lord, Mr. Buddhadev Ghoshal, my lord, learned senior counsel, he is appearing on behalf of the appellant. He was present before the court, my lord, but suddenly he felt, my lord, breathing trouble. And the condition is not very okay. My
It
lord.
is sought on the ground of
Item number 32.
physical ailment. Don't ask questions to the court. You ascertain yourself.
Yes, 32.
I am appearing on behalf of
An
the
adjournment is sought on behalf of the appellant on the ground that learned senior counsel appearing for the appellant, comma, who was present in court till a short time back, comma, has been compelled to leave court due to serious health issues. Full stop. Keeping in view the nature of such nature of such prayer, comma, we grant such adjournment. Let the matter stand over till July 27, 2026.
Lordship, I am for the caveat and my copy is not being served upon me.
Serve it. Next. ডাকুন কোর্টটা দীপঙ্কর ডাকুন তাহলে একজন নিন একজন ডাকুন
May it please your lordship.
Yes.
Lordship, in this matter, lordship, before
Yes.
lordship, Mr. Rohit Das is senior in this matter, lordship. He's in Supreme Court for today and tomorrow, lordship. My lord,
You're enjoying any interim order?
No, lordship.
Then
No,
it goes out of the list.
lordship, kindly, lordship. There is an
No.
emergency, lordship.
No.
Lordship,
No.
lordship, kindly,
No,
lordship, I have been disposed, lordship, while the appeal is pending, lordship.
Very good.
And all of a sudden, this matter has come to lordship on an extreme emergency, lordship.
No, there's a Section 5 application.
Even a leave application is there.
Leave application, section application.
Leave to file an appeal.
There are defects in the appeal also. Several defects in the appeal. Defects can be cured. We are granting you leave to cure the defects. Do that in the meantime. They are not enjoying an interim order.
No, Lord, I have already got possession of the property. Lord, 1982 degree was Lord, put into execution, and
We
thereafter the
find
police
an adjournment is sought on behalf of the appellant, although the respondents are represented through counsel for sub. We find from the report of the stamp reporter that there are several defects in the appeal, whose leave is granted to the learned advocate on record for the appellant to carry out the necessary corrections to the memorandum of appeal.
If it is 232.
By tomorrow, full stop, let the matter stand adjourned till July 27, 2026, Monday. Please carry out the corrections. Next.
Item 34 is my application, Milord.
34. Yes, Dasgupta.
Milord,
Yes.
There is an application under section 5, Milord, delay of 159 days.
Appearing for the first time?
Appearing for the first time, Milord.
Serve and come back. Serve and
Milord,
come.
There is no caveat, Milord. Only, Milord, kindly seize, Milord, the order. Milord, kindly seize, Milord, the order impugned for once.
Section 5 is there. Are you supposed to allow it ex parte? What are you saying? No caveat. The appellant shall serve a copy of shall serve copies of the applications as well as the memorandum of appeal on the respondent, indicating that the matter shall be listed under the same heading on August 10, 2026, when an affidavit of service to that effect shall be filed by the appellant. Serve everything, Mr. Rajguru, so that if you allow the condonation, then we can lock, stock,
Yes.
barrel, we can. Yes.
Yes. Yes. Okay.
Yes.
Please, my lord.
Yes, absolutely.
And for the appellant, there are two minor defects
What are
in
the
the
defects?
appeal. Number one, the learned judge's name is not appearing in the memorandum of appeal.
That we can permit you
that.
And what else?
And another one, that the date of the decree drawn up is wrong. That would be February 27. That is the date of the judgment.
Yes.
Yes,
Right.
that is the date of the judgment, but the department says that it has to be mentioned like that.
Thank you for two things. One is you are the first person today who actually knows what are the defects when you take up the matter. Secondly, you have pinpointed the exact law on the subject. Very good. So we'll give you that liberty and you move the appeal. Leave is granted to the learned advocate on record for the appellant to carry out the necessary rectifications in the memorandum of appeal to cure the defects as pointed out by the stamp reporter during the course of the day.
Lordship.
Yes. What is the matter?
Lordship, the suit is a partition.
There is no
suit.
caveat in this matter.
There is no caveat. The suit is a partition suit.
Yes.
In regard to the estate of one Bhagwat Das. Now, the said deceased had 3 sons, 1 daughter. Lordship, kindly comes to page 14.
No, you are challenging a preliminary degree.
Yes, we are challenging a preliminary degree.
Periodically, we pass as a matter of course, we direct the final degree proceedings to go on, but no final degree shall be drawn up. That is the usual order.
Lordship, but prima facie, may I only indicate my case is that the preliminary degree that has been drawn up, Lordship, there was no prayer for a cancellation of the gift deed. The main challenge was that there was a gift deed in respect of my clients, in favor of my clients, and such gift deed was purportedly challenged. But there was no prayer in the plaint suggesting a cancellation or a declaration challenging the gift deed. But in spite of that fact, the learned trial judge has, in essence, set aside the gift deed.
Without holding so.
And that too after the period of limitation. That cannot be challenged at this point.
Did you raise this question?
Yes, Lordship. That is my appeal.
Which was the issues, please? Yes, page 9 of the judgment.
Lordship, in the memorandum of appeal?
No. In the trial court judgment, internal page 9.
That issue. Yes.
Come to internal page 9.
Lordship, these are the issues.
Not internal. No, it does not appear to have been taken by you. Otherwise, an issue would have been framed.
No issue was framed in that regard as well. That has been dealt with in paragraph issues number 3 and 6. Lordship, page number internal
So, well,
21.
from the narrative in the judgment, let us see that you have whether you have argued that or not.
Lordship.
That's an admitted position that there are gift deeds in your favor.
Yes, admit, and they have
Because from the case as narrated in the injunction, narrated in the
Lordship,
judgment
page 21
of
the judgment, impugned judgment. Internal page 21 and 148 of me.
So, internal page.
And thereafter,
it's a registered gift deed.
Yes, it is a registered one.
It was dealt with and disbelieved for some reason. The quality of
Lordship,
that
but
adjudication you have to look into definitely.
I understand, but for that, Lordship kindly comes to the
But there was
prayers
no
of the
prayer for cancellation.
there is no prayer for cancellation or at all declaration.
So the difficulty is the court proceeded on the premise that there was not a valid gift at all. That appears to be sure. I mean, suppose.
Lordship,
but still, you have a point there.
Lordship, I'll indicate that point where the court, in essence, says that it has been executed by an, in essence, insane person. Lordship kindly comes to page 22 of the judgment, just next page. In the middle portion.
Yes, yes.
But also ailing with hypoxic encephalopathy. Lordship, no medical practitioner was ever called on for that. And in essence, with a basic Google search and with the help of AI, it can be presumed that hypoxic encephalopathy deals with memory loss and seizures. But in essence, it's for babies. That is the it does not in effect harm any adults.
Arguable questions.
Lordship, these are.
Let the final degree proceedings, if you
in the meantime, there will be a stay in the suit.
No, the entire suit we won't stay.
Lordship,
ultimately you lose, then this period will be lost.
Lordship, I'll indicate one thing, only one thing.
No, final degree will be drawn up, will grant that.
Lordship, only one thing, that the cancellation of gift deed at this point cannot be made, because in Lordship kindly comes to the plaint ones.
Yes.
At page number 15.
In the plaint, no challenge to the gift. It was
yes, in the plaint, but no prayer at all.
No, in the plaint, the reliefs of the plaint.
No, Lordship, I'm showing that page 17 and 18 of my stay application.
Do they admit in the plaint the gift deed?
Yes, they admit
Which
the knowledge. Paragraph 10. That being surprised with their claims of the defendants, the plaintiffs immediately inquired in the registry office and came to know that their father and elder brother jointly executed a gift deed.
You are granting stay.
I'm grateful.
Very well argued. Yes.
Great.
The present appeal has been preferred against a preliminary decree of partition. Full stop. One of the grounds taken in the appeal, comma, as submitted by learned counsel for the appellant, comma, is that the plaintiff stroke respondents 1 to 3, plaintiff stroke respondents admitted a gift deed executed in favor of the defendant stroke appellants in respect of a portion of the suit property, but did not seek any relief of cancellation of the same. Full stop. Moreover, comma, the relief would be such a relief would be time barred as well. Full stop. Next para. However, comma, despite the same, comma, the learned trial judge entered into the issue of the legality of the gift deed and declared the same to be void, comma, thereby transgressing his jurisdiction. Full stop. Next para. Apart from the other grounds taken in the memorandum of appeal, comma, the above question raises a strong prima facie case in favor of the plaintiff, defendant stroke appellants. Full stop. As such, comma, the operation of the impugned judgment and preliminary degree shall remain stayed till August 31, 2026 or until further order, comma, whichever is earlier, full stop. The appellants shall serve copies of Can 1 of 2026 on the respondents, indicating that the application shall be listed in the monthly list of August 2026, when an affidavit of service to that effect shall be filed by the appellants. Full stop. The appellant shall also put in postal costs and requisites for service of notice of the appeal on the respondents within a fortnight from date. Full stop. The trial court record shall be brought by special messenger at the cost of the appellants, comma, to be deposited within a fortnight from date. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appeal. Application will appear in the monthly list next month.
I'm great.
Next. Was this matter mentioned in the morning on the ground of urgency? Not this. This is the matter.
Yes, 22
You mentioned, yes, right. So reached. Happy. No, no application. Thank you. Yes, yes, Mr. But you did not mention that these people will be appearing. Then we would not have reached it. Yes.
Millard,
Mr. Mukherjee, you are for all the respondents or what?
Yes, Millard, I am the decree holder responding.
Yes. So eviction suit or?
Eviction suit filed on just page 51 of the stay petition, one paragraph of the plaint. Lord, I am sued as a lessee. Para 15, page 51. This is part of the plaint. Lord, I am sued as a lessee.
Yes.
Lease, my lord, is head lease is, my lord, 1905. Then, my lord, another lease in 1907. Ending registered lease 1907. Rent, my lord, 350 rupees. Ending in 2005. I am governed by the West Bengal Premises Tenancy Act after the last amendment to Section 3, my lord. So the suit itself was incompetent. But, my lord, the suit has been decreed.
Decreed on what ground? I mean,
my lord, that lease has expired by efflux of time.
So under the transfer property.
Under transfer of property act. My lord, please, my lord, have a look at the section. The first section, my lord, I could not fully understand, my lord, the 1956 Act section. I've read it at least 100 times. I have read my lord's division bench judgment and Justice Gupta's division bench judgment. But I confess, my lord, it is not clear to me.
You cannot make that confession sitting here. So
I can't understand this section. My lord, this is
sometimes you have to resort to creative writing.
My lord, I have noted down. Your lordship will tell me if I'm, though it's not relevant for the matter. My lord, I've got a copy. My lord, I have no access. So, my lord, I thought I'll take this chance.
I have the judgment where it is quoted.
That will do.
I've got the act. I've got the act. My lord, I have noted down. Lease must be between, under subsection 1,
yes,
between 15 to 20 years, registered lease for personal use as a residence executed after 1st December 1948. This is subsection 1. And subsection 2, all premises held under a lease of more than 20 years after 1965 ordinance, not terminable at option of either. You know, that was the exemption. 97 Act, my lord, made it simpler. Registered lease before or after commencement. 2002, it became even simpler, my lord. It's only, my lord, after.
This lease was entered into when? 2005?
This is, yes, expired in 1907.
1907.
And then, my
It
lord,
was extended.
1907, 191907.
Before the CPC even.
And it expires on 31st of July 2005. Now, my lord, rent is below even 1,000 rupees. So I am governed, all tenants are governed by, my lord, the West Bengal Transfer of Property Act. The Premises Tenancy Act. So the suit, my lord, plain doesn't disclose cause of action, could not have been a decree for eviction.
No, registered leases are exempted.
Yes.
Is not a registered lease.
Registered lease.
So exemption clause section
Please
3.
see, my lord, 3.
Come to 3, please.
My lord, exemption, nothing contained in this act shall apply to.
Then come to C.
See, my lord, any tenancy where the lease with due consent of the tenant has been registered under the Registration Act 1908.
So after the commencement.
After commencement of the act.
Yes, but.
So after commencement of this act.
Yes.
So if it is anything done before, this act will apply. So, my lord.
No, but if it was entered into between the during the regime of the previous Act, 56 Act, then that provision should apply.
It was registered under 56 Act. Before 56 Act.
These are extensions. The subsequent ones, 2005.
1907, my lord, is the lease.
2005 it was extended.
No, expired.
It expired.
Oh, there are no extension. Oh, that
only
only 1
years
lease.
after that, my lord, is staying.
Yes. So my lease is of 1907. And first, my lord, I'm governed under the 50.
Before all of these rent control acts. So governed by then.
My lord, it doesn't fructify as on that date. My lord, please see the section. Nothing contained in this act shall apply to any tenancy where the lease with due consent of the tenant has been registered.
Mr. Chaudhary, we have to look at the statutory regime which was prevalent at the time of inception of the juror relationship. How once it's a transfer property act lease, how can it change its character to a?
That your lordship has held in my lord's judgment. In course, Lord, it cannot change the character.
Yes, subsequently it cannot change its character.
No, my lord.
That's basic. I mean,
no, my lord. Here, what we are saying is this:
it's accrued rights are created under that act to both sides.
But that act gets repealed. Rights don't get, my lord.
No, unless this act repeals previous things, it does not.
So, my lord, now
it only repeals 1956.
Look at 97 Act first, my lord.
Yes, 97 Act.
97 Act repeals, my lord, the 56 Act.
Yes, the 56 Act.
Section 45.
56 Act is repealed.
Repealed. Then, my lord.
Act is even not applicable when this was created.
No, but when, my lord, the 56 Act, all these sections relate to past leases. From, my lord, the 56 Act section, it relates to past leases also.
See, Mr. Chaudhary.
I understand what your lordship is saying. Your lordship is saying that as at the date of execution, your rights crystallize. So my rights crystallize.
The juror relationship at least.
Juror
and
relationship.
yes, the associated rights.
Yes, associated rights crystallize. So in 1907, when I execute the lease deed, that's when my rights crystallize.
Whatever was the position on that date, legal position under whichever act you were, the juror relationship was entered, that becomes your matrix of rights.
The Transfer Property Act.
Yes.
That at that point of time.
Yes, you can prove us wrong. I mean, that's the prima facie view we have taken in it.
Your lordships are thinking aloud.
Yes. No, we have
already
difficulties. We have written aloud also.
Yes, that is what I am carrying.
So
but we are open to
can
change our opinion.
Now, I have to show your lordship that each of these three exemption sections consider, my lord, past leases. If they consider past leases, that means, my lord, status changes. Yes, I agree, my lord. When I started under Transfer of Property Act,
No, what are we hearing? This section stay application.
The stay application is filed for execution. He's going to throw me.
Tomorrow is
And
This is the only ground you have.
This is the main ground. This is the main ground. But it's a very arguable ground, Milord. Milord, please look at the
And show his previous blood, the order he obtained from your lordship. He was appeared.
What sort of order?
That your lordship held against him on this particular proposition.
Sir, always your lordship is holding against me, no problem.
Yes, that's a given.
But then I feel your lordship
And
doesn't hold against
sometimes
me.
when you feel we hold against Mr. Mukherjee also.
No.
Depending on the
Your
mood, the
lordship-
weather,
No,
time of day.
No, what I wanted to say is your lordship never holds against me. It's against my client.
Yes, of course, that way.
But I won that matter, which you're showing. देखिए, Charu, I won. Why are you saying?
He said proposition
No, but
on the proposition that my learned friend is forwarding paragraph 39
Charu
and paragraph 40 is exactly what fell from your lordship.
Charu doesn't apply.
Oh, sorry.
Charu doesn't apply because I'll tell your lordship what the argument in Charu was. Charu argument was that lease expired. Lease was governed by the Transfer of Property Act. After lease expired,
This was specifically held.
Yes.
no, but your lordship will see what is
The
this.
40 dictum is laid down. But
No, this
we
is
have to then refer to a larger bench if we
no,
hold
totally,
against we can do that if you prove us.
Charu, first, I'll tell your lordship what was the argument which I was meeting in Charu. In Charu, the argument was lease expired. Lease was governed by Transfer of Property Act. However, after expiry of lease, they said we have become monthly tenants. Without there being any tender and acceptance of rents, etc. Now, Charu, your lordship, this is before the Supreme Court now matters going on. There is no stay. Milord, please see. In any event, since accrued rights under Transfer of Property Act has been created.
Before which bench is it now?
Before Justice Manoj Mishra and Justice Ujjwal Bhuiya. And their lordships, my lord. Detailed hearing.
We're trying to anticipate that because then we'll wait for some time and wait for that
Detailed
outcome.
hearing. It's happened 8 days.
We'll give you the right to come back under section 144 of the CPC and wait for that matter.
But if I get thrown out?
That's 144.
That's what.
No. Milord, doesn't have. Milord, please see Milord Charu details. In any event, since accrued rights under Transfer of Property Act had been created in respect of the lease of 1972, executed in favor of the plaintiff.
Is there any contrary judgment in the meantime? So that
this is not contrary.
All
It is
supportive.
not contrary. I will show your
there was
lordship.
some contrary judgment, we could say that the position is not settled, pending before the Supreme Court and all these things. But if there is no stay and this is the only judgment holding the field in our court, Mr. Chaudhary, and we don't have ownership of the judge, just because it's our judgment, we cannot also reverse it at the drop of a hat.
But I will show
We
you.
don't have ownership of this judgment.
This
is a dictum of our court, so we have to prove us wrong.
But this
court wrong. Rather.
No, this was not in issue.
Para 40, we clearly say once a lease
44,
commences
Milord.
under para 40, once a lease, sorry.
And I just read 40.
Para 40.
Once a lease commences under the Transfer of Property Act, it cannot automatically change its character and partake the nature of a tenancy under Rent Control Act merely before such rent control came into force unless specifically provided. Now, what is the argument, Milord? Milord, kindly see para 39.
Yes.
Admittedly, Milord, please see middle of page 16.
Admittedly, yes.
Admittedly, in the present case, sublease in favor of the plaintiff was created on 25th May 1972 for a period of 45 years. At that point of time, 1956 Act was operative, and thus the Act was not applicable in terms of Section 3 of the same to the lease held by the plaintiff. It was not operative. By default, the TP Act governed the said lease at its point of inception. Once a lease commences
This
under
is even prior to that. Here there was an additional layer. That agreement to that tenancy
Milord-
agreement was in 1972 during the regime of the 56 Act. So even that we held that it was entered into at a time when 56 Act held the field. Under 56 Act that did not fall under the 56 Act. It was an exception. So
And-
by default it went to the TP Act
May I
regime.
just add something?
Here it was entered into the
May I-
during the TP Act regime.
Milord, it was nobody's case in Charu Diesel that during the tenure of the lease, that the lease came to be governed from the Transfer of Property Act to the West Bengal Premises Tenancy Act. That was not the
No,
argument.
the premise was that merely because Rent Control Act comes into force, it cannot change character. Your argument, if it is accepted, Mr. Chaudhary, then by virtue of enactment of the 97 Act, automatically a prior lease which was continuing under the Transfer of Property Act
Just I'll take
becomes
2 minutes on the section. 2 minutes on the section. First, my lord, 56 Act section. 56 Act says, I'll go back to my note.
56 Act is not German in your case.
No, but I'll show your lordship from the beginning. Framers, my
Your
lord.
beginning is transfer property.
No, from the beginning of the
Rent
enactment.
Control Act. In
They
us.
have been looking at prior leases. So what is the first enactment?
Mr. Mukherjee, you
50
can take your seat probably. And yours.
50 between 15 to 20 years.
You also take your seat. It will be quicker. Otherwise, if you go on adding something, then it will take more time.
Millard, first subsection of the 1956 Act makes it applicable to leases after 1948. So prior leases.
Yes.
So it looks at a situation where at the time of enactment, the lease is governed by the Transfer of Property Act, but if it's executed after 1948.
So it excludes prior leases.
Yes.
The provisions relating to rent and provisions of such and such shall apply to any premises held under lease and registered under where such lease has been entered into on or after 1st December.
Yes, shall apply.
So this is not exemption, unlike
unlike the later section. So what it says is,
so it will apply only if it is entered into after 1st December 1948 and.
Yes. So my lord, again, so it's
prior leases are left out. Therefore,
but
in your case, 1907 it was entered into. So
No,
it was
Milord.
prior to this.
provisions relating to rent and provisions of section 31 to 36 shall apply to premises held for residential leases of the lessee registered under the Registration Act where such lease has been entered into after 1st December and not more than 20 years. So my
So if
reading
it is
is
registered lease deed before that, then
Out.
it is out.
out. But let's look at, my lord, registered lease in 1949 for a period between 15 and 20 years.
That's a hypothesis which we need not look at.
No, what am I
Let
saying?
us focus on your case. Here.
Yes, Milord, what am I saying? I'm only saying this, that this so Rent Act is being made applicable in 1956 to a lease entered prior in point of time.
After 48.
After 48.
Before 56 Act.
Yes.
That may be, a statute may do that.
So a statute, so right starts under Transfer of Property Act. In 1950, there is a lease under Transfer of Property Act. I am an executant, I am under Transfer of Property Act. When this act comes, I come under Premises Tenancy Act.
Right.
Now, my lord, next act, the 97 Act. 97 Act, my lord, again deals with prior leases. So rights change, my lord. It's not that it will be forever. My lord, you please see the 97 Act once, my lord.
It is 2002 before amendment.
It says,
Mr. Chaudhary, you miss out the last phrase of this para 40 of our judgment. We say, once a lease commences under the Transfer Property Act, it cannot automatically change its character and partake the nature of a tenancy under the Rent Control Act merely because such Rent Control Act came into
Unless
force.
specifically,
Unless specifically
so this is
provided. there.
specifically provided.
Specifically provided. If it is
Yes.
provided that this will operate for leases registered after 1906,
Yes.
then it would apply to your case. If it's specifically, legislature may always specifically apply from a particular date.
Not providing may mean exclusion also.
Unless provided for, then Mr. Chaudhary, it cannot apply merely per se because the Rent Control Act has come in,
No.
automatically taken the
I'll
under
argue
its
it's provided.
None of these acts provide that it will operate retrospectively. This act provides retrospectively from 1st of December 1948.
Yes.
Not prior to that. So this act argument does not help you at all. What about the 97 Act?
Now
What
see
is-
the 97.
Come to the 97 Act.
Milord, 97 Act says
The suit was filed. This suit was filed during the 1997 Act period.
90, no, no.
Suit was filed after
No, no, no,
1990.
after.
So let us look into
2002.
this act. Let us look into this act.
Milord, please see 97. One sentence.
97 Act.
Yes.
Yes.
One sentence.
97 Act we are looking into.
Yes, yes. Milord.
That is the only act we would look into. That is what we are saying.
I'm getting confused. If you constantly.
Ma'am, please take your seat. Please take your seat. Please take your seat. You are disturbing the food also. Please don't do this. This is the last time we are telling you. Please take your seat, ma'am. Enough is enough.
Milord,
Yes.
second, Milord, is the 97 Act. Then is the
Yes.
2002 Act.
Yes.
Now, Milord, please see the 97 Act.
Yes.
Section 3,
Yes.
subsection C. Any tenancy where the lease has been registered under the Registration Act before or after commencement of the Act. Nothing contained in this Act shall apply. Before or after. So, my lord, all registered leases go after the commencement of this Act. So, my lord, after 97. Before, so after
or after?
97
Before also.
or before.
Before also.
Or goes. Now, my lord, please see the 2002 amendment. Any tenancy where the lease with due consent of the tenant has been registered under the Registration Act 1908 after commencement of this Act, and the fact of such consent has been recorded in the instrument so registered. So, now the exclusion is only post-Act. So, anything pre-Act will transfer, Premises Tenancy Act will apply. And your lordship's view, my lord, is number one, Charu diesels. I'll show your lordship. I have my old brief. I have the Supreme Court brief also show your lordship. Argument was lease started, unaffected, lease came to an end. Subsequently, I continued in possession. I am a tenant holding over. Therefore, I now continue to be governed by West Bengal Premises Tenancy Act.
Charu diesel facts were different because
Facts are totally different.
Not totally. This
totally
this proposition was
not considered. Not considered. Milord, I'll tell you. I argued that I'm still arguing it, Milord. I'll tell
Yes.
you. Okay.
Yes.
So, Milord, argument is I am a tenant holding over or a tenant at sufferance. Lease ran its full tenure. During the tenure of the lease, I was governed by the Transfer of Property Act. After the lease comes to an end, I continued in possession. Therefore, I am holding over. When I am holding over, I am governed by the West Bengal Premises Tenancy Act. That is the argument. My reply was that after the expiry of the lease, yes, during the lease, you're governed by Transfer of Tenancy Act, Property Act, Transfer of Property Act. After expiry of lease, you are a trespasser. And there cannot be any automatic change after expiry of the lease. So during lease, your Transfer of Property Act, after expiry, without below tender and acceptance of rent, creating a fresh tenancy, your status cannot change. Which is why, my lord, paragraph 40, your lordship's observation is, once a lease commences under Transfer of Property Act, it cannot automatically change its character and partake nature of a tenancy under Rent Control Act merely because Rent Control Act came into force unless specifically provided therein. So this specifically provided means unless by statute. Now, if statute says specifically or creates by exclusion, it would be the same thing. In this case, my lord, so this doesn't, my lord, come in the way at all. I have judgments to show that what I am arguing, my lord, perhaps is acceptable. Now, there are 3 minutes, my lord, we can continue.
When is the next date in the execution?
Tomorrow, my lord, Calcutta. Tomorrow. My lord, we'll go take an adjournment. I want the point to be decided. I'm sure Mr. Mukherjee will aid our request for
Heard out, we should not.
for one day, my lord, he'll agree.
The Lordship desires to, my Lord.
No, we'll keep it as a
We'll
part.
come back tomorrow morning.
We can keep it tomorrow.
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 কালকে কিছু আছে স্পেশাল
কালকে দুটোর সময় হবে 5টা তাহলে ওই তো।
So if my appeal gets dismissed, we'll go and face it. If it does not, then there'll be an order.
So tomorrow
Oh, 10:30.
10:30 original.
Original site.
Original site.
So whenever your lordship keeps it, my lord.
দুটোর সময় হবে।
Two, we'll keep it at 2. If it suits both.
And
of
I
you.
must say, my lord, in my learned friend's defense, she's actually very good at tenancy laws. I am not so
We
good.
don't doubt
She
it for a
get-
moment. She
I
argues
think
very
he
well.
got excited.
She argues very well. She does it very well. She is a good lawyer, no doubt on that. But she was misbehaving herself. She did not follow the decorum of the court, Mr. Chaudhary. That's why we admonished her.
Yes.
If she does it again, if you do it, we will also admonish you.
Of course, my lord. And I've been admonished so many times by so many people.
Not by us so many times, but if you do that, you will get admonished
Yes, of
similarly.
course.
That
I'm
has
sure
nothing to do with her acumen, her
Yes, yes.
expertise as an
And
advocate.
I'm sure her, my lord, what she was doing will not be repeated.
I'm not sure.
Mr.
Mr. Mukherjee, then what? Should we say that give a limited stay or what? I mean,
But kindly do not, Lord. I'll come back tomorrow, Lord. I have got other judgments to assist your Lordship.
no,
Lord, as
obviously,
against
but
Mr.
we anticipate what will happen tomorrow, but to us,
Lordship.
but
And to
No,
hear-
Lord,
But then
only
tomorrow
on
also-
this, Lord, the small point, Lord, what my learned
all
friend-
point that by now we have
Otherwise,
understood.
in 41, Lord, I would not have objected until unless it was, Lord, an efflux which happened in 2005.
Very well. Heard in part. The matter be listed for further hearing tomorrow at 2 p.m. under the heading Special Fixed Matters. Full stop. We are not recording anything then.
At liberty to pray for an adjournment tomorrow, my lord.
কালকে কি আছে বাবা তোদের?
কাল-
Oh, SRAD. Lord, nothing
Yes.
will happen. SRAD.
Yes, sir.
Police reporter, John.
For police report.
SRAD আছে।
Let's not take a risk. I'll just go and take an adjournment. I don't want to stay. I'll take an adjournment. my lord.
আরেকটা কপি দে।
Peace case of-
Kindly see the last line.
No, no.
You are sure I have
Notice of the order for 2197 and 6.
Ask him if he's sure that I have no problem.
Police help has been paid. Service has been directed. For service return, it has been fixed tomorrow.
Service return আছে, not for
Yeah, I
orders.
mean, I know.
Okay, বিনয় আছে, ও তো নিজে
Very well. You just take care of it. We'll go and ask.
He's there in the trial court. Leave is granted to the parties to seek an adjournment in the connected execution case. In the meantime,
I'll go and do some more research. It perhaps arguable.
yes, yes, yes.
Maybe before the Supreme Court.
No.
No, whichever way we go, it will go before the Supreme Court. Now,
The sooner the better, Lord. I mean,
sooner the better. Yes. Very well. Thank you.